never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a
Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Scheck, Mr. Bailey, Mr. Douglas, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Counsel, before we resume with the jury, I thought I would advise you of two things. I'm going to advise the jurors as to the nature of the delay that we had yesterday, what caused it, and give them my reassurances that that difficulty will not occur again. Also to advise you that it is my intention from time to time to inspect the jury facilities, either on their holding pen upstairs or at the facility where we have them housed, to make sure everything's okay. And I'll advise you ahead of time before I do that, but just to let you know, I intend on doing that from time to time. All right, Deputy McNair, let's have the jury, please. I'm sorry, Mr. Darden.
The court please consider giving once again the 1.02 instruction indicating to the jurors that statements of counsel.
No, that's part of my standard.
Okay.
Not rereading, but just reminding them of that fact.
And with regard to the exhibition of the defendant's knees, will the court also advise the jury that that exhibition is not evidence?
That's understood, and I'm sure Mr. Cochran will mention that to the jurors at the time he thinks that's appropriate, and he's also, I'm sure, advised the staff as to when that's going to happen.
That's the last thing you're...
As to the exhibition of the knees,
Oh, yes, sure. It's not evidence.
yes, also the fact that you'll have to give the bailiffs advance notice.
No, I've talked to Deputy McNair, Your Honor. We're prepared on that. Your Honor, one thing that I did want to show also, if I could, is there is a mark on his middle finger also.
The one that was displayed by the prosecution yesterday? Yes.
Okay. Those two things I want to... Not have any surprises from the prosecution.
Will there be a 352 objection to that? What is the relevance of a scar on his finger today?
Oh, I think I'll link it up, Your Honor.
All right.
Is that an offer of proof? I think I'll link it up.
It's an offer of proof. Thank you. All right, let's have the jurors, please. All right, thank you, counsel. Thank you, ladies and gentlemen. Be seated. All right, good morning again, ladies and gentlemen. Record to reflect that we have now been rejoined by all of our trial jurors. Ladies and gentlemen, let me just give you a brief explanation as to what occurred late yesterday afternoon, just to put your minds at ease and so that you don't speculate as to what the problem was yesterday. Yesterday afternoon, the television camera that is mounted above you swung and inadvertently took a photograph of one of the jurors in our case, and that was brought to my attention, and what I needed to do was immediately get from the personnel operating the camera an explanation as to how that occurred, and to find out what measures would be necessary to prevent that from happening in the future, because if you recall, when we started this trial, I told each of you, I gave you each my promise that you would not be photographed or in any way represented to the public by way of picture. And so I was very concerned by that report, so I had to take immediate action, and that's why I felt it was necessary for me to stop the proceedings until I could be assured that the problem would not reoccur. I've discussed the matter with the juror whose picture was taken, and we've resolved the fact that there appears to be no problem at this point. It was less than a second that the juror was actually depicted, so it was a relatively minor transgression, but it was something that I felt was serious enough as far as your welfare is concerned that I had to take the time to do it. So I want you to understand that I was interested in your welfare at the time, and I'm sure you understand the need. Unfortunately, it also stopped Mr. Cochran from immediately beginning his opening statement, and on behalf of the court and the court TV, I apologize to defense counsel for that delay. All right, we will now start with the opening statement made by the defense. Let me just remind you that any statements made by the attorneys during the course of their opening statements, of course, is not evidence, should not be considered by you as such. It's merely an explanation as to what they intend to prove or what they think the evidence will show you during the course of this trial. Mr. Cochran, on behalf of Mr. Simpson, are you prepared to proceed?
I'm ready to proceed, Your Honor, and thank you very, very kindly. Morning, Judge Ito, to my colleagues on the right here, the prosecutors, to my colleagues on the defense side, to the Brown family, to the Simpson family, to the Goldman families. Ladies and gentlemen, good morning to you. As the court indicated yesterday, I would have liked to have had this opportunity about 3:30 to address you. And it's my opportunity and it's my honor and privilege on behalf of the defense and our defense team, as it were, to stand before you now and address you what is called opening statement. Now, the opening statement is not opening argument, but that's just that, opening statement. If you've had occasion to go to a movie, you know that there's something called the previews of coming attractions. And that's what this is supposed to be. It's supposed to be a guide, our roadmap, if you will, what we expect the evidence to show. As an officer of this court, and in the course of my remarks this morning and maybe this afternoon, I would expect to tell you as honestly and as forthrightly as I can what I expect the evidence to be. As the court has so appropriately indicated, what I say is not evidence. It's just to aid you and guide you. I hope you remember something else the judge said to you last night. You heard the prosecutor's opening statement yesterday, that you were the same admonition applied to them. Those were not facts. But you kept an open mind, because you promised to do that throughout. We started this process of trial back on September 26th, 1994. That was the first day we all met, when you came down to that jury room up on the 11th floor. And here we are now, several months later, in this search for justice. You hear a lot about this talk about justice. I guess Dr. Martin Luther King said it best when he said that injustice anywhere is a threat to justice everywhere. And so we are now embarked upon this search for justice, this search for truth, this search for the facts. Each of you made a number of promises in the course of the voir dire examination, which is basically unprecedented and due mainly to the largesse of Judge Ito in understanding the possibility of media taint associated with this case. So we know a lot about you at this point. And we, of course, all sides are very, very pleased with the fact that you've agreed to serve as jurors, to give us your time, to leave your lives, to be sequestered, as it were. That's a remarkable sacrifice. Abraham Lincoln said it best when he said that the highest act of citizenship is jury service. And you're embarked upon that jury service. But it doesn't stop with just coming down and taking notes. It doesn't stop with the inconvenience of being away from your families. When it stops is when you, if you can, render a verdict in this case. And whether or not that verdict reflects the evidence in this case. A verdict rendered devoid of sympathy for or passion against Mr. Simpson or any side of this case. You made these promises, and both sides are mindful of those promises. And we know that you're going to keep those promises. Cicero said that he who violates his oath profanes the divinity of faith itself. And of course, we know that you will live up to your promises. And be fair, and keep an open mind, and decide this case not on speculation, not on conjecture, not on surmise, but based upon the facts. You then, as jurors, are the conscience of this community. Your verdicts set the standards of what we should have and what should happen in this community. You have this rare opportunity, it seems to me, to be participants in this search for justice and for truth. And in the final analysis, hopefully by April of this year, I'm optimistic still, you'll be able to render perhaps the most important decision of your lives. And so we want to keep your minds open and fresh so that you can render that decision impartially to both sides, so that people all across the world can say, this system works. This was a fair trial. These were fair people. So thank you in advance again for your service, for the verdict that you're likely to render, and for all the things that you're doing here for us.
Your Honor, the court knows me, and I know Mr. Cochran knows me. I have to interject at this point. This is argument.
Were introductory remarks that were similar in nature to prosecution's opening remarks. I think Mr. Cochran has just concluded his opening remarks.
And I trust so, Your Honor.
That's exactly correct, Your Honor.
And again, I hesitate to interrupt another lawyer's opening statement, but I simply wanted to make sure that this type of statement was ceasing. Thank you, Mr. Cochran.
Thank you. Thank you, Mr. Eisman. I was just about to compliment the district attorney's office on their opening statement yesterday. Maybe I'll take that out now. I was about to say they did a thorough job as far as they went. But they're advocates. And all of us, as you will see today, have an obligation to tell you the whole truth of these facts. So in the course of my statement today, let me share with you some of the things they didn't tell you yesterday, and we'll have to wonder why they didn't do that. The evidence in this case, we believe, will show that O.J. Simpson is an innocent man wrongfully accused. Mr. Darden said yesterday that in Richmond, California, and someplace in Georgia, people were asking questions. Well, I'd like to think that in my hometown of Shreveport, Louisiana, my mother-in-law is in New Orleans, Louisiana, and other places throughout this country, today they're asking, why did Mr. Darden spend all that time on domestic violence? This is a murder case. Why did he do that? And then when he gave you this answer, he was going to answer the question for all of America. It's a little presumptuous, don't you think? Because the answer of O.J. Simpson's guilt or innocence will only be determined by you if you're able to do it. None of us were out there on June 12, 1994. We can only deal with the witnesses as they were. And it seems to me that this case, the prosecution's case, based on what we heard in the evidence, will show this case is about a rush to judgment, an obsession to win at any cost and by any means necessary. The evidence will show that the prosecution in this case has enlisted the services Why? Let me just briefly talk about the witnesses that they didn't talk about yesterday and they didn't tell you about. There's a lady who lives next door and works next door to Mr. Simpson's home on Rockingham. This lady was interviewed as far back, I think, as July. She indicated, essentially, that on this night in question, she came out to walk her dog on several occasions. She knew Mr. Simpson. She knew his voice. She knew the Bronco. She'd seen it parked there many times. She will indicate that when she came out and walked her dog at about 8 o'clock, that Bronco was parked at the curb there. And it was parked at kind of a unique angle so that she noticed it. The rear wheels were a little bit further from the curb. And when you go out there, and I think the court will probably share with you that at some point you're going to get a chance to go out to each of these scenes to see for yourself these areas. When you come out of the Rockingham gate and you make your turn, the evidence will show it's a quick turn. And so you can't land the car up quite like you'd like to. But this lady will testify that she was out with her dog and saw that Bronco parked at that particular angle at about 8 o'clock
8:30 on June 12, 1994, Sunday evening. She will indicate to you that she heard Mr. Simpson's voice at or about the time he and Mr. Cato Kalin went to McDonald's to get the hamburger. But she could hear, because her quarters are right across the fence there, that after he left, she heard something very strange. She heard a prowler that she described out there in the yard with like hard-soled shoes. And she was concerned about this prowler. That's what her statement was. She relaxed when she heard Mr. Simpson return back, could hear his voice back over in the yard. But she was concerned because the people she works for were out of town at this time. She's concerned about this prowler. We'll talk about that more later. She went about her business, and then she heard Mr. Simpson's voice again about 11 o'clock. She could hear his voice at that time as though he was leaving. We know that's correct because he was leaving to go on a trip to Chicago, a pre-planned trip. And then she didn't hear his voice anymore. But one of the important things that she tells us is that after Mr. Simpson had left, after 11 o'clock, she heard men's voices over on the Simpson property between 12 o'clock up till about 2:30 or 3 o'clock in the morning. Heard these men's voices over there talking. She didn't know what was going on. I hope I told you that when she came out to walk her dog at 10:15 that same night, she looked at the Bronco, and the Bronco was parked exactly the same way, at that curb, same way. When she saw the Bronco the next morning, it was parked that same spot, the same place. And one of the most unique things about this lady is the fact that the morning of June 14th, that Monday morning, a police officer came over to her residence to ask her what she'd heard and to put her on alert that if she found any weapons or if the gardeners found any weapons, to let them know. And she can identify that officer as Detective Mark Furman. Detective Mark Furman will play an integral part in this case for a number of reasons. Now, it's very interesting that the prosecution never once mentioned his name yesterday. It's like they just want to hide him. But they can't hide him. He's very much a part of this case. We can only ask ourselves, why didn't they mention him? I think that answer will become very clear to you as the case progresses. But she will identify Detective Furman as the person who came over and spoke with her. And she told him at that time about her observations, about hearing this prowler, and about the fact that she heard these voices that went on until about 3 o'clock because she couldn't go to sleep until about 4. Woke up, it was like 7:30 or 8, and he was there showing his badge through the door. And she saw him on television at the preliminary hearing. So that's how she could identify him. He said that somebody from the LAPD will get back to you. But they never came back. They never came back at all. Because there's a rush to judgment here. There's another witness, Mary Ann Gerches, a very interesting lady, has her own business. On this particular night, in June of 1994, June 12th again, she wanted to find a place in the West Los Angeles, Brentwood area. She drove her car after she closed up her business on Sunday evening and went to Catholic church, went to Mass, went and parked a car. And she came over there on Monday. Very interesting. Before I tell you what she has to say, let me tell you her contact with law enforcement. The evidence will show that Mary Ann Gerches, after she became aware that what she had seen had some great relevance to this case, started calling the police. She kept being transferred around, couldn't get anybody really to talk to her. Finally, when she finally reached the police officer, they told her, we've got that case all wrapped up. They didn't want to hear from anybody else. And then, lo and behold, she called the the district attorney's office. Spoke to a person whose name will be revealed during the testimony, and she didn't feel she's treated quite appropriately. In fact, she will say that the person put her on hold and said, "Excuse me, I'm talking to a psychic right now, and I'll get back to you." I guess it was part of that hotline they had. So it seems they're more interested in talking to a psychic than talking to her. So ultimately, she called the defense, and we talked to her. Walked with her out of the scene. Here's what she will testify about. That on June 12, 1994, sometime after 10:30 in the evening, she's walking down Bundy. She's looking, it's a warm night, she says. She's looking for places that have signs up to rent or to lease. That Miss Nicole Brown Simpson's condo, you recall, is on one side of the street, that's the west side, and she's on the east side of the street. And at about 10:45 p.m., she sees 4 men who come within 10 feet of her, 2 of which, gentlemen, appear to be Hispanic. I think the other are Caucasian. Several of which I believe have knit caps on their heads. The 2 who are behind apparently have something in their hands they're carrying. She thinks they may be undercover police. She doesn't know. They get into an unmarked car and they speed away, and she sees them. And that's what this lady was trying to tell the police, trying to tell the district attorney, trying to tell anybody who would listen. But they didn't want to listen because they made their decision in this rush to judgment. There are other witnesses that I won't bother you with right now because we'll talk about them later on in the course of the opening statement that bear upon that evening. But I will share just 2 of you because it sets the stage for many of the remarks that Ms. Clark made yesterday. You'll recall that in her opening statement, quite well done, Ms. Clark kept telling you that she had to fix the time of death in this case at about, what'd she say, about 10:15? She had to make it 10:15, and she made it based upon a dog's wail. Now, this is the first case you'll ever hear where the prosecution's theory is that you've got to determine the cause of the time of death by a dog's wail. And this is the most scientific of all cases. But there's a reason why she wants that, because she wants to give enough time for her theory about O.J. Simpson to work. But we will produce for you, and hopefully all these witnesses will be available. As you're well aware, these witnesses are afraid. This could be because of all the media attention, but we're going to try to get them. And what I say to you is what these witnesses have said to us at this point. There's 2 people who have been to Metzaluna restaurant, the same restaurant. Mr. Dan Mandel and Miss Ellen Aronson. They've been on a blind date. It's like their first date. And they're walking home. They walk home and they come right down Bundy also. It's very interesting. As they walk down Bundy, they walk on the west side of the street, right past 875, Miss Nicole Brown Simpson's residence. And they walk past there, and it's interesting because as you saw from those pictures, and we all apologize you have to look at those pictures, and certainly to the family, and we want to be as careful as we can with those pictures. But if you saw those pictures, you could see with the gate open, and you walk right past, the sidewalk comes right down, and the bodies were very visible with the gate open. They didn't see any gate open or any bodies or anything. And it was like 10:25. 10:25 at that point. So what does that do to their theory about 10:15 and the dog's will? Now, who are we going to, well, I won't be argumentative. At any rate, there'll be evidence that at 10:25, that people who walk past, who have no axe to grind, have nothing to do with this case, who they know about, we know about, don't see any crime having been committed. There are other witnesses who are going to testify they don't hear any dog barking at 10:15 or no plaintiff wail, whatever that means. And so, in this initial phase of the opening statement, what I've tried to share with you is that all of us, it seems to me, have an obligation to share with you and be as honest and forthright as we can. In that connection, you'll recall that Ms. Clark yesterday talked on a number of occasions about the limousine driver and what he saw. You recall she said to you that the limousine driver, when he came and left to take Mr. Simpson to the airport, she told you that he did not see the Bronco parked there. It's not exactly what he said in his testimony at the preliminary hearing in the grand jury. And I'd like to read that to you if I might. He says this question: did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked.
Objection, Your Honor. Objection, Your Honor. This is taken from different portions of the preliminary hearing.
Overruled.
May I proceed, Your Honor? Thank you. Did you make an effort to look and see if there were any cars there? Answer: I looked to the right to see if there were any cars coming down the street. Well, I'm asking you if you looked, made an effort to see if there was a car parked. Answer: no. There might have been a car there and you didn't see it? Correct. Now that's under oath before the grand jury. Now let's look at the preliminary hearing. What he says there, at a second time this man testified. Then did you leave? Yes. What gate did you leave from? The Rockingham gate. And which way did you go on Rockingham as you exited the gate? I made a left. So you'll have to picture that. As he's coming out of that gate, he's in the driver's compartment, he's going to make a left. The Bronco would be to the right. And which way did you go on the Rockingham as you exited the gate? I made a left. Question: did you look to see whether any cars were parked on the right side as you faced the driveway of Rockingham outside the residence? Answer: I didn't look to see. You weren't looking at the parked cars? Answer: yeah. You were looking to see if there was traffic? Answer: yes, of course. So I used those examples early on to talk about our contention that there is this rush to judgment in this case. That when Ms. Clark said yesterday that they did everything they could to exclude Mr. Simpson, we're going to talk to you about the trails that they didn't pursue, that didn't go down today. We're going to also talk to you about this evidence, what we call the lack of integrity of much of the prosecution's evidence. You saw yesterday some pictures of this crime scene, and the crime scene was certainly bloody. We all acknowledge that. But I think you'll find the evidence will show that the LAPD, in its infinite wisdom in this case, assigned a trainee named Mazzola, who was the officer in charge of collecting this evidence. This was her third crime scene. And contrary to what you heard yesterday from Ms. Clark, our experts, and we have a number of experts that we call to testify. In fact, one of our experts is named Dr. Kerry Mullis. Let me tell you who Dr. Kerry Mullis is. Dr. Kerry Mullis is a DNA expert. He is the man who invented PCR, polymerase chain reaction. He is the man who received the Nobel Peace Prize for this invention. And he will come in here and tell you about this evidence, how sensitive it is, and how these police departments are not trained in the collection and use of it. That this is, by all accounts, 21st century cyberspace technology that is being used by these police departments with covered wagon technology. And so when Ms. Clark tells you yesterday that it's possible, it's like cooking or doing something like that, she said she wasn't an expert, and I agree now on that, at least. She's an expert lawyer, but not in this area. The experts will say that's just not true. And so the collection of the evidence becomes very, very, very important in this case. And so, you know, when they were trying to hide Furman yesterday, there were a couple of pictures yesterday of an officer leaning down, pointing at the glove and the cap and everything. And you notice that as they talked about it, that was Officer Furman. Never bothered to mention his name, never bothered that. And so we have then this concept of the prosecution's theories. You heard Mr. Darden stand up and tell you his theory of how this happened. The theory is only good until the facts come along and makes clear to you what actually took place. And so we think that if you keep an open mind, you'll be able to deal with these theories and then apply the facts, which is your job as the sole exclusive judges of the evidence in this case. Now, Mr. Darden, when he addressed you yesterday, spent a long period of time talking about Mr. O.J. Simpson's marriage to Miss Nicole Brown Simpson. And he spent a lot of time, and he told you a number of things. He told you how, for instance, that this was like a terrible marriage and that all kind of bad things happened, and these people were together 17 years and was just terrible all 17 years. I think you'll find that's not exactly true. He told you how Mr. Simpson was in, how did he describe it? An ugly mood on June 12th, 1994. He told you also that Mr. Simpson came there with some flowers. Well, we'll forgive him for that. Mr. Simpson didn't come with flowers. He was there. The testimony will be he was there, he left and went, got the flowers, and then came back. But let me try to show you graphically Mr. Simpson with his daughter. And Your Honor, I'm now referring to a photograph, and I need to check with my colleagues, and I believe this will be Defendants 1, if the court would allow, or A, whichever court would.
Defense 1.
Defense 1. Thank you, Your Honor. This is a photograph of Mr. O.J. Simpson and his sweet little daughter, Sydney Brooke Simpson, shortly after this concert at Paul Revere High School. This picture was taken, and I think you'll even see the date. You see 6/12/94. This picture was taken by a Dr. Ron Fishman, who was at that particular recital. They were all friends. He will tell you that since Mr. Darden wasn't there, he's got his facts all wrong. O.J. Simpson, according to the testimony, was not in any ugly mood. He talked to Ron Fishman. He was there to see his child. And you'll hear that he came back to Southern California from New York City, where he was on business. He was out of town almost all that week, specifically to try and come to this recital. He had to leave right after this to go to Chicago. He was already back east in New York, and we'll produce a friend who told him, why don't you just stay back here? And Mr. Simpson told him, I missed my daughter's first communion because I was out of town on business, so I want to go to this dance recital. And that's what he did. Does that look like he's in an ugly mood to you there? And you'll see the two of them there at that point. Wherever we can, we're going to bring to you the facts versus their speculations and theories about this man. They don't know this man. The evidence, you will know him by the conclusion of this case. And so, Mr. Darden kind of apologizes at the end and says, this isn't character assassination. You know, when somebody says that, who said it was character assassination? Because he knew that's exactly what it was. So at the very end, when he said it wasn't character assassination, that's exactly what he had done for an hour to O.J. Simpson. He's not charged with any domestic violence. This is a murder case. And in their pursuit to win, they're trying to dredge up some theory to give you a motive, because they don't have a motive for this and these particular crimes. And who's to say that those 4 men we saw running from the area of 875 hadn't followed Mr. Ron Goldman there, as opposed to looking for Mr. Cole Brown Simpson? Can they?
Counsel. Your Honor, I interject once again on the grounds previously stated. This is argumentative. This is not a recitation of evidence. We've gone beyond the normal scope of opening statement.
All right, the objection's overruled at this time. Thank you, Mr. Carter.
Thank you.
Got a little sidetracked there. Let me see. I think I was indicating to you, who's to say, based upon the facts in this case and the evidence, that those 4 men that Marianne Gertjes will testify about hadn't followed Mr. Ron Goldman to that location. Another thing that happened yesterday that is not true that they told you. Ms. Clark told you that Mr. Ron Goldman checked out of work. He was going to come over and do a favor for Miss Nicole Brown Simpson to bring the glasses, and she described for you how he was dressed. I think she said with some white shirt and black pants or whatever, that he then came over to the residence. You saw those pictures as terrible as they were. He was in some jeans and some kind of shoes that are far different. And the evidence will be he went home, dropped off a book, changed clothes before he came to Nicole Brown Simpson. But the reason that you weren't told those facts is because it's important they keep this 10-15 time. They've got to keep everything squashed in there so they can tell you, oh, we had plenty of time to commit this crime. And when we conclude today, you're going to see there was no time to commit this crime. And so, to wrap up this part about the so-called character assassination or whatever, what I'd like you to do, as with all of the evidence in this case, is to keep an open mind till you've heard both sides. They may try to bring out incidents about this marriage, and these people did divorce in 1992. And unfortunately in our society, there are far too many divorces. People don't always get along, and we sometimes get divorced. Some of you probably got divorced, and it's unfortunate when that happens. But I'd like you to keep an open mind. But I think perhaps the most important thing about this whole area is this as a response to Mr. Darden. There is an expert in the United States whose name is Dr. Lenore Walker. She's, by all accounts, the #1 expert in America on the field of domestic violence. She's been called by some the mother of the battered woman syndrome. Now, they didn't talk about this yesterday, but Lenore Walker will be a witness for the defense. And I want to talk to you about her and her testimony because I think it'll be relevant as we talk about Mr. Darden and what he has to say on this area. We know that Mr. Darden is not an expert in this area, and he's a lawyer conveying the facts as he understood them. But he wasn't there. Dr. Lenore Walker, this #1 expert in America, perhaps in the world, in this concept, has seen and interviewed and tested Mr. Simpson. She hasn't concluded all the testing yet, but she will testify to you about the results of those tests when she's completed. But she has and does have some feelings about this case and about Mr. Darden's remarks. In fact, as an expert, she's permitted to watch Mr. Darden, and she watched him yesterday. And she was kind enough to share with me last night what her thoughts were about this theory. I'm going to tell what the evidence is going to be.
All right, Mr. Trudell.
He's going to offer to the jury Ms. Walker's feelings about my specific comments yesterday. My opening statement was not evidence, Your Honor. Ms. Walker ought to confine her opinions to the evidence in the case. And this is argumentative, and it's been argumentative.
Objections overruled.
Thank you. Dr. Walker, along with a number of us in the courtroom when Mr. Darden was speaking yesterday, felt that it's offensive to women to say that they never had a job.
This is argument.
All right, very well. You're right, Your Honor. And let me rephrase
She
that.
was going to testify as to her analysis of Mr. Simpson or what her testimony is going to be. That's one thing. Commentary upon Mr. Darden is something else.
You're right. You're
Thank
absolutely
you.
right about that. Let me see if I
Thank
can
you.
restate that in a positive way, Your Honor. With regard to Mr. Darden's statements yesterday, you recall when Mr. Darden said that Nicole Brown Simpson never held a job, and he wanted to paint this picture for her for being, totally under control and being controlled by O.J. Simpson and under his thumb and that sort of thing. Well, I think that some of us would feel that somebody who raises 2 children, who's an excellent mother, that's a pretty major job, being a homemaker. And we'll talk about whether or not Nicole Simpson was a Barbie doll that one could just make in their own mode. Because even in Darden's statement, he said this was a strong, tough lady. I think you'll find that's what the evidence is going to be. But with regard to this whole aspect of battering, in this case, let me say up front that Mr. Simpson is not proud at all of the fact that he and his wife got into an altercation and she was struck on January 1st, 1989. He's not proud of that. In fact, in the course of this evidence, you're going to see perhaps 3 letters that he wrote apologizing to his wife. But what Mr. Darden and what the evidence hasn't shown you so far was that from 1989, January 1st, 1989, they made a big thing out of that. From that day forward to the present date, there's no evidence that O.J. Simpson ever struck his wife again. Now, you should never strike your wife. But even when he made a mistake on January 1st, 89, he paid his debt for that. He went to court and he pled nolo contendere. He pled no contest for that. He was sentenced to community service and he paid his debt. Now they want to retry that, I suppose. They don't tell you that. There was not any touching after that. In fact, O.J. Simpson did something else. After that incident, he was so contrite that he had a prenuptial agreement with Nicole Brown Simpson. So if they got a divorce, what her share would be. And he went and he had his lawyer put in writing, which was later signed by her, that if I ever strike you again, the prenuptial agreement is voidable. And until the date of her death, that agreement was never made void or voidable. Now, those are the facts. And so when Dr. Walker comes and testifies to you, she will talk about the fact that life-threatening violence usually precedes a homicide incident. And she does not find that in this case. She will, I believe, testify that according to the National Institute of Justice, approximately 2.5 million women are battered in this country every year. An intolerable situation. Statistics indicate, however, that between 1,200 and 4,000 of those women are killed. That's 1,200 to 4,000 of the 2.5 million battered. Dr. Walker will testify that it is impossible to use these statistics to prove that anybody who allegedly batters becomes a murderer. You might liken it to an example of smoking. Somebody may get lung cancer. The fact they get lung cancer may mean they smoke and may not. But if you smoke, I can't automatically predict you're going to get lung cancer. And so that this is not a predictable science, according to the lady who's the mother of this particular area. That although domestic violence is a very, very serious problem in this country, the level of violence in this case, the pattern, is atypical. Atypical means untypical of those relationships where a lethal incident often occurs. For instance, stalkers don't go all across the United States working, doing commercials, shooting movies, having a new girlfriend, going out with their life, doing all the things you're going to find this evidence is about. They don't have a new girlfriend by the name of Paula Barberi, who you've been very serious about from the time from April of 1992 till April of 1993 until Nicole Brown Simpson asked to reconcile and get back together. She did it in this way. She sent to Mr. Simpson, among other things, a video of their marriage, a video of the birth of their children, accompanied by a long letter spelling out how much she wanted to get back with this family. I think you'll find that's not stalking. And Mr. Simpson's response was, we've had problems in the past. I have a girlfriend now. I'm happy. Let's take our time about this. But she pursued. She followed up on that. She pursued. She wanted to move back to Rockingham. She didn't like the housekeeper there. She wanted him to fire her. Michelle is her name. And ultimately, she got into an altercation and struck Michelle. He didn't want to fire Michelle. Ultimately, Michelle did leave after being struck. It was her who pursued this in May of 1993 to May of 1994. When Darden talked to you yesterday, he didn't mention that. We will conclusively prove that to you so that when Dr. Walker talks to you about stalkers demonstrate obsessive behavior that concentrates on controlling the woman at all times and is inconsistent with making a new life, beginning a new relationship with a woman such as Paula Barberi, traveling away from home on business assignments. All of those things go against any idea of stalking that they would have you believe in this case. Dr. Walker will also tell you that there is a major difference between a wealthy person who gives gifts, someone who uses material possessions to gain power and control. And so the prosecution would have you believe that if Mr. Simpson gives Nicole Brown Simpson a gift, it's going to be bought and paid for. Nothing could be further from the truth. Let me give you an example of the testimony that will come out in this case. Before Mr. Simpson ever got married to his wife, he bought her a condominium in San Francisco and paid $500,000 for it and gave it to her free and clear in her name so she could have money up to $3,000 a month. He never, ever saw any of that money, wanted any of that money. There were no strings attached. This is before they got married. And later on in this discussion, I'm going to talk to you about what I call his circle of benevolence. Those who have come within the ambit and sphere of O.J. Simpson and his philanthropic largesse, what he's done for him. And there are many other things. This $500,000 condo, free and clear, he then gave her some more money to buy the condo on Bundy. These are all her own separate things while they're still separated. He asked for no control. She had her own bank accounts. He gave her $4,000 a month for food at the house. And he paid all of the bills when they were together. Let me talk about this circle of benevolence while we're on it right now. It extended not just to Miss Nicole Brown Simpson, but to her family, to Mr. Lou Brown. He helped him become a Hertz licensee at the Ritz-Carlton in Laguna Beach for 7 years. The sisters, Dominique, he paid the tuition for Dominique for a couple of years at USC till she dropped out. Paid the tuition for Tanya, the other sister, I think, for San Diego State for a year or so till she dropped out. There's a cousin, Rolf Bauer, who worked for 7 years, Mr. O.J. Simpson's chicken franchise, Pioneer Chicken franchises. The mother, Juditha, was a travel agent. He gave her his business and encouraged his friends to do likewise. This man had a great relationship with his in-laws. He did wonderful things for them. Took them all on trips, paid their way, took them all out to dinner. They'd go to Hawaii and Cabo San Lucas. This is the same man that Mr. Darden was talking to you about. Mr. Darden says that she never worked. O.J. Simpson encouraged her to become a decorator. She became a decorator. He helped her get jobs from his friends. She redecorated the Rockingham house to the tune of $500,000. And he paid her. He paid his own wife a fee to decorate the house. This man that Darden was talking about, this man gives $5,000 every year to the Angel City Links, an inner city black organization. And the condition of his gift every year is it has to be anonymous, that he doesn't want to know he does that. The thing that he's perhaps proudest about are these next two things I'm going to tell you about. Number one is his mother, Eunice Simpson there. As soon as he was able, he bought her a house. She still lives in that house in San Francisco. This is a man, 47 years old, who grew up in the poor areas of San Francisco, in Potrero Hill, but he never forgot. Became rich and famous, but he didn't forget. So that to this day, he buys the uniforms for the kids at the Potrero Hill gymnasium where the kids go to work out. He still does that, even right now, even while in his jail cell. Bought his mother's house. You'll hear about those kinds of things. And the second thing he's most important, proud about, is that he had a child who drowned at a young age. That's always a tragedy, and you'll hear evidence about that. And the pronounced effect that it had upon him. And after that, he became involved in all these kind of pediatric endeavors. And he has participated in raising hundreds of thousands of dollars for Camp Good Time, for kids who have cancer. He's very proud about that. There's testimony and evidence about that. People who know him, not people who speculate about him, will come in and testify about those things. And so, when Dr. Walker tells you that for a wealthy person to give gifts doesn't mean you're exercising any control. One of the sisters needed some money, up to $5,000, and he gave it to the sister and her boyfriend. And the condition was, don't tell Nicole. It's a lot of control, isn't it? So when you hear about theories, I'm going to tell you about the facts. So you'll hear from Dr. Walker, and you'll hear ultimately about the battery of tests. And I think you'll find that she will say that in looking at O.J. Simpson and interviewing him and looking at him at this point, she finds no evidence of antisocial personality disorder. I think you'll find that becomes very important in this case. And understand that this is no Janie come lately. This is the leading lady in America who testifies in these kind of cases where a battered woman shoots and kills her husband. So this is an area where, obviously, you get a chance to see her qualifications and her ability as she goes about this. Now, back to Mr. Darden's discussion. It tells you a number of things that I'd like to address, at least some of them, with you now. We've already covered the so-called ugly mood by showing you the photograph. We've covered the aspect of the flowers, because Mr. Simpson did get flowers, but he went out and got those flowers. We'll cover the aspect, let me talk to you about Mr. Simpson at that particular recital. I've told you how he came back to California specifically to go to that recital. That he'd come in to Paul Revere at about 5 o'clock and saw his ex-wife. He had to get his ticket and take his ticket back to the person at the door. That his daughter was 30 or something on the program. You've been to those programs where your child is going to come up and she's like, there's probably 100 people there and your child is like 99th and you have to be very interested until you get there. So this was like 30-something and she was at the very end. But as all parents, you kind of sit there and you're really proud of the youngsters and you do that. As the program was going, he remembered that he didn't have any flowers. So when he first got there and he was sitting, he was 2 seats away from his ex-wife, Miss Nicole Brown Simpson. He wasn't staring at anybody. He wasn't glaring at anybody. He wasn't jealous about anything. In fact, you'll hear the conversation he had with Ron Goldman, who was still in the group. There was a group of them who ran around together in Brentwood. And O.J. Simpson was commiserating with Ron Goldman about his problems he was having. Please forgive me. Ron Fishman, excuse me. I heard those sounds. I'm sorry about that. Thank you. Ron Fishman. He's the man who took this picture here. He was talking about his problems with Cora Fishman and the group that ran around together. The testimony will be that he was saying, I'm glad to be out of it. I'm back with Paula. And was he back with Paula? Yes, he's back with Paula. The night before this trial is over, we'll have another picture, but this picture will do for now. By the way, this is Mr. Douglas is going to help us because there are some graphics and things. Hope you'll bear with us. Thank you, Mr. Douglas. Your Honor, can you please see this picture? Would you like to see it? We'll call this, this is...
I thought we had agreed that it would be defense 1, 2, 3, 4.
I think the clerk has not changed it.
Right. But we're going to have so many, Mrs. Robertson. I thought we agreed on this. For now, we'll call it defense 2. And Mrs. Robertson will explain to me the error of my ways at lunchtime.
You are in charge.
No, I'm not.
Oh, I see. This is in 201. And number 201 is another example of O.J. Simpson. This photograph, there'll be testimony, was taken on June 11th, on Saturday, June 11th. That is a charitable fundraiser. I think $25,000 a plate, by the way, to the benefit of Israel. And that's O.J. Simpson there. Now, that night, on Saturday, June 11th, he went with his girlfriend, Paula Barberi, who had picked him up at the airport on Friday evening, June 10th, when he came back from working in the East from New York. They spent that time together, and they went out Saturday evening. And so this picture, again, is graphic evidence of O.J. Simpson and who he really is, it seems, to us. As I said, there is another picture of Paula Barberi with him there that we don't have yet, but that we will. Now, Mr. Darden talked a lot about Miss Simpson being weak and that he exercised all this control over her and picked her friends. The evidence will show that Miss Nicole Brown Simpson was a very strong, independent woman, very attractive, and an excellent and wonderful mother. But the one thing they never fought over and never had any arguments about were those children. But they both mutually loved those beautiful children, and that was very, very important, it seems, to both of them. That she picked and chose her own friends. That O.J. Simpson or no one else could tell her who her friends were to be. She had whatever friends she wanted. She did whatever she wanted. He tells you about two incidents where he alleges there's stalking. Let me tell you the facts and the true facts about those incidents, backed up with witnesses. There's a man in Los Angeles named Joe Stellini who owns a restaurant in the West Side out on Pico. He's a good friend of O.J. Simpson's. They went out to dinner one night. And while out to dinner, they became aware of Miss Nicole Brown Simpson and their party. This is the time when they were separated. And they had an agreement, generally, that if one or the other came in while they were there, the person who was there first would leave or whatever. There wouldn't be any problems. The incident regarding Joe Stellini had nothing to do with Miss Nicole Brown Simpson or her party. He was out to dinner. They might frequent the same kinds of places. You'll hear from Joe Stellini, and you'll see there was not anything about any stalking. The other incident was about Mezzaluna, I believe. It was an incident where they both were at this restaurant. Mr. Simpson's party had already been seated when he came in. And again, you'll hear from these parties who will tell you that these were not any stalking incidents. If you live in Brentwood and there are restaurants, hot restaurants in that area, and you go out to dinner a lot, you're going to run into each other. And there was no hostility, no stalking, no jealousy, no nothing. And so he tries to paint O.J. Simpson as a jealous man. Let me tell you what the evidence is going to be about that. You heard about this incident of Keith Zlomowitz. I'm sure as a witness who's going to be called. Mr. Garden described it. Remember he said yesterday, well, he didn't punch out Nicole and he didn't punch out Keith, or words to that effect. He certainly didn't. What happened was, Mr. Simpson, in one of these incidents, had seen his ex-wife out. They went out dancing afterwards. And he stopped by her house afterwards to try to talk to her. He would go by and woo her on occasion. And the evidence will be that when they first broke up, he was advised in January of 1992 that she wanted a divorce. Between January and April of 1992, it was hard on him. Knowing somebody for 17 years, he didn't want to lose her. He likes family. He learned that from his mother, and he's got this close-knit family. And he likes that. He loved his children. He didn't want to lose his wife. But something happened in April of 1992. As soon as he became aware that she had a boyfriend, from that point on, his interest changed, and he went on. And when he saw what he saw with Keith and Mrs. Simpson, he then went on with his life with Paula. That's when it started, in April of 1992. And so what happened was he wasn't peering in any windows. He came to the front door to try to see his wife. And he looked in, and he saw his wife making love to a gentleman on that couch. Now, according to Chris Darden, Wouldn't you expect that he would just blow up, become ballistic? He went home, the evidence will be. He came back the next day to talk to Mrs. Simpson about the fact that the kids were upstairs and what he saw them doing he didn't think would be appropriate. One of the kids came downstairs. And so when he came back on the next day of this incident, he saw Keith, I think, sitting astride Miss Nicole Brown Simpson, giving her a massage or something in her shoulders. O.J. Simpson talked to both of them, shook Keith's hand, went on his way, and said essentially, look, I don't think you should be doing this in front of the kids or whatever. They didn't tell you that Keith Zlomowicz moved in with Nicole that summer. But O.J. Simpson was back with Paula. Didn't bother him. He knew she was there, that Keith was there. Was he stalking? Was he jealous? Was that a rage? I think not. So, again, I want you to take these facts and look at them. But there's an even more painful incident, probably, that tells you that he's not jealous. He has a very close friend, somebody who's very near and dear to him. The evidence will show who had a relationship with Nicole Brown Simpson, because she told him so when they got back together, and this gentleman told him so. And it was hurtful. But he never said a harsh word to her or this gentleman. He didn't go ballistic. He didn't do any of those things. In fact, you know what he did? He let this gentleman get married at his Rockingham house after learning this gentleman had been intimate with his wife. That's what O.J. Simpson did on that occasion. Your Honor, may I put your name?
Gentlemen, we're going to take a 10-minute recess. Love the tie. Love the suspenders. All right. Let's take a 10-minute recess, ladies and gentlemen, if you'll just step back into the jury room, and we'll resume in 10 minutes. Apparently, the Public Information Office has received several comments that apparently jurors are visible in the reflection off of the bailiff cubicle there. I have looked at the videotape. It does not appear apparent to me, but I only took about 30 seconds to look at it. We'll look into it at noon, but I just thought I'd let you, don't go away.
Well, I guess I can put a cloth there, but there's security concerns, right?
No, what I'm going to do is I'm going to take hairspray so that it won't reflect, is what I'm going to do. But rather than have everybody move while I hairspray it, we'll... All right, Deputy Magnero, let's have the jurors, please. And Mr. Cochran, I'll allow you to, if you want to slop over a couple of minutes there, but close to 12, you know, conclude your thought. And my guess is we're, if I had to guess, that was the introduction.
I'm sorry, it'll be this afternoon. You're worried about witnesses? We're leaving at 3:30 today, you Judge? Yeah. I'll make sure I finish before then. And I will, if that's all right. I'll, you know.
All right, here are the jurors. All right, record should reflect we've been rejoined by all of our jurors. Counsel, ladies and gentlemen, be seated, please. Thank you. All right, Mr. Cochran, do you wish to continue?
Yes, I do, Your Honor. Just 1 second, I'm trying to pick up the last thought.
Certainly.
Thank you very much, Your Honor. Thank you very much.
I wanted to try to pick up where we left off. To conclude those remarks about this friend, I think that speaks volumes about Mr. Simpson, his stability, his relationship with his ex-wife. I think the evidence will also show that in about May of 1992, Ms. Nicole Brown Simpson came over to the Rockingham house and said she'd found a boyfriend, somebody different than Keith, where the incident was April of 1992, and asked Mr. Simpson for some advice. He, of course, knew at that point that it was over and he was back with Paula and went on with his life, as I said, until such time as in 1993. She decided she wanted to get back together at that point. Now, to clear up, I want to always keep the faith with you about being as accurate as I can. The two incidents that they talked about, on the one incident involving the man Joe Stellini, that was at Mezzaluna. The other incident was a restaurant called Tryst. In both incidents, there was no problem, no fight. In fact, in the Tryst incident, I believe it was, at the Mezzaluna incident, Mr. Simpson went home with his wife that night. So that there was not any incident where they were stalking or fighting, anything like that. There was no obsessive behavior. I hope that we'll put those in some kind of perspective. Mr. Darden talked in his opening statement about a 1985 incident in which some damage was done to a vehicle. And as I understand it, the testimony will be that was not any incident in 1985 because Miss Nicole Brown Simpson was pregnant, had a C-section later in that year, and they didn't have any situation like that. They did have some discussion apparently maybe in 86 or in 84. There was some damage done to her car, and she was not in that car. She was not struck on that occasion. So I think you'll find an incident of not great consequence. And Mr. Darden talked about the 1993 911 tape that you've heard so much about. And I think even he conceded yesterday that in that situation, although you could hear Mr. Simpson's voice, he was angry, Mr. Simpson never laid a hand on his wife, never called her a name. And I think the important thing about a trial is that finally you're going to get to hear all of this tape. And what you're going to hear, Mr. Darden didn't tell you this yesterday, is that there was a discussion on this 911 tape. And he alluded to the fact that Mr. Simpson couldn't get out of his mind what he'd seen back on April 1992. Well, now, first of all, most of us might have a problem getting that picture out of our mind of seeing your wife making love to someone else. But at any rate, this wasn't the reason for the argument. What had happened was, and the facts will be, that when they started trying to get back together again in 93, they had an agreement that they would take the pictures of their boyfriends and girlfriends out of the, you put them away, basically, which seemed to be a reasonable request. And there was a dispute because when Miss Brown Simpson would ever see Paula Barberi's picture, she was very upset about that. And Mr. Simpson, on this date, I believe, saw a picture of somebody that she had dated during the time they'd been separated. And he said, gee, what's fair for me would be fair for you. And they got into this conversation that went over a period of time. At some point, it was just a verbal conversation. It escalated, and tempers flare. It sometimes happens with married couples. Doesn't make it right, but sometimes it happens. He came over to her house, and he did, in fact, kick a French door. The evidence will be the door was already broken. He fixed it, but he never at any time struck his wife during this period of time. And what he was saying, at some point, she says, OJ, be quiet. What about the kids? And he says, essentially, you weren't thinking about the kids and being quiet when you were on the couch with Keith. And I think you'll hear that on the tape. So you put it in perspective, and the important point to make is that nobody was ever injured during this period of time. In fact, there is a tape recording and a transcript from some police officers who came out and talked with these parties. And in that tape, you'll get a chance to hear what Ms. Brown Simpson thought about that incident. And they also talked to OJ, who waited there for him. He agreed to fix that door. And they went on with their lives. They went on and continued during that period of time to get along. This was the time they were back together. You should note that Mr. Simpson, because of how he's conducted his life and the things he's done in his life, has been able to amass some assets. Not bad for a young man, a spindly-legged youth from San Francisco, who suffered with rickets, who had trouble walking, was cared for by his mother, who grew up to become the greatest running back in the history of the National Football League. And so, because of that and his commercial endorsements and things, he's able to have several homes. He has a home in New York. And the evidence will be that in August of each year, because of his commitments with NBC, he would go and live in New York. And so he wouldn't try to control Miss Nicole Brown Simpson. I mean, she would do what she wanted to while he was here. Even during '93, he was living in New York from like August to like January, maybe after the Super Bowl or whatever, till August to January. He'd be back there at his New York house. He also had a house in Laguna Beach in Orange County. And one thing I forgot to tell you about the circle of benevolence. He assisted his wife in buying a condo in Laguna for herself, separate from his house. So when she was at Rockingham, she had 2 condos in her own name. One in Laguna, one in San Francisco, she's getting money from, and living at Rockingham. They didn't tell you about that. He also had bought some property in Cabo San Lucas where he planned to build. All of the things that he was doing was about the family, about keeping the family together, about doing things with in-laws and with friends and with the children. So I think you'll hear evidence about the fact that he was away at great periods of time. And while I'm about that, let me tell you about the kind of schedule this man had. You won't be able to see his calendar yet, but at some point, hopefully, we will. If you went back and looked at Mr. O.J. Simpson's daily calendar from January to June of 1994, you'd find a man that in January was out of town and probably still living in New York almost every day. But he was out of New York because he was traveling. Some of you who know this is Super Bowl week. You can imagine that he was in Atlanta that week because that's what the Super Bowl was last year. That the evidence will be that this was a time that he and his wife were trying to make it, that he took some family members, the Browns from Germany, to the Super Bowl in Atlanta, paid for all of them, got them 50-yard seats, took them to all the big parties that are going on this week. He was again out of town during almost all of that particular month. If you looked at his calendar and you're able to be testimony that in February, he was spent a lot of time in Cabo San Lucas. He was in Nashville, in St. Louis, in Miami again, involved in charitable work. Few days where you find he was even here in Los Angeles. If you looked at March, you find that he was in New York. He was doing Bryant Gumbel's charitable golf tournament in Orlando, Florida. Back in New York again. He was all over the country doing various and sundry things. You got to the month of April, he was back in Cabo. From there he came back to Los Angeles. Then he went to Puerto Rico. Evidence will be that some of you know he's an actor, a would-be actor, and that he made this movie Frogman during that period of time in Puerto Rico. Again, very much out of California. And in May, with the exception of some things that he came to do for his children, and by the way, again, talking about the kind of things that he would do at Rockingham. And you'll see this place at Rockingham. On May 22nd, he had a school picnic at Rockingham. We had a number of kids, and I think that's for the Sunshine Preschool. That is where his son Justin went. It was a fundraiser for this school. They have all these kids, and all the people would come to his house at Rockingham to raise money for the school. On May 22nd, he did that. And Nicole Brown Simpson was there. And even though they had agreed in May, earlier that month in May, and he was now back with Paula, when Nicole Brown Simpson got sick the week of May 15th, 1994, she had pneumonia. O.J. Simpson was the one who took her soup, who tried to nurse her back, to get her back on her feet, even though they agreed they weren't going to be together anymore. You heard testimony with regard to that. And he continued, of course, being in and out of town. In June of 1994, he'd had and had taken his two children, Sidney and Justin. And let me say something at this point. Mr. Simpson has two other children that he's equally proud of. The minors cannot be here, obviously, for obvious reasons. But he has two other children that he's equally proud of, and they're here in court today. And there's Arnell Simpson over there and Jason Simpson, sitting between his two sisters, Carmelita Duro and Miss Shirley Baker, and the balance of the family. And you've met Miss Eunice Simpson already. So he, on May 5th, attended a pediatric AIDS affair. Again, his interest in children and AIDS and charitable work, along with Paula. And he took the two younger children. It was a real fine day. And that was on that Sunday. On that Tuesday, he left to go to Washington, D.C. Again. He left town. He had to work. On Wednesday, he was working for Hertz in Washington, D.C. On Thursday, he's in Connecticut, working again at one of his board meetings. He's on these various boards, some charitable, some profitable, hopefully. He was in Connecticut. On Friday and Thursday night, he was in New York with his friend Bender. And he'd work, and he'd try to play golf during these periods of time. You recall I mentioned that Mr. Bender had suggested, you're going to be in Chicago on Tuesday or Monday night. Stay over. He came home for the recital. And when you see his calendar, you'll see it's planned all the way out, far beyond June, of course, of 1994. But it gives you a sense of this man, this man's life, what he'd been able to do with his life and with himself. I point out these things to you because I think as you look at all of the incidents that Mr. Darden talked about, it puts them into perspective. This is not a case about domestic abuse. It's a murder case. It's a murder case about who did these horrible crimes. That's going to be your decision. Not to think that O.J. Simpson is a bad guy or a good guy, for that matter, but to get a picture of him. I think that you'll agree with me that after you hear the facts, you'll have a clearer picture. Now, about we talked about the 1993 incident, I think we did. And I think those are the main incidents that Mr. Darden talked about. One thing I wanted to point out to you is that there will be, I believe, testimony that as these parties got a divorce, as so often happens, Ms. Nicole Brown Simpson had her deposition taken. And she made a statement in that deposition with regard to whether or not he'd ever physically struck her after the '89 incident. And it'll be interesting to hear what that is. That this Mark Furman becomes even more relevant in this case as we go along and discuss it, because he was the officer who had supposedly responded, he says, in '85. There's other evidence that the incident involving the bat and the Mercedes was not in '85 because she was pregnant. But he writes a report 4 years later, in '89, saying he had an indelible impression of Mr. O.J. Simpson and coming to that location. An indelible impression. So we'll have to pursue what that means in this report that he wrote about that incident some 4 years later and whether or not it was accurate. It was not done contemporaneously with the incident. Mr. Darden also said to us that this was not a tabloid prosecution. Well, that's interesting, isn't it? He used those words, didn't he? He said, first of all, this wasn't character assassination, which we now know it was. And he says it's not a tabloid prosecution. Well, I think the evidence will be that after this book that you've heard about from this so-called friend, Faye Resnick, came out, it's when the people started getting all these witnesses who wanted to come forward, talk about these incidents. So whether or not it's a tabloid prosecution is not for me to say. It's going to be for you to say. Let me say this about Faye Resnick.
Counsel,
The
I'm sorry to interrupt, Mr.
Okay.
Your
Go ahead,
Honor, once again, my objection has been previously noted.
I caution you, Mr. Carkin, about what you're just about to launch into, because that person's not on the witness list. And when you say, let me tell you about somebody, I'm concerned.
This,
You're right. There's a possibility that...
All right,
Well-
I think we should hear these objections at the sidebar.
Okay.
However,
And,
Mr.
I tell you, let's do it without the recording. I think we can solve it. Okay?
Please. No. All right, thank you, counsel.
Oh, excuse me, sir. Thank you. Thank you, ladies and gentlemen. Excuse me. I talked just briefly about this witness, Faye Resnick. And you may or may not hear from her. She's on our witness list. There's a possibility. We may call her for a number of reasons because...
Object, Your Honor. There's only a possibility.
Counsel, overruled.
The reason why I think the evidence will show and will be relevant to you is that on or about June 3rd of 1994, Faye Resnick, who had had a long-time relationship with a Dr. Christian Reichart, whom we will definitely be calling, they'd been living together for a long time. And because of her drug usage, because of the fact she was freebasing cocaine, he put her out literally. They broke up. She was one of these parties who they ran in this circle out there in Brentwood. And when she was put out on June 3rd, which I think was a Friday, she then moved over and lived with Nicole Brown Simpson because they were friends. They would go out at night. These were all friends. The evidence will be these ladies would go out 2, 3, 4 nights a week and stay out till 5 o'clock in the morning. Nobody was controlling these women. There's a group of them, and you'll hear about it. They go out dancing, they do whatever they would do, and we know Faye Resnick was using drugs during this period of time. It got so bad, the evidence will be that on June 8th, 1994, they had what we call an intervention, that Nicole and Christian Reichart and her former husband, Paul Resnick, all got together to try and convince her that she had to go into a drug treatment facility called Exodus. And on the 8th of June...
Excuse me, counsel. I'm sorry once again. Your Honor, you had asked us or given us leave to address these issues.
Overruled. Please be
in the
seated.
noon hour.
Please be seated.
Very well.
Thank you.
goes into a drug treatment facility on June 8th, and she remains there, and she's there on June 12th. And I think you hear from the evidence that she is one of the people who calls Miss Nicole Brown Simpson on the night of June 12th, perhaps after 9 o'clock, that particular night, from this drug treatment facility. We'll be talking about that and her role in this whole drama. To conclude, then, what I've tried to do in this opening statement is to lay out for you the fact that in almost everything you hear in this case, there are two sides. that as jurors, I'm sure you're not going to rush to judgment. But this should not be a case about character assassination, and I hope you will keep an open mind until you hear all of the evidence as it relates to who Mr. Simpson is. Now, shifting our attention now to the discussion, the very able discussion of Ms. Marcia Clark yesterday. It seemed to me, as you summarized what she had to say to you, that her argument broke down, or, well, it was argument at the end, but her opening statement broke down into a discussion of timeline and so-called evidence trails. Let me first of all talk to you about the concept of the timeline. We've talked a little bit about that. And let me tell you what she didn't tell you about. And some of this we'll cover, so I won't be redundant. But there are witnesses like the lady who lived next door to Mr. Simpson. There's a Mr. Tom Lang that she knows about and didn't tell you about, who on this particular night, June 12th, 1994, was walking his dog on a street called Dorothy Street, right down the way from Mr. Cole Brown Simpson's condo at 875. That from his vantage point, just a short distance on the corner, he looked up and he saw a lady that he believes was Miss Nicole Brown Simpson, either embracing someone at a vehicle at the curb, and behind Miss Simpson, he saw a man that he described as a Hispanic or Caucasian standing with his hands clenched, standing there looking as though he was angry. And he didn't know why this man was looking like this. And this is about 10 o'clock on June 12th. Whether he was angry because Mr. Lang didn't know whether he was angry because his dog was loose or what. But again, this is what I expect his testimony to be. This is at 10 o'clock, and he sees a lady that he believes is Nicole Brown Simpson at that point. I talked to you briefly before about Ellen Aronson and Dan Mandel, who she didn't talk to, but she's talked to him, but she didn't talk about them yesterday, as they walked past this place, right at about 10:25 or thereabouts. And there's another witness, whose name is Robert Heidstra. Robert Heidstra is in an alley one street over. But when you go out there, you'll be able to see how well you can hear late at night, especially on a Sunday night at this location. Mr. Heidstra, according to his statements, is walking in this alley. And now it's about 10:35 or 10:40. As he walks parallel to where the Bundy residence is, would be then looking west, he hears the sound of like arguing, and he hears someone or a voice say, "Hey, hey, hey," and he hears the sound of a fence closing, and he continues on walking his dog. Now this is at 10:40 or thereabouts, and you know then at 10:45, Mary Ann Gertrude sees these four men running from 875 down toward her direction, and she believes they're coming after her at that point. In her statement to you yesterday, Ms. Clark talked to you a lot about Alan Park, and I read you some of his transcripts, some of his testimony that you didn't hear about. And I think there'll be considerably more with regard to Mr. Park and to Mr. Cato Kalin. An interesting man, and I think that it'll be interesting when you hear from Mr. Cato Kalin about Mr. Simpson and how he appeared that night. Just before we wrap up for lunch, I think the evidence will show you that in order to believe that O.J. Simpson committed these horrible murders, you'd have to believe that he came back from back east where he'd been working to come to his daughter's recital, attended that recital. You see his picture there. He was home getting ready for a trip to Chicago that had been long pre-planned, that he was hungry. And the evidence will be that he didn't have any dollar bills or $20 bills, that he asked to borrow some money from Cato Kalin. Cato Kalin gave him this money. He went and had a Big Mac. You'd have to believe that he was planning to kill his wife either before he got this Big Mac or then went and got the Big Mac that Cato Kalin will describe. He was dressed in some kind of a sweat clothes and some tennis shoes. If you follow the People's Case, you'd have to believe that he then came home and said, gee, I think what I'll do is I'll go over and kill my wife now, and I think I'll take these tennis shoes off and put on some dress shoes, some hard-soled shoes, and change clothes, knowing he's going to be leaving shortly to go to the airport. And then you'd have to believe that, to believe their theory. And then to make their theory work, they spend all this time talking about the plaintive wail of a dog, because they've got to make this as early as possible at 10:15. We know that that's not correct, based upon the facts that you've heard. And to conclude, isn't it interesting that in all of the discussion yesterday by these two very excellent lawyers, they never once mentioned their coroner, Dr. Golden. He's another mysterious mystery witness they don't want to talk about. And when we come back this afternoon, let's talk about why the prosecution doesn't want you to know about Dr. Golden. Let's talk about when Ms. Clark says, well, you can't really fix the time of death here with any precision. We will have testimony from one of the leading pathologists in the United States, Michael Batten, who's also worked for the LA County District Attorney's Office, who's written a book about the John Belushi death. He was able to pinpoint the time of death to within 1 hour. And yet in this case, because the coroner was not called for 10 hours after these bodies were found, or 8 hours, and they got out there about 10 hours, violating the state law, we are precluded from pinpointing this. And they have to tell you that it's about a dog's wail, when a man's life is at stake. We'll pick up after lunch, Your Honor.
Thank you, Mr. Cochran. All right, ladies and gentlemen, we will stand in recess for the jury until 1:30. Let me speak to counsel after the jury has departed. All right, let's clear the courtroom, please.
To portions of Mr. Cochran's...
Oh, hold on. There he is, right behind you.
Oh, there you are. I thought Mr. Cochran was hiding from me, and perhaps Willie should. Okay, no, I see you, Mr. Cochran. And, Your Honor, let me say this. I was about to say, you asked me to examine the record for instances of inappropriate remarks for an opening statement. I want to make the people's position absolutely clear this afternoon with regard to when objections are likely to be opposed, because I want to give Mr. Cochran fair notice. What we heard in large part this morning was not an opening statement, but could very well pass for argument, and if given an argument, would not be objectionable. But this morning, and as I stated to the court, I am reluctant in any case to interfere with opposing counsel's opening statement. It was with great restraint this morning that I did object to a number of clearly objectionable remarks made by Mr. Cochran. I will highlight those in just a few moments. However, Your Honor, what the people are seeking this afternoon is, first of all, an admonition to Mr. Cochran not to engage in argument in the guise of an opening statement. Secondly, with regard to various passages, which I will highlight and pinpoint for the court in just a moment, I'm going to be asking for a motion to strike, and in addition, an admonition to the jury to disregard such statements, because not only are they not evidence, but they are improper remarks for an opening statement, and the jury should be so advised. In addition, Your Honor, after I address the opening statement issue, I have an additional issue to raise with regard to discovery, because it appears we are about to revisit the events of Monday to some degree. I will begin, Your Honor, by stating generally many of Mr. Cochran's remarks were in the form of a rhetorical question. Many of his remarks were in the form of a personal attack on my colleagues, Ms. Clark and Mr. Darden. Such remarks are not fitting, nor are they appropriate in an opening statement. absolutely 100% not fitting, not appropriate. Let me give you just a few examples, and I have to cite to the reference that we were given off the disc that the court reporters were able to provide us. For instance, and I cite to what appears to be 0553 of this morning's transcript, where the defense argues that this case is about a rush to judgment and obsession to win at any cost by any means necessary. Your Honor, such a remark is fitting for argument, perhaps, not fitting for an opening statement. Clearly, that is outside the bounds. And again, Your Honor,
Well, Mr. Hodgman, how does that compare to Mr. Darden's argument that the issue is that you have to establish the relationship and that the person who was guilty of this crime is a wife beater, batterer, controller, blah, blah, blah? Sounds like the same argument to me.
look, does the court intend to make an equity call? I'm simply posing to the court things that I found to be objectionable.
Mr. Hodgman, here's the problem. Each side has to present what their theory of the case is. That involves some type of short explanation as to what that argument is going to be, and here's the evidence that's going to back up our theory of the case. That's opening statement.
And I understand that, Your Honor, and you stated a short.
Yes.
And I would submit to the court that based on what we heard this morning, that line got crossed very, very early on. I will continue.
Mr. Hodgman, let me do this. And please forgive me for interrupting you again, but we did discuss this also informally. My suggestion is that we do this. Because we have to break early for one of the jurors' medical appointments this afternoon, let me let you put these matters on the record when we conclude. Let me just caution at this time, Mr. Cochran, because I did mention to him that I felt that we were about to cross over the line into argument. You can tell him what the theory is. Mr. Hodgman, they are entitled to say that the prosecution has indicated this is their theory of the case and how they're going to proceed. And he's entitled to say this is what we're going to present to counter that. And he gets to explain how they get to do that. Now, I agree with you that evaluating it and saying that your case is trash for this reason or that reason, that gets into argument. I agree.
Okay. And
all right. I will be more. My feeling was that the defense gave both Mr. Darden and Ms. Clark wide leeway in arguing and presenting their opening statements. All right.
But what the defense didn't do yesterday, Your Honor, was engage in rhetorical attacks upon opposing counsel, such as, why didn't Mr. Darden tell you about this yesterday? Why didn't Ms. Clark state something else yesterday?
I agree.
I agree. Argumentative and...
I agree.
Okay.
So what can be said is that the prosecution did not give you a complete picture. We're going to add this piece, and this piece for a clear picture. I think Mr. Cochran can phrase it that simply without referring to what the prosecution said.
Okay. We have additional language, and I raise this now, Your Honor. I will detail these objections more clearly at the time suggested by the court. But time and time again, Mr. Cochran stated this morning, and you would have to believe, and you would have to believe, and then you would have to believe, time and time again, which again, Your Honor, this goes to argument, not to opening statement. Opening statement is supposed to be a recitation of the evidence that they expect to produce. And what you have clearly is argument. This is entirely inappropriate language, Your Honor.
Counsel, I've chosen to caution Mr. Cochran. I can tell by his response to me, he takes my caution seriously. Although I'm beginning to feel like the Rodney Dangerfield of judges these days. In fact, I'll have to call Barry Langberg later today. Mr. Cochran, you will take seriously my caution. All right.
Okay.
I just want to get the ball rolling today because we have a short court day.
And, Your Honor, and I agree with you, and the only reason I raise this now so that we can have appropriate opening statement this afternoon. Reference to hearsay, I lodged my objection this morning. I trust that the court and counsel understand the basis for that. I would point out as well that based upon the record produced thus far in this case, that reference to Mark Furman by name should not have been made. Based upon, no, I am referring to page 11 479 of the record. This is Monday, January 23rd. The court states, I am precluding the defense from making mention of Detective Furman during the course of their opening statement solely on the basis of the fact of the late turning over of other statements of Kathleen Bell today.
And what
I thought that
happened-
was pretty clear, Your Honor.
What happened later in the record, there was a request for clarification. I indicated that they could not mention Detective Furman in the context of Kathleen Bell. They could mention his participation in the investigation, however, not in the and they could not, in opening statement, mention the Kathleen Bell aspect.
Very
There was a later clarification in the record.
Very well, Your Honor. We'll stand by that clarification. Then the last point I'll raise, and I will raise this in greater detail this afternoon, I know the court wants to move along, and that is the discovery issue. I can point out two names in particular this morning that were mentioned in the defense opening statement. Marianne Gertjes and Joe Stellini. These are names which are on the defense witness list, but the way Mr. Cochran referred to these witnesses this morning, it was evident that these witnesses have been interviewed, that there have to be statements outstanding someplace. Now, we have gone through this over the past couple of days. The defense is supposed to disgorge witness statements to the people. And, Your Honor,
I have in my notes that these are items as well that I was concerned about. So
and
let's take...
I share the court's concern, Your Honor. I share the court's concern for this reason, because as we have stated throughout these proceedings, going back to late June and early July in municipal court and
Mr.
superior
Hoffman,
court.
Please forgive me. I recognize it as a discovery issue. We'll take it up as soon as we get the jurors on their way at 3:30. Then we'll have a full hour that we can sit and talk about this. I am concerned, and I do recognize it as a discovery issue, and I'm going to make further inquiry.
Very well, Your Honor. What I'm concerned about is the prospective aspect this afternoon when Mr. Cochran speaks. What else are we going to hear about? The people are being denied the right to a fair trial, Your Honor. That is what's occurring. This is surprise. The court sees the issue. The court sees and senses our concern. It is happening in opening statement, and the people have not received reciprocal discovery. I think that is evident to the court. The people are not getting their fair shot, Your Honor.
All right. All right, let's have the jurors, please.
Your Honor, may I send the witnesses home?
Mr. Cochran?
I think that's probably good. Cut into our time.
Oh, see that more. We have taken 10 minutes of Mr. Cochran's time.
All right.
And what time would you like them back tomorrow?
9 o'clock. What did that mean, Mr. Darden?
Talking to them.
All right, let the record reflect that we've been rejoined by all members of our jury. Be seated, ladies and gentlemen. Thank you. All right, ladies and gentlemen, at this time we will resume with Mr. Cochran's opening statement. Please remember that the opening statements by the attorneys are not evidence. Mr. Cochran.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. When we broke this morning, we had just gotten to the point of discussing the coroner who previously testified in this matter, Dr. Golden, and I think I alluded to the fact that in the course of the opening statement yesterday, we didn't hear his name. And we expect that he will, in fact, be called in this case. Either if people don't call him, then we will. And I think that you will hear evidence to the effect that you can, in fact, determine the time of death with greater precision than you heard yesterday. That if one is qualified, one can look at the state of rigor mortis, the state of lividity of the body, state of the temperature of the body, and also the ambient temperature, use things like the stomach contents. In this case, there was a major problem. Dr. Golden's testimony is that he would place the time of death between 9 and 12 o'clock. Now, between 9 and 12 o'clock, you now have heard enough of the evidence to understand that at 12 o'clock, Mr. Simpson was in the air, and at 9 o'clock, there'll be testimonies you've heard as to where he was at his house. So we have a problem with regard to trying to fix the time of death. And you heard the prosecution's theory yesterday about the time of death being about 10:15. You've heard from me this morning that the defense advances the theory that that's clearly wrong based upon the witnesses that you've heard. Now, with regard to Dr. Baden, who is our expert, and I should tell you a little bit about him, Dr. Michael Baden is a former forensic pathologist, the chief medical examiner for the city of New York. He resides in New York. As I said, he has worked for the LA County District Attorney's Office in the past. He's considered one of the foremost forensic pathologists in America. He came to, the evidence will be, he came to Los Angeles shortly after Mr. Simpson's return from Chicago, and in fact went to the LA County Coroner's Office that week, the week of June 13th. And it was after Dr. Michael Baden's conferences with Dr. Golden and his superior, along with Dr. Baden's colleague, Dr. Barbara Wolf, that the coroner's office wrote a letter to Mr. Hodgman with an amendment to the coroner's report they'd filed. And I'd like at this time to turn our attention to the graphics. This is a letter that is directed to our colleague, Mr. William Hodgman. You'll see Mr. Hodgman there. And we'll proceed on.
D88.
It'll become clearer.
Your Honor, excuse me. May we? I have an objection to interpose. I wish to approach at sidebar, and I would like this image stricken from the screen for a moment. At least certain parties, was that this would be an opportunity for America, law students, law professors, and perhaps even people around the world to see how the system operates in America. I am sorry to say that we have a horrible breakdown. And while I appreciate Mr. Douglas falling on his sword this afternoon, I think he minimizes the consequences and the depth of what has occurred here today. Your Honor, if the people on the day of opening statement were to unload discovery dated June, July, August of this year, I can only imagine that the sanctions against the people would be severe. I don't intend to minimize this, and I encourage the court, do not minimize this at all. Your Honor, it is not only what was turned over this afternoon, which we will need time, and perhaps more than overnight, to examine. We are going to have to go through this and evaluate it in light of other evidence.
I understand that, Mr. Hodgman. That's why I was suggesting that perhaps you ought to take the time, carefully evaluate what you have there, and if you want to come back on another day on Thursday or Friday to argue the issue of sanctions, we can take it up then. I'm just offering that opportunity to you because I think that would be a more efficient way to deal with it.
Well, I agree that some time in order for us to evaluate would be a more efficient way to deal with it. But, Your Honor, we do not want to proceed with evidence until we've had not only an opportunity to view this discovery, but the remaining items that have been alluded to in Mr. Cochran's opening statement. I can go through a laundry list right now, but, Your Honor, I hope this is a file. This, up until today, this is the extent of the defense discovery to the people. Under California law, there's supposed to be reciprocal discovery. That's part of playing fair. That's part of playing the game fair. The people have been severely prejudiced today, Your Honor, severely prejudiced. This conduct is outrageous and unbelievable. Now, in Mr. Cochran's statement this afternoon, we have reference to statements from Joe Stellini, Howard Weitzman, Skip Taft, Ron Fitchman. We have a number of witnesses like that. On top of that, we have a myriad of representations as to the defendant's physical condition with regard to dyslexia. Where is the report? Arthritis of several different varieties. Where are the reports? An expert regarding shoes. Where are the reports? Potential evidence regarding tire tracks. Where are the reports? The cut on his finger. He intends to present expert testimony. He said it this afternoon with regard to the nature of that cut and a possibility of where the defendant got it. Where is the report? Mr. Cochran refers to other photos, apparently other than what have been disclosed to the people. Where are the photos? He talks about having an expert testify that trauma on Ron Goldman's hand is consistent with a certain scenario. Where are the reports? We have all sorts of test results apparently conducted by the defense that have not been forthcoming. We have reference to Ms. Walker, who has been giving information to the defense. I realize she's just recently retained, but Mr. Cochran is referring to findings, to data, to other material that have not been disclosed to the people. We have reference to testimony of Dr. Bodden and Dr. Lee. Where are the reports? The people don't have them, Your Honor. This is supposed to be a fair proceeding. Where are the reports? There are witness statements which have been given to us which have redactions. We're going to be asking the court for a hearing with regard to the nature of the redactions so we can determine whether or not it was proper to even have those redactions. Your Honor, there is a myriad of issues that have been raised by the acts of the defense today, an absolute myriad of issues. The people need some time to digest this. I realize this comes at a difficult time in the proceedings, but I don't think in the history of jurisprudence have we ever had anything occur like what happened today in this courtroom.
All right, Mr. Douglas, would you address the additional issues that Mr. Hodgman raises that...
Certainly, Your Honor. Your Honor, with all due respect to Mr. Hodgman, and he is a colleague whom I respect, he has never practiced law as a defense lawyer under Prop 115. There's a new way to practice law these days, and that way is, since reports are discoverable, Your Honor, reports are not automatically written. Perhaps the way that he's accustomed, whenever you talk to a doctor writes a report and turns it over, and then it's discoverable. Your Honor, when I talk to Michael Bodden, and Michael Bodden gives me some ideas for an opening statement or talks about what is his theory of the case, we are not doing it writing faxes back and forth. We talk over the telephone and we present evidence. Mr. Cochran has been trying cases for 33 years. He doesn't need to have a report in order to say something in an opening statement. I can call Howard Weitzman, who is a colleague of mine on another case, and ask him, Mr. Weitzman, did they tell you to leave the room in that interview? And he said yes. And can I call you as a witness? And he says yes. And there is no report. I can talk to my client about a dear, dear friend, Joe Stellini, and say, what would Joe Stellini say? And he will tell me that Joe Stellini said that there was nothing going on, and I put his name on the witness list, and there is no report. Your Honor, I will fall on my sword, but I object to the insinuation that I am doing something untoward. I acknowledge, Your Honor, that I am not perfect. I acknowledge, Your Honor, that I have done something wrong. I stand before this court chaste, and I acknowledge that. But I have been a lawyer for 15 years, and I take my obligation seriously, and I take the accusations of the people very seriously. I do not practice law that way. I acknowledge when I'm wrong, but there has not been any maliciousness. This is not the most preposterous thing in jurisprudence. This is a mistake. This is a function of dealing with hundreds of witnesses and going to trial in 7 months. This is a function of there being 12 lawyers, 5 investigators, 22,000 pages of evidence. These are slips through the proverbial crack. I accept it and I acknowledge it, but I object strongly to any impugning of my integrity or the integrity of any lawyers on this team. Thank you.
Mr. Hodgman, how would you suggest we proceed at this point? Since the ball seems to be in your court, you're the aggrieved party, how do you want to proceed?
I am the aggrieved party. The people, well, I am not, Your Honor. The people are.
You represent the aggrieved party.
I certainly do, and the people are deeply aggrieved. Your Honor, first of all, we will provide to the court a case that says the defense cannot circumvent discovery laws in the manner suggested by Mr. Douglas. There is a case on point. We will provide it to the court. We'll let the case speak for itself. As far as Mr. Douglas
Well, that was
goes...
part of my, you expect me to believe that comment from the day before.
I'm sorry?
Never mind.
Oh, in fact, I recall, yes, Your Honor. Yes, I think the court is familiar with the case. Your Honor, how do we proceed? We don't proceed at this point because we need an opportunity to deal with what has been unloaded on us.
Counsel, what we are doing, we are breaking early today because of the juror's obligation. Let me suggest that we do this. Do take the evening hours to examine what has been presented to you. Do prepare whatever letter brief you feel is appropriate. Obviously, fax a copy to counsel. I think some of these witnesses, obviously, for example, the Berman child, I think you're aware of, because I recall seeing something about that somewhere in the... Some of these things may not be egregious errors of discovery. Some of them may be very fundamental problems for the people's case that you may not feel comfortable going forward without having some substantial investigation done. I understand that. But what I'm asking you to do is take a few deep breaths, evaluate what you have, evaluate the record from today, and then come to me with a proposal as to how we proceed tomorrow morning.
Your Honor,
I just think it would be a more efficient way to do this.
we will do that. What concerns me is what we don't have, what we have not been given. The court is familiar with the law. The court, a couple days ago, stated, you expect me to believe that. Now, Your Honor, this is just a question of fundamental fairness, and fundamental fairness for the people. The people, too. We have
Mr. Hodgman, I agree. I understand the point you're making. And what I'm suggesting to you is that in a coherent, witness by witness, item by item, you determine what your position is. Because the sanctions for failure or delay in discovery are oftentimes very severe. And if you recall in our discussion from yesterday or the day before, your first position was preclusion, which is the last step the court can take after having exhausted all lesser remedies. So I want you to be very careful about how you do that, because if I preclude something and the Court of Appeal or somebody else decides that I've abused my discretion, oftentimes that's reversible error. And there are enough landmines in this case already. So let me suggest that that course of action to you.
Your Honor, in addition to what the court suggests, we will review Mr. Cochran's statement this afternoon.
I understood that that was part of your comment.
Very well, because we will be asking for an order that any such reports be produced, and forthwith.
Which is why you have the real time, and I suspect you may unplug your computer and take it home with you tonight.
It may be a long time before I get home tonight, Your Honor. Your Honor, we will do as you suggest. We will report back in the morning. I expect it's going to be a very long night. I also anticipate...
They're all long nights, Mr. Hodgman.
Well, they are, but this one's going to be especially long. And, Your Honor, before we can proceed any further, We need to evaluate this, and we need, well, Your Honor, like I said, a Pandora's box of discovery issues has just been cracked open this afternoon. We're going to need time to evaluate.
All right, counsel, just as a precaution, I'm going to direct Deputy Magnera to have the jury brought over at 10 rather than 9, so we at least have a running start to look at these issues and see how we frame them.
I appreciate the court's optimism. 10 o'clock may be early, but
I'm
we
always
will do it.
optimistic. You know.
I know, Your Honor.
All right. All right, any comment from Mr. Cochran, Mr. Shapiro on the discovery issue? Mr. Douglas, I'm sorry, you're the discovery sword man. All right. We will stand in recess as far as counsel are concerned until 9 o'clock. And Ms. Childs, can I see you, please? Ms. Childs. All right. I was unaware of that.
Press conference this afternoon concerning the reason for her involvement in this case. The court should be aware of that because it's a questionable ethics and conduct, and I think that I thought it should be brought to the court's attention.
Well, that person is not presently within the jurisdiction of the court, so I don't know that there's anything I can do about that, or would be inclined to at this point. All right, well, thank you for advising me.
It is defense counsel's witness. Perhaps the court would like to advise defense counsel of the advisability of a press conference of that nature, but perhaps not. I just thought you should know.
Thank you. All right, thank you, counsel.
He is Faye Resnick's ex-fiancée. She dumped him and he's out to get her. That's fine. I have interviewed Mr. Reichard myself with the use of a court stenographer in the presence of his attorney, Mr. Dominique Rubakava, and we have turned that over to the defense. If there is an additional statement or additional information, we would like to have it. If there were additional conversations, not reduced to writing, we would ask that the court order the defense to reduce those conversations to writing. If the defense intends only to rely on the interviews conducted by the prosecution and by the LAPD, then that's fine, but they should stand before the court and inform the court of that. If that's what they're going to do, then there's no surprise necessarily as to Mr. Reichard. But I will say this, and that is that no statement has ever been received from the defense as it relates to Mr. Reichard. In addition, Mr. Reichard is not on the defense witness list. So maybe I jumped the gun on this one. Should strike it. And he should move to the back of the line. And we should be allowed to do as the defense has been allowed to do to us in this case. We should be allowed to let them know when they can call this witness. There's Dr. Barbara Wolf and Dr. Gerdes.
Take them one at a time.
And Dr. Lee. And we can say the same thing about each of these experts. And that is that we have no reports or statements from these witnesses.
All right, Dr. Wolf, Dr. Gerdes, and
Dr. Lee.
Lee. All right.
I think I've already indicated that we have nothing from Dr. Baden.
I thought you had one report from Dr. Lee already.
Only as pertains to
Yes, only as it pertains to the envelope.
Well, that's one.
Well, we heard yesterday that he was the foremost crime scene expert, the best in the world, and he was going to testify about the crime scene. Where's the report? Where's the opinion? We require immediate disclosure of these expert witness reports. And we'd ask that the sanctions already mentioned, requested by us as they relate to other witnesses, apply to these witnesses as well. And then there's the envelope, Your Honor. The envelope that Mr. Cochran waved in front of the jury yesterday. The envelope which contains an unspecified knife, as I understand it. I'm not sure exactly what's inside the envelope. I've seen the report. I have not seen the item, but the defense has seen the item. We have no knowledge or information as to where the item came from, how it was recovered, who handled it when and where, how it got there. We know nothing about this item, except what we know from Dr. Lee's report. But the defense knows everything about it, and they apparently intend to introduce it as evidence in this trial. If that is the case, Your Honor, we have a right to know the true circumstances surrounding this particular object. We have a right to know how it was recovered, how the court was contacted. We have a right, I believe, to know all the details surrounding this particular item. And we require immediate discovery as it relates to this item. And I would suggest to the court that the display of that object yesterday was just one of many flagrant violations of this court's rules and orders. This court ordered us to give each side the opportunity to view any exhibits that might be introduced before this jury during opening statement. We didn't get that opportunity. Mr. Cochran just pulled it out, waved it in front of the jury.
That was not exhibited to you during our two show and tell sessions.
I've never seen it before, Your Honor.
Thank you.
And I had no knowledge that it was about to be presented to the jury. At the time I saw it, it was in full view of everyone in the room, as I recall. The jury should be ordered to disregard any viewing of that item. They should be ordered not to speculate as to the content of that item or the weight to be attached to it. The jury should be informed that this was a low blow and a cheap shot. That it is gross misconduct. A serious violation of the court's directives and orders. Mr. Cochran mentioned yesterday that certain witnesses will testify about the defendant playing cards on June 12, and that he suffered some acute attack of arthritis, I believe, some form of arthritis. Well, it is apparent that Mr. Cochran intends to call these witnesses to testify. Well, who are these witnesses? Where are their statements? Where do they live? We don't even have the names. We'd like that information. We require immediate discovery. And the jury should be advised that the defense is up to cheap tricks and that they're in violation of the court's rules, and that the display, or rather the mention of this card game, the mention of these witnesses, is a flagrant violation of the court's order. The defense also referred to 2 doctors who they say examined the defendant. Who? Where are the reports? Where are the statements? Where are the test results? We didn't get any of that. We didn't get notice.
You have the cite to the record where that is in the transcript. I'm just wondering if you had it. It's all right. Move on, Mr. Darden.
As it relates to those 2 doctors, Your Honor, until we know who they are, how they specialize, or what areas they specialize in, until we get the discoveries, it's difficult to seek a particular sanction. But I'll say this, I cannot imagine, I cannot understand why anyone in a case like this, especially given the supposed quality and abilities of these defense lawyers, why anyone would want to hide expert witnesses in a case like this. It's just unfair. It's mind-boggling. Howard Weitzman and Skip Taft were mentioned yesterday. If there's been a conversation with Mr. Weitzman and Mr. Taft, we would like that statement. We would like that conversation reduced to writing. We would like discovery. Any mention of these 2 gentlemen should be stricken. The jury should be admonished. They should be advised to disregard counsel's comments regarding these 2 witnesses. Next.
How do you suggest I deal with the attorney-client issue that it's obviously going to be raised in response?
I don't know whether there is an attorney-client privilege issue in this situation. I don't know what they have to say. We know they have something to say. And whatever Mr. Cochran has said so far certainly ought to operate as some form of waiver as to some or all of any conversations.
Just a few legal issues here.
Just a few.
Go ahead.
Mr. Cochran referred yesterday to an unspecified doctor who would testify that the defendant's cut, one of the cuts, or maybe both, on his left hand is consistent with a knife cut.
I think he said inconsistent.
Okay, inconsistent with a knife cut. I'm sorry. Thank you, gentlemen. Well, we'd like to know who that person is. We'd like to see his report. We'd like to know what qualifications he has to form such an opinion. That should be stricken from the record as well. That's an expert witness. Counsel knew that this person would be testifying. You know, as I sat there yesterday, the day before watching Mr. Cochran, I noticed that his opening statement, most of it, was typed. He had time to type it, to type out that opening statement, and it was a very fine opening statement, and I'm always proud of Mr. Cochran whenever I see him in court, Your Honor. I love him, I just don't like to go up against him. But if he had time to type his opening statement, then he had time to turn it over. And I'm disappointed in Mr. Cochran. I'm disappointed that he hasn't turned over that information to us, because just this past weekend, Mr. Cochran and I had a telephone conversation on Sunday evening, and we discussed discovery issues. I discussed with him issues and information which he could not otherwise learn or obtain until the following Monday or Tuesday. And I advised him of these things so that he would know that they were in existence and so that he wouldn't be surprised. And so I'm surprised to stand here today before the court, Your Honor, and I'm disappointed in Mr. Cochran. I would think that he would return to me the same professional courtesy. And the court will recall that we have been ordered to turn over to the defense, literally within 24 hours or one business day, the name of any potential witness, as well as the statement, as well as the tape of that statement, as well as a transcript, if a transcript exists. These are the rules that the court has set for the prosecution in this case. But no rules have been set apparently for the defense. Or if rules have been established for the defense for some reason, and I think I know what that reason is, they don't feel as if they have to live up to those rules or to follow those rules. Apparently they feel that they're above the rules. This conduct is outrageous. Mr. Cochran next described an unspecified gentleman who would testify to having had an affair with Nicole Brown. I don't know who that individual is. I'm confident that it won't be Mr. Marcus Allen because I traveled to Kansas City and I was present with 3 police detectives when Mr. Allen told us he never had an affair with Denise, with Nicole Brown. And so if it is Mr. Marcus Allen, or if it is some other person, we would like the discovery, Your Honor. We'd like to know the identity of that person. Mind you, that we don't think it's going to prove to be relevant in this case anyway, but in the event that it does, counsel has dragged this information in front of the jury in an attempt to sully the reputation of the deceased victim, and that's fine. That happens in court. But we have a right to that information, to the name of that individual, and to that statement, that individual statement. And if they think that they can just sit there and talk to these people on the telephone or in person and not reduce their conversations to notes, or if they think they can reduce their interviews to notes and then not turn them over, well, that's not the law. That's not the law in this state. Now, you can't sandbag the opposition that way. And I understand Mr. Cochran when he stands here and tells us how he's the only one interested in the truth in this case. And I appreciate that. But I would suggest to the court that this conduct, as it relates to the discovery in this case, is completely inconsistent with any desire to determine the truth, or to have the jury determine the truth. And I would like the jury to learn the truth regarding the murders of these 2 people, Your Honor. Win or lose, as long as the truth comes out. But the type of conduct exhibited by the defense these past couple of days and over the past several months, I mean, they had the audacity to stand here and demand that you sanction us, all the while knowing that they had statements from material witnesses that they took 4, 5, and 6 months prior. And they knew they had them, and they knew they hadn't turned them over. And they stood here and asked you to sanction us. The gall. The court should impress upon the defense that the rules apply to them. It doesn't just apply to the poor civil servant lawyers over here on the other side. It applies to the dream team, too, and to the dream defendant. It isn't fair. What they've done in this courtroom the past couple of days is not fair. I have never, ever seen anything like this. Mr. Cochran next made reference to tire tracks and another trail of footprints.
Let's take those one at a time.
Okay. it is apparent to us, based on his comments yesterday, that they have an expert. And maybe that expert is Dr. Lee, or maybe it's some other person who has reviewed this issue on behalf of the defense. Whoever that person is, Mr. Cochran has indicated that they will probably be testifying in this trial, or that they will be. We have a right to know who they are. We have a right to any statements they've made, any tests that they've conducted, any conclusions that they've drawn. We have that right. And it's just, this isn't just some right that just came to us the Monday or on January 1, 1995. This is a right we've had for years and years and years. And Mr. Douglas and Mr. Ullman and Mr. Cochran have stood before the court and told the court that we understand, this is what they said, we understand our responsibilities under the rules and laws of discovery. And yet they've chosen to ignore those rules and those laws and the court's order. If they have experts or reports or studies or anything not given to them by us, any photographs, anything relied upon by the expert they intend to call, we have a right to have that. And this expert, if there is such an expert, should not be allowed to testify in these proceedings until the end, Your Honor. Until the end, and the jury should be admonished, instructed to disregard Mr. Cochran's comments regarding this witness in his opening statement.
So you have the same comment as far as the tire tracks and the footprints?
Yes, Your Honor. Next, Mr. Cochran mentioned Dino, and I apologize if I mispronounced the last name. It's Buccola, B-U-C-C-O-L-A. And this relates to his observations at the Red Onion, an incident which was described in our domestic violence motion.
Is this one of the individuals in the car?
Yes. We received a statement, I believe yesterday, regarding this gentleman.
That was not one of the statements
Was it?
yesterday. It's not on my list of items turned over. Mr. Douglas?
Okay. Yes, as they were running to the elevator. Here, have some more discovery. They gave us 2 reports just that way yesterday.
That's not correct, Your Honor.
Well,
Wait your turn, Mr. Douglas.
we'll get there. Mr. Darden, all right, what is the date on this witness statement?
Do you have it here? I believe it is, well, why don't the court inquire of Mr. Douglas, if you don't mind? I don't have it immediately available.
Okay. So but you have now a statement from Mr. Buccola
Yes,
regarding that incident?
yes.
All right.
I believe it's dated, you would inquire?
No, I'll find out soon enough.
Okay, well, it's about January 25 or something like that.
Okay.
And it raises a significant issue, I think. As we proceeded with our investigation, we interviewed witnesses on January 1, and January 2, and January 3, and dates like that, and January 10. And as we turned those witnesses over to the defense within 1 business day, and in compliance with the court's order, we were nevertheless precluded from mentioning those witnesses in opening statement. And we were precluded from calling those witnesses until the end of the prosecution's case. And it was no fault of ours that we discovered these witnesses on January 1 and turned them over the next day. It was no fault of ours. And still, we had to suffer some form of sanction. We suffered a sanction for being diligent. They've given us this gentleman's statement taken just a few days ago. He should move to the back, just like ours.
Now, I don't recall this person being mentioned in opening statement or any issue.
Okay, then he should just be required to move to the back then. and Mr. Cochran should be precluded from mentioning him in the event he intends to.
Certainly. Madam Reporter, how are you doing? All right, I'm going to go another 15.
We received a number of statements on January 25, Your Honor. Mr. Bacola's statement was one. We received a statement regarding Mr. Jason Wood, and we will seek no sanction as it relates to Jason Wood. We interviewed him, we're acquainted with him, and the report we received was consistent with what we already know. And so we will seek no sanction, but we will ask the court, however, to ask the defense, do they have information in addition?
Certainly. Thank you.
Next, Your Honor, there's Ronald Taylor. We received his statement on January 25th. He was on their August 31 witness list. However, they waited until January 25th to give us a statement. There was Paul Solenshine, S-O-L-E-N-S-H-I-N-E.
Hold on. All right, Paul Sonnenschein, the Rubens employee.
Your Honor, I stand corrected. We did receive an earlier statement on Taylor. Don't talk to me, okay? We did not receive a statement on Paul Solenshine until January 25. As I indicated, he was on the August 31 witness list.
I'll never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love.
However, no statement was provided. The same applies to Rosita Ruban, R-H-E-U-B-A-N. We require time to investigate the content of their statements and determine if they have information relevant to these proceedings. They should not be allowed to call these witnesses.
Are the people intending on presenting any of the items seized from Mr. Cowling's automobile?
We have not yet made that decision, Your Honor. they should be precluded from calling Mr. Solenshine and Ms. Ruban until the conclusion of their case and until we have been given a reasonable opportunity to investigate their backgrounds and the content of any statement they might give. Next, there is the statement of Tony Parker given to us on January 25. We had no prior discovery regarding this witness. We require additional time to investigate the content of his statement as well as his background. We were given a statement, or rather Kevin Whalen's statement, and he claimed to have gotten the defendant's autograph on June 12, 1994 at 11:20. You would think that he might be a material witness to the defense, and I'm sure they saw it that way. And he was on their August 31 witness list, but they didn't turn that statement over to us until January 25th, 6 months after the homicides. Yesterday, Mr. Cochran mentioned, strike that. On the January 25, we received a statement from Narendran Singh regarding the possibility of a tape of some kind at the Mezzaluna restaurant. This person was on the August 31 witness list. We received that person's statement on January 25, 1995. And next is Alex Castillo. He has some information regarding a beeper, a pager. And he was on the defense August 31 witness list. But it was not until January 25, 1995, that we received a statement or a report. Can I have one moment, John?
Certainly.
Time and time again, the prosecution stood before the court advised the court that the defense was playing fast and loose with the discovery rules, with the evidence. Each time, a member of the Dream Team stepped to the podium and advised the court as to what they thought the law required. They advised the court that they had no discovery, they had no reports, or they didn't intend to call a witness, or that they had no duty to turn over relevant and material information, statements from material witnesses that they knew from day one they would want to call in this trial. And they did that time and time again. Mr. Douglas did it just last week on January 20. The court may recall, and this is at volume 73, at page 11319, where Mr. Douglas informed the court, certainly, Your Honor, the court understands our obligations under the Discovery Act, and certainly, Your Honor, with this fine collection of lawyers, we understand our obligations under the Discovery Act. And I think their understanding, Your Honor, was probably correct, and that is that they had a duty to turn over the statements of these material witnesses. And I think they understood that. I think the law is pretty clear there. I think Mr. Ullman stated it rather succinctly and clearly when he said, in circumstances like these where trial has already begun, each party has a duty to turn over to the other party discoverable material immediately. And Mr. Ullman said to the court, Your Honor, immediate means immediate. It means now. It means soon as possible. And that, as I recall, was the court's understanding of the term. Well, we've been in trial since September, as I understand it. Well, it is that section of the discovery rules that applies to these defendants, to this defendant and these defense attorneys. They should have turned over this information to us immediately. But they didn't. They wanted to sandbag us. Had they turned the information over to us last week or at Christmas or on December 14, as we did, the court will recall that on December 14, we turned over discovery to the defense, and you had to pull them off the ceiling. It's 6 weeks later now. The sanctions the court imposed on us back on December 23rd and earlier are still in effect. They've had 6 weeks to conduct an investigation, and in that 6 weeks, I don't know what they did in terms of an investigation, but in that 6 weeks, they certainly had an opportunity to think about the issue of discovery. I mean, they filed a 40-page brief on the subject. They argued it to the court day after day. They understand the law. They understand the rules. They know that they are not allowed to turn over discovery to us after Mr. Cochran has mentioned the content of that discovery before the jury already. They know that they have a duty to turn over information to us immediately. But they didn't do that. They didn't do it last year. They didn't do it last month. They didn't even do it the morning before Mr. Cochran began his opening statement. And that's outrageous. That's outrageous. And they didn't do it because they knew that had they done it, you would not have allowed Mr. Cochran to poison the minds of these jurors with hearsay on top of hearsay, with the content of statements given him by witnesses who are completely unreliable, and whose background I am sure that if Mr. Cochran knew or was aware, he would not have even mentioned. When the voters in this state passed Proposition 115, there was a clear mandate, and that mandate was no more sandbagging, no more sleazy trial tactics, no more abuse of the process or of the system or of the courts. As the court already alluded to earlier, discovery became a two-way street. I don't know why the Dream Team can't seem to understand that or grasp that, or why they don't want to follow the rules. I understand that they have a celebrity client, and I understand this is allegedly the biggest murder case ever, but the rules don't stop just for this case. The rules apply to this case. Had we done what they did, I shudder to think what the court would have done to our case. Because even despite our innocent and negligent mistakes in terms of discovery, you've gutted our case to some extent. You've dismantled it in many respects.
Rearranged it.
You rearranged it all right. And I don't think that's fair. But the bell has already been rung, Your Honor, and the shot has already been fired. And once the shot's fired, as Mr. DeBlanc stated last night on television, once the bullet's out the gun, you can't get it back.
You had time to watch television last night?
I heard about it. I heard about it, Your Honor. I've missed the entire NBA season up to this point, and I am upset about that. But the people have a right to a fair trial just like Mr. Simpson does. And we have a right to play on a level field. And that field is supposed to be level and supposed to be balanced. Well, there is a terrible imbalance now. And this imbalance is brought about by the Dream Team's refusal. There's intentional and willful disregard of some very basic and fundamental rules of discovery. This is their fault that the field is no longer a level playing field. It's their fault that things are out of balance. And I want the court to understand that it's not, so much of Mr. Cochran's opening statement the other day. I mean, he did what I figured he would do. He's a good lawyer. They say he's the best. He's a friend of mine. I'm proud to have him as a friend of mine, but I'm disappointed in him. But I want Mr. Cochran to know, and Mr. Simpson too, to know that we're not just here playing games either. We may just be civil servants and blue-collar lawyers, Your Honor, but we intend to win this case. But the only way we're going to win, And the only way we can fully and fairly participate in this process would be if the court rectified this imbalance. And I believe the court must, because this problem and this issue, it's more than just an affront to the prosecution. It is an attack on the integrity of this court. They violated your rules, not just mine, not just the legislature's, not just the rules of court, but your rules, Your Honor.
The legislature had nothing to do with this, Mr. Dard. Do you know that?
Thanks for pointing that out to me, Your Honor. We would ask that the court admonish the jury, and we would ask as well that we be granted a brief continuance so that we can fully assess what has happened, so that we can investigate the backgrounds and the information provided to us in court these past couple of days. And we think we have a right to that. I think we have an absolute right to that. The code section speaks to the remedies the court can provide in a situation like this, where there exists such a flagrant violation of the code. And we would ask that the court allow us to reopen our opening statement. And to correct the imbalance, to make the playing field level again. I'm sure Mr. Simpson didn't play on lopsided playing fields back when he was in the NFL, you know. I mean, there were 11 guys on each side. It was fair. Of course, they had Mr. Simpson on their team. I just want a fair shot. We just want a fair trial. This ain't all about just winning and losing. It's about fairness. It's about justice. Starting to sound like Cochran, aren't you? Although there is little case law, no case law on the issue of reopening an opening statement, there is case law addressing the issue of reopening closing arguments.
I'm familiar with those cases. I was looking for one that dealt with opening statements.
So was I, and I was looking for that case until 2:15 this morning, Your Honor.
I know all about reopening argument, Counsel.
And I would say this as
Well,
well.
let me rephrase that. I know something about it.
And I know the court knows that the court has discretion in terms of the order of proof, in terms of the order of the processes here in this case. And I would say something else, Your Honor, about what has happened here. We have something in the state of California called the Rules of Professional Conduct. It's ethics. And I'm not here to accuse my distinguished colleagues of being unethical. But I would like to point out, if I may, to the court, that there exists in the State Bar Rules of Professional Conduct, Section 5220, entitled Suppression of Evidence. And that section indicates that a member of the bar shall not suppress evidence, that the member or the member's client has a legal obligation to reveal or to produce. And there's also Section 5-200, subsection B, which states that members of the bar shall not seek to mislead the judge or the trier of fact. What has happened here over these past months has been misleading. We've been misled. I believe the court has been misled. There's a clear indication that they have suppressed evidence, information that they should have turned over to the prosecution. And I'm not saying, hey, you should call the state bar or something like that. I'm not saying that. These are my friends. But I do think that they have committed a flagrant violation of the discovery rules, and they have caused the people to suffer extreme prejudice. How are you going to unring the bell? How are you going to get back the bullet once it's already fired? They brought this on themselves. We didn't do it to them. We'd like a fair trial, a fair shot at presenting to this jury the truth. We're not getting that. And we won't get it as long as they are allowed to play fast and loose with the rules. May I have one moment?
Mr. Darden, maybe this would be an appropriate time to take a court reporter recess. All right, we'll take 15. Mr. Darden, do you wish to conclude your comments?
Yes, Your Honor.
No, you had gone through
Yes. I have a
number of items.
Yes.
Do you have any other specific items? And I want to thank you for the specificity of your comments to the court.
Thank you, Your Honor. I just have a few brief comments, if I may. We would just like the court to know that we feel that we have a right, and we feel our position is supported by the law, but we feel that we have a right to preclude the testimony of some of the witnesses whose statements were given to us just recently, or whose statements haven't been given to us, but whose testimony was mentioned in front of this jury. And we're not asking for preclusion. And we're not asking for preclusion because we want to see the truth. We want the truth to come out in this trial. We could ask for contempt. We could ask the court to hold the defense in contempt, but we're not asking that. We're not asking that at all. We're not asking to report anybody to the bar. We're not doing any of that. All we're doing here today is asking the court to level the playing field. Now, just before I left out of here for the break, Mr. Bailey mentioned to me that perhaps what I really want is a mistrial. I don't want a mistrial. I like the 12 jurors we have. I like our case. I like our chances. We don't want a mistrial, Your Honor. We want to see the truth. We'd like to see these proceedings continue. And my distinguished colleague, Mr. Bailey, also asked me before we broke if I felt the need to run away. And I want Mr. Bailey to understand that I'm not going anywhere. We're not going anywhere. We're in search of the truth, and we're going to find it. We have found it. We want the jury to find it. We're going to stay right here, Mr. Bailey. We're going to finish this trial. We just need a little time to repair some of the harm caused by the misconduct of your colleagues and yourself. We just want a fair shot at it, John. Nothing more.
All right, Mr. Darden, let me ask you this. One of the remedies that you're asking for is for the court to advise the jury that I am striking from the record Mr. Cochran's comments concerning certain witnesses with regards to certain issues. Then you were also asking for the opportunity to reopen. Are those in the alternative or in the conjunctive?
In the conjunctive.
Because it doesn't seem to make sense if I'm going to strike it and then you come back and talk about it. That sort of defeating the purpose seems to me to be mildly illogical. They seem to be in conflict. Just an observation. Excuse me, counsel, with one glad one.
The court we were both going to present on this because we just didn't have the time to.
Well,
comment with one.
thank you, Ms. Clark. Just an observation. All right, Mr. Darden, have you concluded your comments?
Yes, I have, John. Thank you.
All right, then I have before me 27 specific items.
If the court may have more, I don't know if the court did a search of the transcript on its own, but that's all that we could pull out in the short time that we had.
Well, I think 27 is plenty for today.
Okay. We'll get another 27 for tomorrow, Your Honor.
All right, thank you. All right, Mr. Douglas, good afternoon, sir.
Good afternoon, Your Honor. Your Honor, I'd like to begin dealing with some of the discovery concerns raised, and Mr. Cochran would like to deal with some of the sanctioning issues that were raised. Your Honor, at the outset of this trial, the court reminded all counsel that the eyes and the ears of the world would be watching us today. It is my sincere hope, Your Honor, to bring dignity to the profession that I love. So I will not dignify the often vile, insidious, and long-winded comments by my colleague by responding in kind. Your Honor, I've known Christopher Darden for well over 10 years, and he has referred, in fact, to me and to my office, the parents of a young man who was once shot and killed while going home from school. So I cannot fathom that he would have entrusted that family in my care if he believed that I or my colleagues were as dishonest and as unethical as he has inferred. Your Honor, he comes to you seeking equity. He comes to you asking about basic fairness. As the court is aware, there's a concept in equity called clean hands. And that comment says that one cannot seek equity without doing equity in kind. And I submit to the court that before Mr. Darden comes and seeks equity, the true record should be considered so that the court can weigh and properly balance a response given the current state of the full record. Your Honor, in September of 1994, the prosecutors gave the defendants a list of 214 names. On January the 6th of 1995, the prosecutors gave the defendants 207 additional names. 5 more were added the following week. 3 more were added after that. 2 more were added since then. The first of his complaints were based on the thought that the defense had somehow dumped names without addresses or phone numbers on the prosecution, and how unfair that was to the prosecution. I give this court at this time the names of Art Shaftman, B. Hart Shaw, Joseph Perulli, Eliza Perez, Cindy Patterson, Brett Lobner, Mark Leon, Ray Kildruff, Bo Jackson, Carlos Hernandez, Richard Gonzalez, Don Detzler, Carol DePrima, Jay Swell, Victor Baffa, Nicholas Bolas, Donna Estes, Gary Kawakawa, Amanda Darling, Patricia Foy, David Prestholt, Cruz Priego, R. Wrench, Rodney Shelton, Norman Smith, John Stewart, Mark Stauffer, Jan Von Poppel, Philip Van Saun, Tony Waybright, Christine Wolford, and Charlotte Ward as just some examples of names given to the defense without addresses or phone numbers. That meant, Your Honor, that the defense had to try to find out who these people were, try to locate them, and try to identify them. They were names that were on the people's prosecution list.
All right, Mr. Douglas, if you will, at the conclusion of today's proceedings, give a copy of the list that you just read to the court reporter.
It has been done already, Your Honor. Thank you.
Your Honor, does the court do this as well?
No, Mr. Darden, thank you. I'll hear counsel's argument.
Your Honor, the fact that they don't know who we are talking about when we may obliquely infer that there is a certain witness that might say certain things does not mean that we have committed misconduct. There is no case authority that they can cite, because there is no case to suggest that attorneys have an obligation to create discoverable notes or memos based on conversations with their client or based on conversations with retained experts. Your Honor, the District Attorney's Office has retained many experts to talk about DNA issues, to talk about blood issues, to talk about other issues. But among the 22,000 pages of documents that we've received in this case, there is not one handwritten note from Marcia Clark, from Christopher Darden, from William Hodgman,
Objection, Your Honor.
from Mr. Fairtlow.
He told us he was not interested in our handwritten notes. Specifically, that was an agreement he had with Mr. Hodgman. He is now misrepresenting to the court
Ms.
the
Clark,
agreement.
I'll hear your comments and rebuttal. Thank you. Mr. Douglas.
From Jonathan Fairtlow, from Scott Gordon, from Lydia Bodin, or from any other attorney, Sherry Lewis, Ms. Kahn, or anyone else who has obviously had conversations with other experts. As well, Your Honor, there have been at least 12 DNA experts that have been noticed by both sides. Carrie Mullis, I strongly believe, was one of the names that were included in our list of experts that they are aware of. And I have not received one DNA report from any of these experts based on testimony that they intend to offer in this particular case. So we're talking about fairness, but we must also remember that both sides must have clean hands. The case, Your Honor, began back in June of this year. We have enlisted several attorneys who work out of different offices. At one time or another, we have used 6 different investigators that were involved in different pieces of investigation. They did not always work in concert. They did not always share their work product with each of the other investigators or with each of the other attorneys. One of the items that were turned over yesterday was a witness statement of Mary Ann Gertjes. That witness statement was obtained by an investigator with whom I personally have never spoke. That is an investigator who basically has done limited work on this case, and unbeknownst to me, one of the jobs that he performed was to interview and to obtain a statement of Mary Ann Gertjes. I represent as an officer of this court that the first day that I personally became aware of the existence of his statement, taken of Ms. Gertjes, was moments before I took the podium yesterday when Mr. Cochran gave me a copy, and I asked your clerk to make copies so that I could read myself. Certainly, Your Honor, I recognized fully yesterday that that was a violation to have not turned that statement over. But if the court were to read that statement, the court would see that Ms. Gertjes had contacted the district attorney's office and spoke to Patty Fairbanks in that office. That Ms. Fairbanks told Ms. Gertjes that I'm talking long distance to a psychic, so I'll have to call you back. That in her despair, Ms. Gertjes contacted the police department, giving them information that was brought before the jury yesterday. That Ms. Gertjes' name, address, and telephone number were included on the witness list that we provided in August of 1994. So certainly, Your Honor, while there may have been a problem with our physically turning over her statement, the surprise, the absolute shock and amazement that has been offered here is somewhat overblown. For example, Your Honor, not only did we give the name of Rosa Lopez, we gave her address as being a location directly next door to where Mr. Simpson lived. Not only did we give her name and her address, but we gave her statement as well. Despite having her name, her address, her telephone number, and a statement, there was no representative from either the district attorney's office or the Los Angeles Police Department to interview Rosa Lopez.
She's not one of the individuals under dispute here, Mr.
Your Honor,
Douglas.
I'm simply by analogy hoping to offer to the court that the protestations of prejudice are perhaps not in good faith, because though they had the very important information on Rosa Lopez, they never saw fit to go and interview her until Monday evening when Mr. Bailey stood up and explained to this court the significance of her testimony. I offer that to say, Your Honor, that yes, there may have been some facial violations of the code. However, before the court believes that there has been dire prejudice, you have to look at the equity. You have to look at the clean hands. And that's what I seek to offer to the court. Now, Your Honor, there has in fact been a list given yesterday because the court made it very clear on Monday that I would have to go through, on Tuesday. Monday, when I gave the name of supplemental witnesses, I told the court that these were the statements that were attached, and there were, I believe, several names and 6 statements that were attached. There was one name in particular, Scott Matsuda, that the people knew about and that they knew that there had been a statement of, and that statement was not immediately forthcoming because it was not attached in that packet. I then made a call, and the next day that name and that statement was given to the people. It was on Tuesday that the court directed me specifically to go through my entire records and to make sure that I have completely satisfied myself, that I have gone through and found out everything that has not been turned over. And we did an exhaustive process, Your Honor, and we followed through with the court's warnings and the court's directions. And that was how we were able to find out that there were 12 statements that had fallen through the crack. 12 statements out of hundreds of names that were given by the prosecution and hundreds of names that were provided by the defense. Now, Your Honor, of these 12 individuals whom statements have been prepared, there are 5 whom I reasonably expect that I will be offering testimony at trial. Therefore, Your Honor, when the court considers the propriety of a sanction, the court should do so within the context of reality. It doesn't make much justice or fairness to cry out numbers or to call out names without knowing in actuality the impact that it's going to have on this trial. And, Your Honor, it cannot be ignored that this is January the 26th, the start of the beginning of the case. It is a day when typically, in preparation for the trial, the lawyers huddle together, the lawyers review the state of the record, the lawyers review the state of all of the pretrial arguments and rulings, and get together and decide whom we now reasonably expect to call. And we did that. And even on doing that, Your Honor, we omitted the names of Ron Fishman, we omitted the names of Christian Reichardt, and those names will be soon added. But the people have added names just this very week, and we are already beginning their case, should have been today, perhaps tomorrow, but they too are still adding names. Your Honor, when you look at the 5 individuals whom we reasonably believe that we are actually going to call, it is my opinion that only 2 of those names are names that are unknown to the prosecution. And, Your Honor, they talk about how they've been sandbagged, yet in 24 hours they have attempted to assassinate the character of Mary Ann Gerchis, one of our witnesses, by suggesting allegations that are totally untrue. And, Your Honor, Mr. Cochran will deal with that more when he comes up. But, Your Honor, there is a tremendously effective wheel that is already in place called the Los Angeles Police Department. And there is another cog in that wheel called the Los Angeles District Attorney's Office. And although they may have been given short time to adequately investigate some of the names, they've done a pretty good job in 24 hours. And I dare say they'll be able to do a much better job in the 2 months' time it's going to take, at a minimum, before we begin calling any witnesses on the defense. Your Honor, if this were the first day of the defendant's case, and we were then intending to call Mary Ann Gerchis or Ron Fishman or Christian Reichardt, I would not be making the same arguments to this court, because I would recognize that there would really be a clear prejudice. But when we have 400 names on a witness list, and when we have a 6-month trial estimate, and when we have the expectation that there will be dozens or scores of witnesses called, I believe this court may fashion a more equitable solution to this problem, a more equitable response to our mistakes, recognizing that these lawyers, whom you also know, whom you also have some admiration for and respect for, whom you also believe would not maliciously or in bad faith attempt to sandbag or do all of the things that have been alleged. I think certainly, Your Honor, you don't come into this position in a vacuum, and certainly I think you can understand, given the massive size of this case, given the complexity of issues, given all of the witnesses who will be called, that it is likely that things fall through the cracks. Now, Your Honor, the people stood up here in December and tried to tell you all of the reasons why they made certain mistakes. And the court said that the code required that they immediately disclose and that they hadn't done so immediately. And the court then issued a sanction which the court felt was appropriate. I think the court should do the same sort of balancing today, because in December the 14th, or whenever that hearing was, opening statements were due to begin the following month. We have at least 2 months now before we're even going to call any of the defendant's witnesses. Your Honor, Marianne Gertjes is a name, as I suggest, that the district attorney knew of. Her statement taken in July gives the name of Patty Fairbanks or Patty Fair something, clearly suggesting that she had had contact with someone in the district attorney's office. Michelle Abduran, who's another name on our list, with a statement turned over yesterday, is also a person with whom they are aware. They have interviewed other witnesses about Miss Abduran and about the allegations that Nicole Brown Simpson struck her prior to her leaving the Simpson home. Joel Pitkoff, who is an employee of Ford, is a witness who we intend to call, who is probably unknown to the prosecution. And on that one, I would accept the sanction of allowing them to adequately provide or perform background investigation and background research and try to challenge the strength of the numbers that he is going to offer and require us to wait and receive permission from this court before we mention his name or before we call Mr. Pitkoff as a witness in this case. Kevin Whalen, the courier, is another person who I respectfully believe was in fact unknown to the people. And similarly, it would be measured and proper for the court to impose that sort of a sanction. Mark Partridge is the fifth of the names that I gave witness statements for yesterday, whom we do intend to call. But, Your Honor, when I reviewed my list this morning, I saw that there was a one-page statement of Mr. Partridge that was turned over in August. What I turned over yesterday was 2 additional pages. So therefore, they cannot complain to this court that they did not know Mr. Partridge and that they were not aware of what evidence he would offer in this case. So it would not be proper or fair to include him with the other 4 names. Ron Fishman, Your Honor, is a friend of Mr. Simpson. When we go down to lockup or go down to county jail and have conversations with Mr. Simpson, and we take notes during those conversations, and we'll ask him about what would Ron Fishman say, and Ron Fishman may make certain comments, or Mr. Simpson may make certain comments about what he believes Ron Fishman will say, or Joe Stellini will say, or Louis Marks will say. Your Honor, when we're thinking about calling witnesses weeks or months in advance, we do not have time to spend on limited resources, and they are in fact limited, for investigator time, and there are 2 investigators now only working on Mr. Simpson's behalf on a full-time basis to try to track down friendly, favorable witnesses whom we will not call for at least the next 2 months or so. And therefore, because we do not want to be sanctioned by preclusion, we then put their names on the witness list. And sometimes, Your Honor, we put the names on the witness list before we even have a copy of the address or the telephone number, because we expect reasonably and fairly that they will be called as witnesses, and that by the time it is relevant and necessary, we'll be able to provide continuing discovery, because it is in fact a continuing process. Your Honor, there are occasions when we've interviewed or spoken with, Mr. Cochran would speak to, for example, Henry Lee, Barbara Wolf, Michael Bodden. These are individuals who are on their witness list. They are aware of the names. And I do not believe that the people have cited a case that argues that when a lawyer speaks to an expert about something that the lawyer may say in his opening statement, or about a proper response to the suggestions in the people's opening, that by that conversation alone, he is required to reduce that conversation to a discoverable document and then immediately turn it over to the other side. That is not the obligations, even under Prop 115, or the U.S. Constitution, or the California Constitution, Your Honor, because this man still has Fifth Amendment rights that still survive even Prop 115. Your Honor, they talk about not knowing about Dr. Kary Mullis, the Nobel Prize winner. I represent to the court that Dr. Mullis was a witness in the Wynn case, a case where Mr. Robert Blazier was the defense attorney in, a case with some of the same DNA issues, and a case where Mr. Blazier won and the court decided that DNA was not adequately reliable to be admitted in a criminal case. The district attorney's office is aware of that. And Your Honor, I believe that if Mr. Darden were to check with Mr. Woody Clark and Mr. Rock Harmon, he would learn that they have attempted to obtain Mr. Mullis's testimony in that particular case, that indeed Mr. Harmon sought to be introduced as a special district attorney in that case to help cross-examine some of the defendant's experts. So for them to say that lo and behold, they didn't know, that they are surprised, I suggest to the court, is not totally with good faith.
Mr. Douglas, is Mr. Mullis on your witness list?
Your Honor, I've just looked for today, and he was on the list that we gave in October of complying back and forth with who our DNA experts are. He was not placed on our supplemental list, but he will. But that list, Your Honor, of DNA experts responded to their list of DNA experts. It was turned over to the district attorney. Mr. Clark, Mr. Harmon, and Ms. Khan are aware of each of them.
All right, was his CV exchanged in accordance with our agreement?
My understanding is, Your Honor, and Mr. Scheck is no longer here in court. Hopefully he's watching on a television with his family in New York City. But it's my understanding, Your Honor, that both sides have now mutually exchanged resumes of each of the DNA experts. But that's my understanding secondhand from Mr. Scheck. There's a suggestion, Your Honor, that Barbara Wolf was a surprise. Ms. Wolf's name, her address, her telephone number were provided in August of 1994. Again, we have conversations with Ms. Wolf. We do not reduce those conversations down in written form. There are no reports from Barbara Wolf concerning her testimony or her conclusions or her findings in this case. There are no reports from Dr. Michael Baden concerning his testimony, his conclusions, or findings in this case. There are no reports from Dr. Henry Lee, who is in fact the preeminent blood splatter expert in America concerning his conclusions, his findings, or his impressions in this case. We are aware if any such report is generated that it is discoverable, and we will do so. Your Honor, Mr. Weitzman is an attorney that Mr. Cochran has known for 30 years. I have enjoyed the pleasure of his company for 10, and I call him on the phone at home if I need to. When I say, Howie, tell me about what happened at the jail, and he says, they told me I had to leave, I do not think law or the code requires that I put that in a writing and turn it over to the other side. Skip Taft has been Mr. Simpson's personal business attorney for over 20 years. When he tells me that the police officers told him that they had to leave when Mr. Simpson was being interviewed, that is not a conversation that I would put down in writing. Whether or not the disclosure of the envelope was a proper function to present to the jury is not really a discovery issue, Your Honor. Is not really a discovery issue. That is properly a 402 issue. But remember, what happened was Mr. Hodgman stood up, Mr. Cochran walked over, told him what he's going to do, giving him the benefit of his information, allowing him to lodge an objection. It was lodged, sidebar was approached, the matter was resolved, and he moved on. There is some question about the statement of Dino Bucola, Your Honor. Mr. Bucola's name was given on Monday, and the court asked me, do you expect me to believe that there is no report? And I said yes, and there was no report. But on January 24th, in part because His Honor gave those words to me, I had my investigator interview Mr. Bucola. That interview took place on January 24th, and the document was faxed to our courtroom fax at 4:16 p.m. that day. When I received that document, Your Honor, rather than leaving the courtroom, I went upstairs myself to the 18th floor and handed that document to Sherry Lewis, making sure that I could do everything that I could in the face of the slings and arrows that were slung my way to show my good faith, to show that I'm trying to play fair, and to obviate any accusations that I heard this afternoon. The prejudice, Your Honor, that the people have suggested is just not true. Before 1992, Your Honor, there was no reciprocal discovery. Yet there were murder cases, there were robbery cases, there were shoplifting cases, there were drunk driving cases where the people would open up their entire file and the defendants would give absolutely nothing. So for these histrionics to go on and for there to be the suggestion that this is the most egregious wrong in the history of jurisprudence is laughable, clearly laughable. Only since 1992, when the people of this state, not the legislator, thought in their wisdom to impose on the defendants the requirements of Prop 51, have those requirements been in place, and defense lawyers in this state are continuing to wrestle with the implications of that law. We are continuing to weigh and to balance our obligations to a law that we feel is unjust and our primary obligations to our client who has an absolute right against self-incrimination. And Your Honor, if it means that we weigh in favor of self-incrimination and that those interests are more profound and those interests are the strongest, and as a result, we must be precluded from offering the testimony of those witnesses until the end of the defense case, so be it.
Mr. Douglas, as a former longtime federal public defender, this scheme of reciprocal discovery is not unknown to you, and it's well settled in the law given to us by the United States Supreme Court that these schemes are not unconstitutional.
Your Honor, I'm not arguing that the schemes are unconstitutional, but I argue that as a defense lawyer, I must constantly, daily wrestle with the internal conflict within me of resolving a law that I feel is unfair, a law that I feel is unjust, but a law that I'm compelled to follow. And there are conflicts, Your Honor, that are occurring across the defense offices in the state, in public defender offices everywhere. No one who represents a man accused of a crime, particularly a murder case, enjoys complying with that law. But we must, and we try to. Your Honor, I recognize that it is not a constitutional issue solely. I recognize the wisdom of the courts. I do not argue that I should not or must not comply with the rule, even though I feel it unjust. And I do comply, Your Honor. But I offer to the court that when the court measures and balances and weighs everything, when the court does equity, which is indeed one of the most important roles of a judge, that a court balance the equity of the prejudice to the defendants and the real prejudice, not just the puffed up souffle of prejudice that we've heard this afternoon, but the real prejudice against reasonable solutions to a clear and understandable mistake.
Mr. Cochran?
Thank you.
Good afternoon, counsel.
Good afternoon, Your Honor. Of all the lawyers who've addressed you, Your Honor, this afternoon, I'm going to try and be the shortest if I can. I'm sure you've been very patient, as always, and listened to us. I'm going to try not to raise my voice, Your Honor, because I think that it's important that we always try to conduct ourselves as professionals, even in the face of some rather untoward attacks. But I ask the court to remember that in the prosecution presentation, Mr. Darden, my good friend Mr. Darden, and I'm reminded that my wife is present in court here today, court knows. And during the break, I introduced her to Chris Darden, and Chris says, I'm your husband's good friend, and I told my wife, I certainly hope that you don't love me like he does, because I think I might be in trouble. But I want to point out to the court that with regard to Mr. Darden and some of these histrionics we've heard over the last couple of days, Mr. Darden is the same person who stood before you and told you that if we interrogated any police officer, like Mark Furman, with any racial slurs, it would so pollute, we could not pursue racial animus. It would so pollute this jury that they couldn't get a fair trial. Their whole case would fall apart. Remember that? You have to understand and put it in perspective. They're the same people who brought you that, which is not going to be true, and I think everybody agrees with that. The counsel made a number of statements in their opening statement, and I think we should put things in perspective about opening statements, Your Honor. You have said on a number of occasions, and I said, we all said when we got up, opening statements are not evidence. What we expect to prove. What we expect to prove in good faith. If you don't prove that, then you suffer the slings and arrows that occurs with that. For them to stand here and talk about that they have suffered, there's an uneven playing field. Your Honor, for the first time in 7 months yesterday, somebody was able to get up and say something on behalf of Mr. Simpson. And that's all that took place. All I did was try to address what they had said, Your Honor. And
No,
with
objection, this is not relevant to the matter before this court, and Mr. DeCosmo has already addressed
Ms.
the
Clark,
court.
Ms. Clark, please, when we're here, outside of the presence of the jury, I'll hear the complete comment of counsel, please, without objection. You'll have an opportunity to respond to this. Mr. Cochran.
Thank you, Your Honor, again. With regard to this, I tried to address the things that they'd said in their opening statement, and I felt they said a number of outrageous things that they couldn't prove by any stretch of the imagination. But I didn't stand up. I didn't come crying to you that night and said, look, Judge, he can't prove those things. He can't prove those things of domestic discord he talked about. That's not going to be, because we don't try cases that way, Judge. I'll just wait until I get my chance to tell the jury what I think, and then I will deal with the evidence. It's the evidence that we'll be talking about in this case. Now, certainly, for anyone to stand here and say that after 32 years of practice, that I would in any way jeopardize my reputation or do something untoward in a case, I would never do that. I would never, ever do that. What we're talking about here, and I wouldn't stand up as Ms. Clark did and tell the jury that Alan Park says he saw a Bronco parked there. I didn't jump on that. I just came back and read what he said. I don't have to call anybody a liar. I think in this case, that's the problem with them. They always want to label everybody. I would much prefer reading the testimony. And then I think it makes it clear. That's what I think we'll be doing or trying to do. Now, they make a big thing about all the things that I said. And it turns out, Judge, with regard to the things I talked about yesterday, that Dan Mandel and Ellen Aronson, very well known to them. They had all the reports. They talked to him. We had talked to him. Tom Lang, they talked to him. We had talked to him. As Mr. Douglas points out, Rosa Lopez, they talked to him. We had talked to him. Mr. Douglas has explained the situation with Marianne Gertjes, and I apologize to the court for that. Certainly, I thought that had been turned over. The last thing in my mind to try to do that. But I want to tell the court something about the responsibilities of counsel and why we need to be professional. During the break, we received a call in this courtroom from Marianne Gertjes' lawyer. She was so distraught. She is totally distraught at having been called a thief on television by Mr. Darden. He should be real happy that he made these statements within this courtroom. Her lawyers are incensed. This woman is very, very, very upset. She says it's absolutely untrue, and what she said is the truth. I mean, it's ironic and outrageous that they would do that. It seems to me, then, that whenever they stand up to talk, Judge, it has to be character assassination. Whether it's O.J. Simpson, whether it's Marianne Gertjes, whether it's at the end of this morning where he stands up and says, everybody on our list is a liar, a thief, or a felon. Isn't that interesting, Judge, that anybody that they don't call becomes some very bad person? I don't think you conduct yourself that way, and I don't think that's appropriate when you talk about how we appear and how this system appears around the country. Now, more specifically, I've indicated to the court about Marianne Gertjes, and the court, Mr. Douglas has talked about Kerry Mullis. There's no confusion there. There's no confusion with the people regarding Cora and Ron Fishman. They know all these people because they all ran around together, Your Honor. And if it was inadvertent we left their name off, we apologize for that. I assume those names have been taken care of. My job has not been that aspect of it. I'm not trying to shy away from it, but everybody has responsibilities and roles, and so you can't do everything. But we want to adhere to that. Certainly, it's outrageous for anyone to say that we think we're above anything. I've practiced law in the courts of this county for 32 or 33 years. I am the blue-collar lawyer that he's talking about, except you see, I was on that side for almost half the time, and I've been out here earning a living the rest of the time. And so I understand both sides. I understand. Now, one of these days, when they get up enough nerve and come on this side, they'll understand, Judge, that it's tough when you have to run your own practice. You know, and Marcia was there for a short time. Yes, she was, to the credit, but not as long as we've been here. And she'd understand what Mr. Douglas was trying to say, and I want to clarify this as being a little older, maybe a little calmer at this point, that there is this philosophical thing, and then I want to point it out to you, Your Honor. And you, the other day we had this conversation, we talked about defense lawyers and their role, and you said you've been a defense lawyer. When I go to the jail and I talk to my client, and he tells me something, I don't have any obligation to tell them that, Judge. If I know that he has rheumatoid arthritis, if I know that he had trouble shuffling cards on June 12th, there's no report on that, Judge. If, as Mr. Douglas says, if I talked to Howard Weitzman, whom I've known for 30 years, we represent Michael Jackson together. If I talk to him and I know what he and Skip Taft will say, there's no report on that. I don't think that you require us, in the midst of everything else, to sit down and write a report regarding that. Now, they know Howard Weitzman was down there. They know Skip Taft was there. This is no surprise, Judge. What happened, Judge, yesterday, and I want you to put this in perspective, was finally somebody from the defense had an opportunity to stand up and tell the facts as we understood them. If they don't like those facts, they say they feel is unfair. Judge, if we don't prove those facts, then they're all the better for it. They benefit from that. Nobody's trying to sandbag them. For months, they talked and tried this man in the press. Talk about unclean hands, to vilify somebody like this man. And then even to stand here today, Your Honor, and refer to him as a dream defendant. Your Honor, who would ever want to be a defendant? That's if ever there was an oxymoron, Your Honor, that may be it, isn't it? A dream defendant? I mean, who wants to be a defendant? But that's to malign all of us. And we don't take it personally because Mr. Darden says he loves me. So since he loves me,
And I do.
I'm not going to take it personally. But Judge, to go and look at the rest of the list, Joe Stellini is a friend of the defendants. There's no report. We've not interviewed Joe Stellini. We don't have unlimited resources like they have, Your Honor. Michael Baden and Barbara Wolf came out here the week of these murders, if the court pleases. They went over, and there's a letter where Mr. Shapiro offered to help the LAPD and the coroner's office help solve this crime, which was rejected. They went over to the lab. They went over, looked at these exhibits. They know about them from the beginning, Judge. They were there like June 15th. They know about it. The one report from Henry Lee that you know about, we turned that over. I mean, we don't have any other reports. Now, I mean, I can't make, these are busy men. Henry Lee is the foremost blood splatter, crime scene, forensic expert in the country. And so they might not lack we have Henry Lee on the side, but that's not the reason to bar us. They know about it. Same thing with Kerry Mullis. If he wins the Nobel Peace Prize and they don't have him, they may not like that, but that doesn't level the playing field, Judge. They know about it.
I don't think he won the Peace Prize.
I said that. You know, Judge, I said that. I'm going to make that clear. The Nobel Prize for Chemistry. I had Dr. King on the mind yesterday when I was saying that, who did win the Nobel Peace Prize.
Linus Pauling won both. Never mind.
Yes,
Never
the only
mind.
one. No, you
Never.
would know those facts, too. I'm not surprised, Judge. You would. And Judge, is he on our witness list yet? Okay. Well, if we put him on our list, then I'll let you know. If we put him on your list, Judge, I'll let you know.
If he appears, I'll be amazed.
Then you'll be amazed. Well, I think so, Judge. Your Honor, to continue on in a serious vein, so with regard to Michael Baden, Henry Lee, and Barbara Wolf, they're all out here the first week, Judge. What are they talking about? And there are no reports. I'm telling you, there are no reports. These are our experts. I don't have any reports. When we get reports, I will make sure, and Mr. Douglas will make sure that you get those reports. How about the envelope? I walked over to Your Honor's clerk, and I said, may I get this envelope earlier? And then I asked Mr. Douglas to get it. Before I finished doing anything, it was over here. I walked over to Mr. Hodgman, and I said, let me make an offer of proof to you. I'm not going to try to open this. What I was seeking to try to do, and you'll have to make the judgment on this. I'm a trial lawyer. And this is a court's exhibit, so it's not anything I had, and I was concerned about the chain of custody. And I made the offer of proof there. What I was seeking to try and do was use this as another example of the people's rush to judgment. Now, I know they wouldn't like me to use those words, Judge, but they can't stop me from using those words. And that was another example, as I tried to demonstrate with the fingernails and with the other things that they didn't bother checking up on. When Mr. Hodgman said, well, I like to approach the bench. We approached the bench. You, at first, as you recall, I'll tell you what you did, at first felt that it was appropriate. When you inquired further as to whether they had some report, which apparently Mr. Hodgman said they didn't have, which I didn't have either, and I thought they probably had it. You said, well, if they don't have that report, Mr. Cochran, you can't do it. Well, we put it back. Never talked about it. Now, that gets blown all out of proportions, and we still don't know until his speculation. He doesn't know what's in that envelope. Let me make that clear. I don't think he knows. If he does, that's something else that they know we don't, that they claim they don't know. But we've never said what's in that envelope. Never, and we didn't yesterday at all. The jurors don't know anything about that. So, with regard to this man's physical condition, respect for him, as I've indicated. And I'm very concerned about his physical condition, and I hope that he'll get well soon, and I'm very concerned about it. I've discussed that with our client. But talk about sanctions. When have you ever seen a case, Judge, where, first of all, they get up and make an unfettered opening statement to our jury because we wanted to be professional? We didn't object to the very end. It became absolutely necessary. Because of events beyond our control, I couldn't start that day. We had to leave. The jurors got to go home that night. We came back the next day, and I got my chance to make the opening statement, in which the things that I said, I expect to prove. Things that I know from my client, I don't think that they can change that or talk about leveling the playing field. Because apparently they felt the job that I did made them nervous and upset the next day. We saw these histrionics. And so they now want you to carve out some new law. They have no cases that cite this, and you have a lot of discretion, Judge. They want to carve out some new thing to give them like another opening so they can get back up and talk. Well, then do I get a chance to respond to that? I mean, that doesn't make any sense. Everything that we did, we've done in good faith. We want to try this case as much as they did. In fact, you recall I've said for the last 10 days, let's stop all this posturing. Let's get this case on the way. The final thing I want to say is this, that it's rarely productive of good to malign citizens. As you know, I'm a big fighter for jurors and for witnesses. And for Mr. Darden to stand here and say that Christian Reinhardt, was dumped by Faye Resnick is perhaps the greatest bit of hyperbole I've ever heard. That is so far from the truth. It strains credulity. It didn't happen. He put her out because she was using drugs. And after she used drugs so badly, in that 5 or 6 day period, he was the one who helped put her in a drug treatment place, Judge.
Mr. Cochran, as interesting as that conversation about that probably is and probably will be later.
Sure.
My interest is in the people's request for sanctions. They've asked me to tell the jury that I'm striking from your comments and for them to ignore your references to these various witnesses and items that they've discussed. They've asked me to admonish them that the mention of those was not appropriate because the prosecution was entitled to know of those witness statements or the identity of those witnesses before the opening statement was made. And they're asking for a 30-day continuance. So I'd like your observations on the various sanctions that the prosecution has requested.
Let me do that. Thank you, Your Honor. And the only reason I was doing about Reichard, I just felt you have to set the record straight sometime. There's a man, he's a doctor, Judge. He's out there having these slings and arrows. We can take it, but it's not fair to these other people to go through Christopher Darden's thing. I know he loves them too, but we can take it better. Judge, with regard to the 30 days, I think, again, Your Honor, it's almost like they're kidding about 30 days. Your Honor, they haven't even called their first witness. You know, you're very optimistic, and so am I generally. I'd like to think the defense is going to start within 2 months, probably more like 3 months. Judge, by that time, they'll have time to investigate everything. They've got the LAPD, they've got the DA's office, they've got everything. Look at all this information they supposedly got on Marianne Gersh's, supposedly, which apparently isn't true, but they can have all the time they want to investigate. And as Mr. Douglas says, we're not trying to play any games, and to show that, they can have as much time as they want. I don't mind if we're going to call her as a witness, calling her at whatever time you set. I mean, we would play by the rules. I don't have any problem. We made a mistake with regard to her. With regard to the other witnesses, Judge, I don't think they can show there were any mistakes. I think that they knew about Carrie Mullis. They knew, I mean, they say to me that I say that he has this man suffers from rheumatoid arthritis. Those are the facts, and I'll be able to prove that. What do we strike based upon that? They don't like the truth, and they want to try to change it around. to talking about a level playing field. So as I listened to it, I didn't see, and I try to go through the list of witnesses. I mentioned Ron Fishman, and they know about Ron Fishman. We hadn't turned that report over. With Chris Reichart, they know about Chris Reichart, Judge, because they've interviewed him. They've interviewed him. We don't have a report, I don't think, from Christian Reichart. We don't have a report. And we don't have a report from Fishman, so we have nothing to turn over. They know about Lenore Walker, Judge. In fact, let me respond to that on Lenore Walker. With regard to Lenore Walker, we got a special order. She went to the jail over 2 weekends. She has not finished her examination, as I indicated to the jurors. We don't have a report from her, and we don't have one for either from Geraldine Butch Staley either, who's her associate, because they were due to go to the jail last weekend to finish the reports. They haven't finished them, or they finished the testing. So again, that's not anything. We tried to give them the CV. We've done what we could on that. With regard to Michelle Abduran, they know about Michelle Abduran. Joe Stellini, there's no report. So Judge, the sanctions they're asking are far out of line with what should take place. I think we're in a similar position than what they were. What I'm trying to indicate to you that we've not done anything intentionally. We would not do that. We're just trying to get what we know we can prove before this jury at the earliest possible time. It's the first time we had to do that. And so I would ask the court not to try to come back and then gut my opening statement by trying to pick out things that we said if it's the same situation. If we don't prove those things, the problem comes with that. Where does it say that because in an opening statement I make a statement believing that they have Marianne Gertis' testimony and they don't have it, when they should have, because of the statement of itself, in that statement, if you look at it, has the DA's phone number. Marianne Gertis says she has the DA's phone number from Patty Fairbanks, who puts her on hold, and she tells about calling all these police departments. So and this is an investigator I have never met with, and I received that report within the last couple of days before the argument. So I think that if you look at it, what I think you should do is put us in the same position that you put the prosecution in when they were faced with the same situation in December. I mean, what's fair for them is fair for us. We wouldn't ask any more or any less. It doesn't go to my opening statement. Just much of what you have seen over the last couple of days, make no mistake about it, is to try to keep me from getting back up before that jury. There is an ultimate sanction today. Now, I believe that Bill Hodgman is sick, but everything that's happened, when Mr. Darden kept talking and saying the same thing 6 or 7 times, I thought he was filibustering, and obviously it was so I couldn't talk to this jury today. But ultimately, Judge, no matter what they do, I get to finish talking to this jury. That's not a sanction they can impose. I get to get back up there. They're not going to like that. And so that's what this is about. And so I'd ask you to be fair in that, and be fair like I thought you were imposing to them. If we slipped up, I'm telling you it was not intentional. We would not do that. And if we slipped up, the same sanctions they got in December should pertain to us. And if that happens, it has nothing to do with the opening statement. I haven't misled anybody. If Christian Reichart...
Well, the problem is I can't really impose the same sanction at this point because part of the sanction was I told them they could not use certain witnesses in their case in chief until they had completed their original witness list, and they could not mention it in opening statement, which as far as Mr. Darden is concerned, I essentially took the heart out of his domestic violence argument because he was not able to mention 3 or 4 other incidents that fill in certain time gaps. I assume that's the argument he's about to jump up and make.
Well, when you say take the heart out of it,
Well, that's his argument.
Okay, well, yes,
I'm asking you to respond
yes,
to that.
well, I will. I think that, Your Honor, with regard
So
to
I
that...
can't give you, or I can't impose upon you the same sanction.
Well, you can give... I think the thrust of it, though, Judge, isn't it that they would have an opportunity to try and check these things out? I mean, I think, for instance, Christian Reichart, they already know about him. We don't have a report, so that's maybe a bad example. They know about him, they already have a report, and maybe that's a bad example. I mean, the only one that I can really fix on, because they know about Ron Fishman, is Marianne Gertis. And I'm just saying to Your Honor that in 24 hours, they've done all this work, supposedly on the rest of the people, Judge, they knew about, and we don't have any reports on them. So I don't know where we go from there to saying, admonishing this jury regarding this. You admonished them, even after I didn't get a chance to talk to them for a whole evening. When they came in yesterday, you start off by saying, what counsel says is not evidence. And that's exactly what it is. It's not evidence. So, you know, we're going to have evidence. The case will ultimately be, why are they so afraid? The case will ultimately be decided. We want to uphold all the rules like everyone else. But why are they so worried about that, Judge? Ultimately, It's going to be the evidence that this case is decided upon. And that's all that I wanted us to get back to. The rest of these witnesses, and some of them, is that they knew about them. We don't have any reports, with the exception of Mary Ann Gertz, that I can see as I look at the list. And I think that the sanctions are way out of line with where we are. And having understood what your sanctions were back then, we have to deal with where we are at this point. With regard to Mary Ann Gertz, this is a witness who gave a statement. I don't know her. I have a statement from her. The investigators talked to her. And that's how it came to me. I assume they had it, and I wasn't aware they didn't. And again, I apologize for that. But I don't think that's any reason that Mr. Simpson should have to suffer, where these jurors would have to be told, oh, gee, it's not evidence, but just disregard that. It's not evidence. And, you know, and Judge, if we do it based upon that, I could come back tomorrow and say to you, Judge, I want to look at the transcript. For all the times Ms. Clark was argumentative that I didn't object because as an officer of this court and a gentleman, I didn't want to do that. That's like running back, doing something like that. I don't want to do that. I want to get this trial on. I want to finish my opening statement so they can call their first witnesses. And so what I'm going to ask you to do is to fashion something that's reasonable. You're wise, and in these situations, it calls for a wise decision. Well, we have done something in good faith, and I will conclude by saying this, Judge. We certainly don't refer to ourselves as a dream team. Just a collection of lawyers who try and do the best we can for our client. And that's all we're doing. And others can refer, Mr. Darden can refer to us derisively or any way he wants to. But we're just trying to do our job. And in that, Judge, we're trying to represent our client to the best of our ability. I think you know, we would never intentionally mislead this court. We would not do that. I would not do that. I know that my reputation means far too much to me, and this case is not the last case of my career. And so we don't have the obsession that some seem to have about this case. We want to try this case, and we think we're going to win this case. But we're not out here trying to win this case at all costs. We're trying to do it methodically and do the job that we're paid to do. And that's what we expect to do, ethically and morally, Your Honor. And all I ask you to do is to allow us, remember that part of the sanctions have already been the delays, the internal delays in my opening statement getting back to that jury. Allow me to get back to that jury without any real unnecessary delay. If the court felt that there was some problem with regard to Bill Hodgman, obviously we want to listen to that. I mean, that's something that I am sensitive to, and I've talked to Mr. Simpson about that. Although he wants to proceed as fast as he can. I'm sensitive to that. But with regard to these other things, Judge, when you look at when it's reduced down, you know, things that I knew because my client told me, I have an obligation to that. And I hope I put the envelope and the other things in perspective. So I'd answer any other questions that Your Honor has for me at this point.
Well, you're objecting to the 30-day continuance that Mr. Darden has suggested.
Yes, Your Honor, I think that is far, far too long. What are we going to do for 30 days? Judge, we have a jury that's being sequestered. They've wasted another whole day today. I don't have to tell you that, but those are the facts.
All right. Thank you, counsel. All right, Ms. Clark, briefly, please. And let me ask you a couple of questions before we launch into this. Do you concede that Dr. Mullis was on the DNA list for the defense for the DNA?
Yes, I do. He was on the Kelly Fry list. And
Yep.
his deletion in the trial list led us to believe that he was not going to be called at trial. And that is the problem that is posed, is that we were just beginning to prepare for the Kelly Fry, and then matters were transpiring at a rapid pace. We ceased preparation when it appeared that there was not going to be a Kelly Fry hearing. And that is the problem with him, but it's not nearly as egregious as the others, because we did have some notice of his existence for the defense. Let me indicate to the court that with respect to the 30 days, I believe it was the defense who indicated, and at the court's request prior to this, when they wanted time to investigate witnesses that they claimed they were given late notice of, although they got them far in advance of the last hour of opening statement, they asked for 6 weeks. They thought that was a reasonable time for investigation, as did the court. We're asking for less, even though we would be, under a parity of reasoning, entitled to the same amount of time for reasonable investigation. We are not obsessed with this case, Your Honor, but I wonder about the defense obsession, because their desperate tactics in throwing ethics out the window and behaving as they have is evidence of clearly the opposite of wanting the fairness and justice that we're entitled to in this case. There should be no mistake about it. This conduct should not be minimized this way. Mr. Cochran's very persuasive, very talented, very charismatic, but I'm sorry, Your Honor, in this case, he is wrong. He has done wrong. This is not the way to behave. This is not ethical conduct or behavior. And as I told the court, he glibly stands up to say, well, the people can address it all in closing argument. No, no. See, it's too late. Because by then, Your Honor, there will have been months of time for whatever that jury has picked up that will never be addressed in trial, those witnesses that Mr. Cochran referred to that may never be called out of some kind of fear that he's thinking of, or witnesses that never appear at all, that after they've been represented in front of this jury, they will have that witness in the back of their mind, and that may be enough to persuade the one. Any kind of relief that the court grants us at this point may still not be enough, because the damage may be indelible at this point, after him having mentioned all these people that he himself knows is in danger of not ultimately being called, because once they're investigated, it's determined they have records, they have felony records. These are people that really will not withstand the scrutiny. They know it. The defense knows it. And the willfulness of their tactics in delaying the discovery is shown by virtue of one simple fact. Early on in these proceedings, the defense floated up the name of Frank Chuchulo from Happy Camp. This was a man who came forward to say that he saw burglars, 2 white burglars, leaving the home of Nicole Brown. It was then discovered that he'd come forward to offer false information on other famous cases, and his credibility was exploded as it deserved to be. And the defense realized that then they're going to have to hide their witnesses to prevent the exposure that would show them to be as incredible as they are. And that's what they've done in this case. So it's a very willful thing, and it's not a minor thing. This is a major form of misconduct that has occurred, and I don't want Mr. Cochran to minimize it this way. It is major. And if we look at, let me just contrast it for a moment, because I know what the court is going to say. Okay? Their statements were taken 4 or 5. I saw it.
How am I going to rule?
No. What? I'm sorry.
Never mind.
The counsel wants to compare the gravity of their misconduct to what occurred with the people, and let me contrast the two. The statements turned over by the people were 2 and 3 weeks late. The statements turned over by the defense were 4, 5, and even 7 months late. We were sanctioned for that for just 2 or 3 weeks, and now they're fighting the sanction for 4, 5, and even 7 months for material witnesses. Obviously, witnesses they think are very important because Mr. Cochran is outlining their testimony to the jury. And when you also look at it in this context, Your Honor, out of the tens of thousands of pages that we've turned over, dozens of videotapes, dozens of audio tapes, we were slow to turn over by that I mean 2 to 3 weeks, a few pages of discovery compared to what they did. We had 70 pages of discovery, Your Honor, until the last 2 or 3 days. Now they have doubled the amount of discovery in the last 2 or 3 days. What that shows this court is not only that the gravity is very severe, that the misconduct is very serious, but that it is not inadvertent and cannot be claimed to be. You don't overlook over half your case. And that's what they claim to be doing. I don't believe it. I don't believe it. Mr. Cochran is an excellent lawyer. He knows what he intends to use. He knew what he intended to tell this jury. His statement was typed and it was prepared. And he cannot come before this court and tell us that he didn't know about these witnesses before or was unaware of their statements. And the fact that Mr. Jones Mr. Douglas can stand up before this court and say and try to excuse the misconduct by saying, well, this wasn't always the law. It makes it even more egregious because what he's indicating is a desire to thwart the law, a desire based on his own belief about what he should be able to do as defense counsel. Unfortunately, the voters of this state have spoken. They have said, we will not countenance any more of this hide-the-ball stuff, this shell game in the course of a criminal trial. We want it to be a real search for the truth. We want both sides to air their witnesses so that everybody can have full and complete investigation. And that is the problem with what defense counsel has done. They are trying to prevent us from doing our job. I want Mr. Cochran to get up and speak to this jury as long as he wants to. I don't want to stop him from talking. I want this opening statement to get going and to get completed. I want him to be able to put on every witness he desires. All I ask is the ability for the people to investigate these witnesses so that the jury gets the whole truth, so that we have an opportunity to show the jury who these people really are. And when these people are hidden from our investigators, we cannot let the jury does not get the true picture of who they really are. I would not be doing my job if defense counsel were permitted to trot a parade of witnesses up to that witness stand and I were to sit back and say, "What's your name? What time is it today? Thank you very much." I should be fired for that. It's our job to search for the truth, and it's our job to show this jury the real credibility of who these people are, what these witnesses really is. And if this jury doesn't get to see that, they're deprived of the truth. And if they're deprived of the truth, the people of this state are deprived of justice, and I cannot allow that. That is not my job. My job as a representative of the people is to see that that does not happen, that any witness who is called is given thorough and complete examination, and what they are attempting to do here is prevent that. Mary Ann Gerches now claims that she called our office. This is not a woman whose credibility is unsullied. And the fact, and if she did call the office, which counsel knows because counsel had the same problem, we've all gotten thousands of calls from every Tom, Dick, and Harry that wants to get involved in this case. If the person doesn't pursue it, sometimes they don't get reached again. But I think it's very interesting that they say that. What, are we supposed to now say that the lawyers can rely on the witnesses to give discovery? Is that what he's saying? She's supposed to give her discovery to us? I mean, somehow he's putting the obligation on her to come forward. No. The obligation is not on the witnesses to turn their statements in. The obligation is not on the DA's office to go begging for the defense witnesses to come and talk to us. The obligation is for the defense to give us what they've got, the same as it is for us to give them what we've got, and we have done so diligently at every bend and turn. We have not attempted to avoid it in any way. Now, I think that what the court should know is that Mr. Douglas's position vis-a-vis the law, vis-a-vis his requirements in terms of turning over discovery, taking reports, and reducing statements to writing is wrong, 100% wrong. It's so wrong that previous courts have found that conduct to be contemptuous. I cite the court to the case of In Re Serra, S-E-R-R-A, 484, Fed 2nd, 947. The court held that a defense attorney should be held in contempt for asking an expert to refrain from writing a report in order to avoid discovery. Also cite the court to Standeffer versus Superior Court, 18 Cal. 4th, 672. It cautioned again the attorney not to direct an expert to avoid writing a report in order to avoid discovery. Counsel has deliberately done an end run around the discovery laws, basically by trying to get their discovery from the mouth of their client. Here, Mr. Simpson, go call Ron Fishman, tell us what he'll say. And then they go and ask Mr. Simpson. I mean, that's a very clever game, but it certainly does not serve the ends of justice, and it does not comport with the spirit and the letter of the law under 1054. We love the fact that they have Henry Lee for an expert. But if he's such a great expert, he's so well renowned, and I understand he is, how could he not have written a report with respect to all of the work that counsel has told us he's performed in this case and will testify to here? No report. He's been on the case since day one. We're all aware of that. And to tell us now that he has no report to offer us, that Dr. Bowden has no report to offer us, that Sylvia Wolf has no report to offer us, this is unbelievable. You know, this conduct cannot be minimized, should not be minimized. We have been placed in it's a very unfair position that we are placed in. I think that the goal of a trial is for the truth to emerge, and it's not for a lawyer to hold in his head information that he or she may use to ambush the case with. And that's what we have here. It's a trial by ambush. That's the strategy. The people would request, number one, that the court admonish the jury with respect to counsel's misconduct, as I've indicated earlier. Number two, if the court is not inclined to strike the comments, the offensive comments by Mr. Cochran, and let me indicate about that envelope, he waved it in front of that jury and every single one of them saw it. And we all know that after the preliminary hearing with what occurred there, everybody knows about the envelope. Everyone on the jury said so. Mr. Cochran knew what he was doing. That jury saw what he was doing, and that was a setup, as sure as I'm standing here, because he knew that he was going to surprise us with that, a surprise tactic, that we would object, and that the jury would then see the objection and maybe conclude that we were trying to hide evidence, when in fact what has happened is we've been hidden from. We don't know what's in the envelope. We haven't seen the reports. Counsel knows better than we do. They know what they're waving around. We don't even know. All we're asking is let us know. We want to know. We want to know what their witnesses have to say. We want to know what the evidence is. Is that asking so much? Under 1054, it's not asking anything that we're not entitled to. That's all we ask for. And under 1054, there are a certain number of sanctions that are allowed under the law, and Mr. Cochran is aware of that. And if the court is not inclined to strike the offensive comments, then the people would request that we be allowed to reopen to address those matters, but that's in conjunction with the admonition, and that after the conclusion of opening statement, that we be permitted a continuance in order to investigate all of these witnesses that were just recently thrown at us at the conclusion of Mr. Cochran's opening statement remarks yesterday. I think it's only the alternatives that I oppose to the court, I think, are the only way that the people can be made whole. We are not being hysterical here. We are simply asking for an opportunity to do our job. That's all we're asking.
How would I justify granting you a 30-day continuance if we all agree the people's case in chief is probably going to take between 2 and 3 months to present? Doesn't that give you adequate time to go out and prepare to rebut or to impeach these witnesses, these 12 or 14 witnesses who've just been disclosed?
While we're tied up in trial, we can't get involved in the investigation. That's the same game that's been played throughout this case. We're tied up in court with days and days of jury selection. We have to be out there too. We can't just send people out to do things for us without guidance. Yes. I don't think that the people's case is going to take 2 or 3 months. Not even close.
Promise?
Yeah, I mean, I'd like to, but I really don't think it's going to take that long, Your Honor, seriously. I think that the people's case might well be wrapped up in 4 to 6 weeks.
All right, do you have any other comment?
If the court would like, I think I have other case authority concerning the ability of the court to grant us the reopening of the statement.
Well, that's kind of an esoteric question. I think there are two other cases that I've been able to find in Lexis, but in other states.
I have a California case.
All right. Let me ask you another question. That's really an esoteric issue about reopening. What kind?
This case is right on point.
Well, as after an abuse of discovery, it's right on point. Reopening.
It's not to address abuse of discovery. It's to address something else. But it does indicate that it would have been reversible error to deny the ability to reopen the opening statement.
Ooh. The thing a trial court never wants to hear about. All right, Ms. Clark, let me ask you this, though. What kind of admonition would be appropriate here?
I think I indicated earlier what
No,
my
I'm talking
request was.
specifics, words.
Didn't I?
Just to pick out each one of these individual things and tell them disregard these comments? To say during the course of the opening statement by the defense counsel, this witness was listed, this person was mentioned, this person, disregard all that? Is that what you're asking me to do?
There would have to be,
And then say the reason for this is because we have rules of discovery, that is disclosure of witnesses, because they weren't disclosed in the surprise to the prosecution, they don't get to talk about it in their opening statement. And that's the reason for the delay. Is that what you're asking me to do?
I would like, may I have a moment, Your Honor? We have to,
Well, I
We
mean,
haven't
you're asking me to do things.
Right.
I want to know specifics. What are you asking me to do?
if the court would like me to actually frame the language of the admonition, I would be happy to do that. If the court could give us, well, it's kind of late already.
All right, well, before you answer that question, let me ask you the question that's more pressing on my mind, is what is the condition of Mr. Hodgman this afternoon?
We don't have final word, and we will not have final word as to when he's going to be available to come back. We won't have that today.
Do we have any idea when he's going to be released? I saw Colleen Williams reporting a press conference down at the hospital.
Yeah, I believe the doctors held a press conference, but I have no idea. What the people would request is that the jury be admonished as follows: that defense counsel has committed serious acts of misconduct, that they are to view very carefully the opening statements, they are not evidence, and that to the extent that they fail to fulfill the promises made in an opening statement, any statements made should be disregarded because they do not constitute evidence.
Then
They should be-
that invites them to speculate that the whole thing is bad.
That what whole thing was...
Don't I have to be more specific than that? Because certainly not all of Mr. Cochran's opening statement is in dispute, or the propriety of it.
Well, Your Honor, we're going to have to take a break so I can frame then something more specific. I can't at this time, but they do need to be admonished concerning counsel's misconduct. They need to be admonished to disregard counsel's statement concerning the witnesses who will not appear out of fear. That was a totally inappropriate comment, very improper, and the jury very prejudicial. The jurors should be admonished to totally disregard that. There's no evidence to that effect. And then we should ask counsel at this time.
Mr. Cochran, I'm aware of your 1335 request, so.
We're
That's fine.
entitled. We can litigate that later.
As soon as I receive a motion and application.
We also would request that the defense sit down with Mr. Cochran and review the balance of his opening statement to determine if there are any more witnesses he intends to mention that they've somehow magically forgotten to give us discovery of. We would also request that the court order them to reduce to writing all of these reports they carry around in their head with respect to the witnesses that are civilian as well as the experts who they intend to call. And we have no problem with the resumption of opening statement, provided it begins with the court's admonition to them.
Do you want Mr. Hodgman to be here?
I would definitely prefer that Mr. Hodgman be here, Your Honor. And I'm going to have to find out how long it's going to be. I don't know.
All right.
I feel like it's unfair of me to make a request to wait for his return if I don't know what that is, and so I'm going to have to ask leave of the court to get further information before I make any request along those lines, either way. I mean, if he doesn't come back for 2 weeks, is that fair? That's not fair to defense, and so I should really find out how long we're talking about before I ask for anything.
Mr. Cochran, you have a plaintive look on your face.
Yes, it's not like that plaintiff will, but it seems like the press is being, like the plaintiff will. The press is being told about Mr. Hodgman's condition through press conferences and things, and why don't they take a break, and then they can call and find out?
Because the press isn't being told when he's going to be released.
I think they should make an effort to try to find out.
Well, we
All right.
will.
All right, well, why don't you take 5 minutes? My court reporter tells me she's out of papers, so let's take 5 minutes. Why don't you make a phone call upstairs? And this is not a recess, so everybody stay in place.
I have asked to be beeped as soon as they find out. So
We don't turn on beepers in the courtroom, do we?
But my beeper isn't with me, so it's okay. My beeper's upstairs. They're going to call me. So I'm supposed to get a call the minute they find out.
All right, Ms. Robertson, what information did you receive from the ever-present Ms. Fairbanks? Mrs. Robertson, you'll need to speak up.
She indicated that he was healthy and doctors anticipated he would be released sometime next week, that if he made his wife requesting that he have an additional time off period. Basically, that was Fairbanks related.
So he's going to remain in the hospital till next week?
Basically, that's what he said. Didn't give me a
See, I had asked that as soon as we had knowledge that we'd be called, and they did. Thank you, guys. So that's all we know right now is that he'll be back sometime next week, at least released, but we don't know when he'll come back yet. That might be.
All right, in in light of that,
Uh-huh.
Madam Reporter, have you changed your paper? Yes, sir. All right. Ms. Clark.
First of all, Ms. Fairbanks asked me to inform you that the ever-present Ms. Fairbanks is here. She's gotten word from the press conference that they will not state exactly when Mr. Hodgman is going to be released. The doctors would not give a definite date. And as for his return, it's uncertain as to whether it will be the beginning part of next week or the end of next week.
All right, in light of Mr. Hodgman's absence, when will you be prepared to go forward in his absence? Can you be prepared tomorrow to go forward?
With opening statements or with evidence? Opening
The
statements.
whole enchilada. I assume Mr. Cochran he indicated he had one other segment of the case that he wanted to talk about. And I assume, although that'll be a rather large part, I assume it's not the whole day. So I would assume that he would conclude his opening statement in the morning and that we would proceed to witnesses in the afternoon, assuming we started at a normal hour.
I mean, the court has not indicated any ruling so far on the people's request for a continuance to deal with the discovery that was just dumped on us over the past couple of days.
I'm asking you, when will you be able to do that? I'm mindful of Mr. Hodgman's absence. I'm mindful of the fact that he is a critical member of the prosecution team. I frankly will need time to go through my notes, prepare the record, because we were talking about, as I indicated, my recollection is we talked about 26 specific items of discovery and/or witnesses, so this is not something I feel comfortable ruling from the bench upon. So I probably will not be prepared to rule upon your request and for sanctions until probably late tomorrow is my problem. And I don't know that I want to drag the jury down to sit around and wait all day again. I don't know the answer to your question.
What we could do is there's a possibility that Mr. Hodgman will return on Monday. If, for the purpose of having him present for opening statement, we could do that on Monday. But then, what I thought we could do is sever the issues of the opening statement being completed and then the
Well-
request for continuance.
You've dumped a rather large number of things in my lap. It also is going to require me to go back through and read Mr. Cochran's opening statement again to go through the record to see what's mentioned and where. So this is not something I'm going to be able to accomplish between now and 5 o'clock.
No. And, Your Honor, this is from the defense. This is not from the people. But,
Your request, though.
well, it is our request,
All right.
necessitated by. Anyway, why not start at if we could have it go over to Monday for the purpose of completing opening statements. And at the conclusion of opening statements, would that give the court time to rule on the people's requests? And that way we would know where we stand.
All right. Let me just ask Mr. Cochran one question. All right, I'm contemplating going over to Monday. That'll give me time to review this, make my ruling, and we can find out definitively when Mr. Hodgman will be back. My inclination, though, is to direct the people to be ready to proceed if I rule that certain sanctions are appropriate, but that we're going to conclude the opening statements, that you be ready to proceed immediately, Mr. Cochran. And assuming that we proceed on Monday, that the prosecution also be ready to call witnesses Monday afternoon.
I'll be ready. I'm ready now, Your Honor.
I understand that. I'm ready, too.
No, that'll be fine. I'm ready, and make no mistake, it's the people's motion, not ours, and we don't agree with it. The one thing I'd like to say, Your Honor, however, with
Well, the
regard-
situation is, the creation of the situation, though, I think rests on this side of the table, as Mr. Douglas conceded that these statements should have been disclosed, so.
That's right. We've said that, we just said that it was inadvertent. The point is, Your Honor.
No, and I compliment Mr. Douglas for being upfront, saying we should have done this.
That's the kind of lawyer that he is, Your Honor, and we'd like to see that on
But
the
it's
other
the
side.
creation of the problem.
Your Honor, what I'd like to say is this, though. I would like to suggest to the court that I'd rather not have Marcia Clark drafting. I'd like for you to
No,
have that. I'd like
counsel.
to have that additional time. I'd rather not have her drafting anything that relates to us.
What I'm going to suggest is both sides submit by 10 o'clock tomorrow morning any admonition to the jury they feel is appropriate.
All right, thank you. I think that's fair.
All right. We'll-
Thank you.
All right,
That's
we'll
fair.
stand in
We'll be
recess.
ready on Monday.
9 a.m. Monday. Be prepared to go. Thank you, counsel. 10 a.m. All right, counsel, you've each received a photocopy of the court's ruling regarding requests for discovery sanctions. My apologies to counsel for the court's failure to fax you a copy earlier than today. I experienced a complete breakdown of my fax program. At home, I attempted to fax this to all parties yesterday and was apparently obviously not able to do so. If the parties wish, I'll give them leave to review the ruling, and I would, court's ruling asks for input from both parties regarding opening statements and the jury instruction.
Yes, I've read it. I've read it.
All right. Ms. Clark?
We'd like the opportunity to review it more carefully, Your Honor. There are a number of items that I'd like to take up with the court and have an opportunity to confer with co-counsel concerning the court's ruling.
All right. How much time do you think you need?
I would like at least until 1:30 to address these matters.
Well, Ms. Clark, let me tell you what I think the two issues are that we need to resolve this morning. You've seen the court's ruling and the court's proposed jury instruction to the jury to disregard opening statement comments regarding the witnesses that are listed on page 4. This is significantly different than the instruction that you requested. You requested an instruction directing the jury to disregard the comments of counsel. I think that is overbroad. And I think the only remedy is to mention or to ask the jury to disregard defense counsel's reference to these particular witnesses, or if there are any others you feel that have been mentioned in the record that whose mention was inappropriate.
I don't think we should have that for now.
All right. Do you agree with the list that the court has taken from the record?
That's the only, with respect to this area, I was reviewing the transcript last night, and I thought that there were more references to other witnesses.
Well, that's why I asked for a draft I asked both sides for a proposed instruction because I was seeking particularity with regards to the court's instruction to the jury. This is the list that I have here on page 4 as a result of my going through the record line by line, noting where these persons had been mentioned and then comparing with the witness lists that had previously been disclosed. Oh, certainly, Mr. Kirk, sure.
There are certain notable witnesses who are not mentioned that we specifically delineated to the court when we were last in session. Expert witnesses promised by the defense, although not by name, who have never even been disclosed by name to the prosecution, such as an expert in tire tracks, an expert in shoe prints, an expert on finger cuts, an expert on rheumatoid arthritis. None of these have even been named to us. And then again, the statements made by counsel concerning alleged conclusions drawn by experts Dr. Bodden and Dr. Lee. We have no reports. We have no idea what counsel intends to present in the way of their testimony, having had no discovery. So there are many more that I would add to this list, and that the court is aware were not disclosed to the prosecution in any way, shape, or form.
All right, well, you'll notice that the court's order includes those specific persons, and I make reference to the transcript where certain expert testimony is mentioned, and it includes the ones that you've just listed now. And I think that the requirement at this point is that they be disclosed, since obviously there has been indicated an intention to call those persons as witnesses.
Where does the court indicate to the jury that those experts have been?
No, we're not there yet. Flip back to page 2, where we start with the section on expert witnesses. All right, first full paragraph after the quotation from the code section. There's an order from the court directing disclosure of these persons, reports, et cetera, and in addition, other experts mentioned by defense counsel at these particular places in the transcript, which include the ones that you've just mentioned.
Is this part of what the court proposes to say to the jury?
No, because I think what I need to do is first determine who these people are, because they may be persons already disclosed to you. But I'm concerned, my concern here is also the reports.
The people were not mentioned by name to the jury in opening statement. Those witnesses, the people are not aware of who these experts might be, even
But
by
Ms.
name.
Clark, if you read the first sentence, it says the defense is therefore ordered to immediately disclose, blah, 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 and the identities of these persons.
I'm aware of that, Your Honor, and all
All
I'm
right,
saying
so I
is
assume that that's going to happen today. Now, after you've had the opportunity to find out who those people are, then you can make your judgment as to whether or not they should be included in the court's instruction to the jury.
Then I'm unable at this time to indicate to the court what the people's position with respect to this ruling, because there's information we still don't have.
Well, it's a ruling. After you've had the opportunity to look that over, I'm going to proceed today. My inclination is to instruct the jury, as I've indicated today, and to move on with the case. And if it comes to light that there's something else, I can always re-instruct the jury as to other particulars.
But there's already an indication there are other witnesses who have not been disclosed to us by virtue of counsel's opening statement concerning those experts.
We don't know that yet.
I'm
I have the
telling you.
suspicion that the tire track person is probably Dr. Lee.
Well, a suspicion is certainly nothing that we can call
So
discovery.
there's suspicion, it's Dr. Henry.
Well, thank you very much. I finally hear this today, this morning, that people are entitled to discovery, Your Honor, not an assumption and not a suspicion.
We've given Dr.
We haven't
Henry.
been
Hold on.
told anything,
Hold
we
on.
haven't seen a report.
All right, I agree. And Ms. Clark, that's why I've ordered its immediate disclosure, which means today.
And I appreciate that, Your Honor, I really do. But I'm asking for the court to inform the jury that we were not informed of any of that either. That should have been disclosed to us as well, not just these witnesses, but the experts and what they were going to testify to. Why do we find out only in opening statement that Mr. Cochran intends to call these expert witnesses to testify to various things of which we had no knowledge? The code requires them to do so. Those experts that he mentioned in his opening statement, of which we had no discovery, and only now, based on the court's stated suspicion, do we hear that that's who is going to testify to what he represented to the jury. for the first time ever when we heard it, that's a blatant violation as well. We were entitled to know about that.
Hold on.
just as
Mr. Cochran, you'll have the opportunity to respond.
we were entitled to know about those witnesses, just as we were entitled to know about the witnesses listed by the court in this order. That's why I'm asking for the court to include them in the order. Why would they be any different?
All right, let me ask you another question. What is your position on your request to reopen at this time?
The people strenuously urge the court to allow us to reopen. I will cite to the court the civil case that I brought down to court the other day. Unless the court already has it through Lexis, but it does authorize the reopening of opening statement. I'd like for the court to see that. And we would like to reopen. The court has requested a proffer as to what we would address in the opening
Yes.
statement, and we will, until Mr. Cochran completes the opening statement, we're not going to know the entirety of it, because although it's been represented to us we have full and complete discovery, we obviously do not. And I know that other surprises are going to be forthcoming from Mr. Cochran, so I can't give a complete proffer as to what we would state at this time.
Well, as to the individuals who are listed in the court's proposed instruction, as to those listed individuals, what is your proffer?
Well, we don't have a statement yet from Michelle. We don't have a statement from Mark Partridge. We don't have a statement from Howard Weitzman. We don't have a statement from Skip Taft. We don't have a statement from Christian Reichardt. We still don't have discovery of that. And in order to know exactly what I'm going to say in response, I need to have a statement.
My recollection is that is a list of people whose statements were belatedly given to you and/or... Yes, those statements were given to you, albeit at the close of business after the first day of opening statements by the defense.
No, Your Honor, we have never received a statement for Michelle. Mark Partridge, I believe there's a one-paragraph representation that he spoke to defense counsel, but no particulars as to what he said. Howard Weitzman, we had no statement. Skip Taft, no statement. Christian Reichardt, no statement. There's only one witness here for which we really have a statement, that's Marianne Gerges. And we are putting together our proffer as to her at this time. I believe that Mr. Darden will be bringing it down with him.
Well, hold on just a minute, Mr. Cochran. I just wanted to settle where we are at this point. All right, Mr. Cochran.
Yes, Your Honor.
Good morning, sir.
Good morning, Your Honor. I just got Your Honor's order this morning, a proposed order, and we've had a chance to review it. I'd like to, first of all, turn our attention to the list of witnesses that the court proposes to tell the jury about in the jury instructions, which I think is the heart of Your Honor's proposed order, obviously. With regard to Marianne Gerges, Mr. Douglas has indicated that, and our position is and will always be and absolutely is, that when I read the name Marianne Gerges, I believe that that statement had been turned over. It, in fact, hadn't, and we indicated that. With regard to Michelle Abderrahman, there is no statement. With regard to Mark Partridge, the prosecution, Your Honor, had, in fact, been given a portion of his statement. In fact, in a letter that he wrote after a memo where he's a lawyer, as the court is aware, when we returned back to Chicago, if I recall, and I'll try to find this, Mr. Partridge wrote a letter detailing his observations of Mr. Simpson and sent a copy to the prosecution and to the defense. Mr. Douglas turned over another 2 pages, I think, afterwards. They'd already been notified of Mr. Partridge and had an earlier statement, and I believe they also had his lengthy memo about what had taken place. With regard to Howard Weitzman, Skip Taft, there are no statements. These are both lawyers, and we try to explain that to the court. There are no statements. It's no subterfuge. If the court is aware of the relationship we would have with Skip Taft, a business lawyer that we talk to on a daily basis, there's no report.
Well, the problem, Mr. Cochran, is that neither of these persons appear on your witness list.
And I appreciate that, but I'm saying there is no report regarding those two. With regard to Christian Reichardt...
But the fact that they were not placed on the witness list, there's no notification to the other side that they're going to be witnesses, that's the problem.
All right, and I understand that I've indicated to the court that's through inadvertence, and I understand Your Honor's sanction on that. With regard to Christian Reichardt, they have interviewed Christian Reichardt at length. He's on the list, interviewed him at length with Dominic Rubalcava, the lawyer. There's a transcript to that effect, I believe. And we have no statement, we have no report from Christian Reichardt. So I guess what I'm asking the court with regard to Reichardt, I don't understand where the prejudice is. We have no report. They know about him. He's Faye Resnick's former fiance. You heard what Mr. Darden said. You know, and it's very interesting, Your Honor, how Mr. Darden could immediately make some statement maligning Christian Reichardt when he knows everything about him. Or, for instance, with regard to Marianne Gertjes, when they heard the name, it seems as though they'd already known about her. And the court will recall that with regard to Marianne Gertjes, this is not to obviate whatever you feel is proper. I'm prepared to go forward and argue. Marianne Gertjes had tried to contact the district attorney's office. The court should read that statement. She not only talked to Patty Fairbanks in the DA's office, she puts in the statement, if I recall, the phone number in the district attorney's office that she called.
Mr. Cochran, though, that's dancing around the issue. The issue is, was this person named as a witness by the defense?
No,
And
she
were
was
the
not.
statements in your possession turned over prior to trial? The answer to that question
She
is
was
no.
named. She was named, I believe, but the statement was not turned over, as I've indicated to the court. But
That's
I
a
wanted
violation of the discovery rule.
Okay, and I appreciate that, Your Honor, but I thought the court should have all the facts. And I think what it does, it goes to the state of mind, our state of mind. Your Honor, and I'd just like to say this again. No way in the world, why in the world would we want to withhold witnesses from them that you could possibly preclude down the road? I'm not going to do anything to damage Mr. Simpson. And the effort of this is a massive volume of work, is not an excuse. We want to get this case underway. We're not going to do anything to harm that. We want to try the case. We're the ones who've not waived time and want to get it forward. We understand we have to all abide by the rules, and we accept that. The other thing I think that the court should listen to is that this violation of, in the jury instruction, proposed jury instruction, the court proposes this was violation of the law and the cause of the 2-day delay. Well, that's not completely correct, because as you indicate later, the part of the cause of the delay was the illness of D.A. William Hodgman. So I think the court needs to modify that in some way so it more accurately reflects the facts. If that was the only cause, we perhaps could have argued on Friday or whatever. So I think that I would ask the court to consider that. With regard to the experts, we will comply wherever possible, Your Honor. We do not have reports yet, because much of the reason we don't have reports, Your Honor, is because our experts have not been able to actually examine the evidence. We're making a motion to that effect. To be able to examine this evidence in their lab, they can then make the report. We know generally from their observations what they're going to say. And for counsel to say that they didn't know about Drs. Batten and Drs. Lee, and Dr. Lee and Dr. Wolf were out here the week of June 12th, Your Honor, as the court is aware. The other thing is, as the court correctly points out, in this reopening of the opening statement, it is illogical at best, and I think it's going to be confusing at worst, to allow them to reopen to talk about Marianne Gertjes. From that standpoint, I think that if you admonish the jury to disregard it, then they get up and then talk about her. That doesn't make any sense, Your Honor. Then do I get a chance to respond to what they have to say? Your Honor, what's happened in this courtroom is they have continually maligned witnesses, and that is an intimidating effect, and that is wrong. And so while we're talking about the defense, let's talk about them. Over this weekend, every one of these witnesses who were maligned by Mr. Darden now have lawyers. Marianne Gertjes, Christian Reichardt, Ron Fishman, and Rosa Lopez.
Your Honor, I object to this. None of this
Hold on,
is
Ms.
responsive.
Clark, Ms. Clark, please.
None of this is responsive to the court's
I'm
question.
going to instruct counsel not to interrupt other counsel's statement. This court is more than patient. I allow each side to completely say what it is they want to say. I'm not going to tolerate any more interruptions by counsel from either side. That's a warning to all counsel. Next violation will be dealt with by sanctions,
Thank you.
including contempt.
May I proceed?
Please.
Thank you. Your Honor, what I was trying to say was that I think that it's totally improper to do those things because it has an effect on these witnesses, and I think it's totally unfair. Now, what the court's going to see is in the coming weeks, these lawyers will all be addressing this issue, and it has a pronounced effect when a district attorney stands up and says that and does that in open court. And I think that is germane what we're talking about and to procedures, Your Honor. So I would just like an opportunity, if the court would allow us, to respond to the people's request for this reopening. As I said, I think that's totally being improper.
Well, Mr.
proceeding.
Carpin, what I anticipate doing is after I hear the prosecution's proffer as to what it is they would go into and how it is that they would approach it, then I'll allow you to respond to that to see if it's appropriate.
Thank you, Your Honor, because I think that what we've seen so far, again, is trial in the media. What we saw in court here, to have a witness who's never been before this court, I presume branded as a certified pathological liar, Your Honor, that's outrageous. And if not, would not be done except under the aegis of some kind of qualified immunity here in court. And I think that's unfair to that witness, and obviously it had a great effect upon her. And what kind of message does that send out to other witnesses, Your Honor? Furthermore, all the things that were introduced, Your Honor, the things that were introduced would probably not even be admissible from a standpoint of attacking this lady's credibility. She has some civil lawsuits. How is that relevant as to whether or not on June 12th, 1994, at about 10:45 in the evening, she saw 4 men running from the vicinity of 875 South Bundy? That's going to be really the issue, Your Honor, isn't it?
Absolutely.
That's the issue, and it seems to me that the other things that happen should not be allowed to happen again, because I'm just saying to the court that this is having a pronounced effect, and I know that because I'm being contacted by these people.
All right. Thank you, Mr. Carter.
Thank you, Your Honor.
I should say one other thing.
At the bottom of page 1, I think it was clear as we'd indicated to the court. The other witnesses that were turned over, because the court had ordered Mr. Douglas to make that determination, and we should make it clear that he did exactly as you had asked, and make it clear also that this has not been his responsibility prior to January 2nd of 1995.
Well, I think the record speaks for itself.
All right.
Mr. Douglas did indicate that was his responsibility as of the beginning of the year.
Yes, and he took it over, and of that list, of the total list that we've heard so much about, Your Honor, and we dispute Mark Partridge because we think they did know him and had a statement from him. The only 2 people that basically mentioned in the opening statement were Marianne Gertjes and Michelle Abdram. And apparently there is no report that we have on the shelf. And I'm going to make sure. And the other thing that also comes to mind, Mr. Douglas reminds me, is Colonel recall that in one of his diatribes, Mr. Darden stood up and said, if Ron Fishman tells the truth, he'll say that O.J. Simpson made a statement about getting somebody. Now, Your Honor, we've never seen any report like that. We've never seen any such statement. And so when he makes those kind of statements, or when immediately he knows about Marianne Gertjes, in another statement he says, if you recall, if Mr. Cochran had asked me, I would have told him about this witness or these witnesses. How does he know those things, Your Honor, immediately if he didn't know about these witnesses? So I think the court, in being even-handed, which you are, would want to inquire about that.
Well, I've already sanctioned the prosecution severely for their transgressions in the discovery process, and this sanctioned proceeding process, I suspect, will continue throughout the trial.
I certainly hope not after today, Your Honor. It will not be proceeding. I hope it won't be necessary. But I understand that. But I'm saying, how would he then be in a position to give me advice about witnesses if he had known, or to have a statement from Ron Fishman if he didn't know about Ron Fishman? I don't understand that, and I don't think that makes sense. So I would ask the court to inquire about that. To conclude my point, though, of the witnesses that you'd ask Mr. Douglas to proffer before the court, we did that. As Mr. Douglas has indicated, many of these witnesses were out of an abundance of precaution, will probably never be called. But secondly, they have a right to know about it, and we've done that. But almost none of those witnesses were mentioned in the opening statement, with the exception of Gertjes and Michelle Abdurrahman, as I said, referring to the list at the bottom of page 1.
Well, you did mention Gertjes, Abdurrahman, Partridge, Weitzman, Taft, and Reichart in your opening comments.
Right. I was referring to the list at the bottom of page 1, and I did, in fact, mention the others. And as I said, there are no reports, but I did, in fact, mention them. But I think, again, Your Honor, in the spirit of the law, the prosecution, Your Honor, knows about Howard Weitzman and Skip Taft because they were down there with Mr. Simpson at the time he gave his statement. Now, we don't have a statement, and it was an oversight, and they should have been put on the list. These are 2 lawyers. Now, you know, I mean, I don't think the court's going to shoot me over that. I mean, I think that he may want to.
Don't tempt me, Mr.
I don't think you're going to shoot me over that. And Kristen Reichart, Your Honor, they know about. They've interviewed him. They know that's Faye Resnick's boyfriend. And I think that, as I said, with Mark Partridge, they had a statement on him. So I think the court has listened to us. I'd like an opportunity to respond specifically when they're ready. But I'd like to proceed, Your Honor. Let me just close by saying the court can give these proposed sanctions, and you've done that for the prosecution. I mean, I think it should be clear they were sanctioned, and you did that, and now you impose sanction upon us. We will proceed with those. I think that you should make some adjustment in that in the order regarding the delay. I think it's not fair to say it was all the defense. But we're then ready to proceed, Your Honor, and I would like to be able to proceed this morning. Keep in mind, if you want to talk about sanctions, how unfair it is to Mr. O.J. Simpson. But number one, through no fault of his, I couldn't respond immediately when the prosecutors had finished on Tuesday. Court declared a recess. On Wednesday, I was able to start responding. Then we had all these objections from the prosecution. Then Mr. Hodgman gets sick. Then Thursday and Friday, we've been off. The court says, be ready at 9 o'clock. We come in, we get the order about 8:30. We're ready. Ready again. I've been ready for about now 10 days to give this opening statement. Now the prosecutor says, gee, Judge, we need now till 1:30. I mean, at some time, I should be allowed to complete the opening statement, Judge. And I think that that also has taken the form of a sanction. And I think it's a sanction that's not only upon the defense, but directly upon Mr. Simpson. I'd ask the court to allow us to go forward this morning.
All right, thank you, Mr. Clark.
Thank you, Your Honor.
Ms. Clark. I think what I'm most interested in is hearing what your contemplation is of your proffer regarding a reopening of opening statement.
What do we contemplate?
Yeah.
We have amassed information on several of the witnesses mentioned by Mr. Cochran that allows us to understand precisely why he hid them the way he did. And we are going to prepare those remarks for the court. We've been assembling that information over the weekend, and now that we're finally in possession of the court's ruling, we will address what the court asks us to address. And we're going to have to put that together in a form that will allow me to succinctly state to the court what the points are that we intend to address with each witness. I would simply indicate that the statement taken from Marianne Gerchis most recently reflects the fact that counsel alone was in possession of her statement, that she asked counsel to turn her statement over to the prosecution, and counsel for the defense never did. She indicates very specifically that she spoke to Mr. Hostetler, whom we knew to be one of the investigators for the defense, and she told him that she wanted them to turn the statement over to us. So even the witnesses asked to do that, and the defense willfully refused to do so.
Well, Ms. Clark, you're arguing an issue and ruling that the court has already made. I've already made a finding adverse to the defense. I've granted a large number of the sanctions that you've requested. I am going to instruct the jury that a transgression of the law of discovery has occurred and has been part of the cause of the delay.
I think that
So to argue the basis for the court's ruling at this point doesn't help me a lot. What I need to know is, assuming I am willing to allow you to reopen, since this is a highly unusual remedy that you asked for, and the fact that there's only one civil case that deals with that, I've never seen a case allowing reopening after a discovery sanction has been imposed.
when has the court
And
seen
I
an
looked.
abuse, but when has the court seen a
Well,
violation this severe?
You're arguing,
Okay. Well,
I've already ruled in your favor, Ms. Clark.
Okay.
You don't
I'm-
need to tell me how severe it is.
Okay.
You don't need to tell me what the basis is. I think the ruling speaks for itself,
It does. I'm simply...
especially given the nature of the court's finding as to intent and tactical advantage,
Mhm.
which is as harsh a finding that the court can make under these circumstances. So my question to you is, if I grant your motion to reopen, what are you going to say to the jury?
And,
That's the bottom line.
all right, and I've asked leave of the court to...
And what I would anticipate you are going to say is that you're going to tell the ladies and gentlemen of our jury, had the prosecution known of these persons, we would have told you about them X, Y, and Z. And that's what we're going to prove. I think that's about the maximum parameter that I would entertain. And I stress the word entertain. All right, at this point, then, I would suggest that we proceed then with the conclusion of Mr. Cochran's opening remarks, and that after the lunch hour, you'll have the opportunity to come back and ask me to reopen, and I'll rule at that time based upon your proffer after I hear Mr. Cochran's objections. I
Let
would
me-
suggest that, so we can make good use of the court time since we have our jurors seated, ready, willing, able to go.
I would
You
like
want
to
to
address...
discuss that with Mr. Darden for a moment?
May I address the court further concerning the expert witnesses?
Certainly.
Mr. Cochran indicated just now that some of the experts have not even examined the evidence. And I find it incredible that any officer of the court could stand before a jury and represent what conclusions and findings have been made when the experts have not even conducted an examination. That assertion that they have not even examined the evidence is incredible to me. If that is the case, and he's made representations as to what their findings are, I think that there's a great deal of credibility lost with respect to those witnesses. Obviously, it's going to be a bootstrapped conclusion. Counsel, who is not an expert, can stand up and tell this jury before an examination of evidence is conducted what the result will be. I find that remarkable. And I think the jury should be informed of that fact.
Well,
I think they
Ms.
should be
Clark-
told, Your Honor.
Ms. Clark, that's an interesting point, but I don't know the full parameters of what it is we're talking about until the disclosures of expert witness lists have been accomplished as I ordered today. I can always re-instruct and re-admonish the jury at any time during the course of these proceedings. You can also bring up during the course of your closing argument that contradiction.
I'm aware of that, Your Honor, but that doesn't address the harm that's already been caused in that counsel has indicated to the jury certain experts exist who will testify to the following, and we had no knowledge and no prior discovery of any, not even their names. Only this morning, because the court indicated it had a suspicion about who that was, did we find out what that was. Now
Well,
he
it's not
tells
a
us.
suspicion, it's just a logical conclusion from what we already all know about the case.
Okay, but that does not comply with any discovery law that I'm
This is
aware
true.
of. All right. So counsel is indicating now that he's going to testify to tire tracks and to shoe prints that were found at Bundy. We have absolutely no report, no knowledge, and no information that any such testimony would be forthcoming. Those should be included in the discovery sanctions as well. With respect to Lenore Walker, I'm particularly surprised and dismayed at what counsel has represented to this court. Counsel represented to this court when last we were here that Lenore Walker was only contacted for the purpose of testifying in this matter in January, just a few days before the discovery hearings occurred. That's false. It was stated in the Los Angeles Times by Dr. Lenore Walker herself that she was retained by counsel in the summer of '94 and that she has spoken to the defendant for hours in preparation for her testimony. So the violation is even more flagrant with respect to her. At least that's according to what she said to the LA Times. So counsel is now continuing to perpetrate a fraud upon this court, is continuing to make misrepresentations concerning the nature of the witnesses that they have contacted and their involvement in the case. He is still withholding more information. There are witnesses whose names we still don't have, and obviously there are no reports. That's a flagrant violation of the law, and now it's compounded by counsel's willful assertions to the contrary of what the witnesses are telling us in terms of when they were retained. How can that be? How can that possibly be swept under the rug? The jury should be told all of this.
Tell me about the LA Times information about Lenore Walker.
That's an article in the LA Times today, I understand. Or yes, was it yesterday or today? I have it upstairs. I believe it's in the Sunday Times, Your Honor. And if the court would like, I can have it brought down.
I'd like to see it.
I will.
But before we, Mr. Cochran, you indicated a desire to address that specific issue. I'd be curious to know.
I think I read the article and what it indicated. First of all, it said, if I recall, Dr. Lenore Walker had known me since the time I was assistant DA and worked in this office, in the DA's office, that she and Geraldine Butt-Staley worked on cases that I had the battered woman syndrome as a defense in other murder cases. I think it also indicated that she was contacted, I believe, in December, but she was not retained or brought forward in this case, Your Honor, until after you ruled on the domestic discord. It didn't make any sense. We didn't need her until that point. We don't have a report. The court checks Your Honor's records when we made an application for Lenore Walker to go into the jail to see Mr. Simpson, along with Geraldine Butt-Staley, who saw him, is not even concluded, saw him as late as this past Friday. The court will know the time she went to see him. We don't have a report, and she came about. She's only relevant, Your Honor, after you ruled in the domestic discord. I've known her sometime, but she was not relevant in this case until that time. So I think that I'm more than happy. She was probably talked to. I called her the first time in the fall, but she didn't get involved in the case left the domestic discord. And I knew her since the 80s.
All right. Ms. Clark, let me ask your staff to bring down the LA Times article, although obviously that source is hearsay.
Right from the witness's mouth, Your Honor. And let me also indicate that with respect to Mary Ann Gerchis, in her statement to us, taken most recently after counsel's opening statement, she indicates that she turned over her day runner, that's a daily calendar.
I know
to
what a day
counsel.
runner is.
Okay. And that has never been turned over to us. In fact, it was never even mentioned that they had it. She indicates that she turned it over to them, and they have never turned it over.
All right, well, I can see this is going to be an ongoing procedure here. Ms. Clark, however, I think my suggestion that after the defense has had the opportunity to comply with the court's order regarding expert witnesses, we can revisit the matter again, and I can still re-instruct the jury at any time during the course of these proceedings regarding discovery violations.
The problem is that in our proffer to reopen, we would like to include those expert witnesses.
All right, well, when I hear the proffer, I'll rule on it. But my inclination this morning is to go forward with the jury, have Mr. Cochran complete his opening statements, then I'll hear your proffer, and we'll see where we are. All right?
Can we at least have the defense give us the names of the witnesses they intend to call as to the matters I described, the tire tracks, the shoe prints, the finger cut, the rheumatoid arthritis, those matters?
All right, that seems to me to be a clear intent to call those persons as witnesses, so I think their identity needs to be disclosed, or should have previously been disclosed. Mr. Cochran? I agree that her request is well taken. All right, well, we'll have to take a 20-minute break just to bring the jury down in any event, so you and Mr. Douglas can accomplish that in that 20 minutes. All right. I'm sorry? Certainly. And Mr. Darden, when do you anticipate Ms. Fishman's will be necessary?
February 9th,
All right, are you Cora Fishman? All right, good morning, Ms. Fishman. I'm going to order you to return to this courtroom on Thursday, February the 9th at 9 a.m. without further order, notice, or subpoena. Do you understand the order, ma'am?
Yes.
All right, counsel, your appearance for the record.
Yes. Andrew Rubin, I'm here representing Ms. Fishman.
Good morning, counsel. Good to see you again.
Good to see you, Your Honor.
All right, thank you, counsel.
Thank you.
One of his clients named a cat after me. All right. Ms. Clark.
Did the court indicate we want to take a recess? I would like to hear the names.
Mr. Cochran indicated he and Mr. Douglas were going to prepare a list for you in the 20 minutes that it takes to bring the jury down. All right. Let's have the jury, Deputy McNair. Thank you. Mr. Douglas, you had something you wanted to say before we start?
I would, Your Honor. Thank you very much. Your Honor, in addition to the comments and to the objections that we lodged with the court in chambers, I would like to add one more point that was just brought to our attention recently. And that is, Your Honor, our review of Section 1054.5B does not specifically authorize a judge to instruct the jury that a discovery violation by defense counsel, for example, may be considered by the jury bearing on the credibility of witnesses. And I think that there is the danger that the language of the proposed instruction by the court gives such a suggestion. Nor does case law, Your Honor, authorize such a jury instruction. Indeed, we submit that it would be completely irrational to make a connection between a lawyer's discovery obligations and the credibility of an independent witness. I think, Your Honor, that there is a danger by such a nexus triggering profound state and federal violations, both due process and of a Sixth Amendment nature, and I would urge the court to strike that connection in the court's ruling. Secondarily, Your Honor, I respect, though I respectfully disagree, with the court's finding that the violation to turn over the witness statements of Ms. Kirchhoff was intentional. I suggest that before the court can properly make such a ruling, that is, that there was an intentional violation to gain tactical advantage, that the court should most properly consider that aspect within the context of a sworn declaration, that I would like to have the opportunity to submit myself to this court so that the court could then have facts upon which the court might make such a finding if the court is ruling that a violation is being imposed and a sanction is being imposed based on the court's belief that there was an intentional violation rather than an inadvertent accident, as we contend.
All right, Mr. Douglas, I'll give you leave to file whatever affidavit you wish. However, the court's ruling will stand. The court's finding stands. Thank you. Ms. Clark, you're standing for a reason?
No, I submitted the article to the court
Yes.
of Dr. Walker. I've also been informed by several people that she was on. I've been informed by several people that she was on Good Morning America this morning, indicating that she had had some 40 hours of interviews with Mr. Simpson. In light of the fact that Mr. Simpson is in court most of the day, every day, that would preclude her physical capability of having amassed that number of hours unless she had been retained quite a long time ago. And all of this flies in the face of counsel's direct assertions to the court that she had recently been retained. It's now been exposed to be an absolute falsehood. And I think that the article as well in the LA Times makes that clear also, that she was actually contacted through Geraldine Stolley in the summer, which makes it physically possible to have amassed that number of hours. So I think that what the court has before it is further impeachment of defense counsel's most recent assertions even of having been recently retained.
Ms. Clark, I have before me a photocopy of a press release that Ms. Walker released on, Dr. Walker released January the 26th, and the ending paragraph reads as follows, quote, "As we began to examine the evidence over the past 5 months, which included some 40 hours of evaluation of O.J. Simpson himself, we realized that the potential for long-term harm to battered women was present if the facts, patterns, and significance of the battering in this case were misinterpreted, distorted, or otherwise misused by either side." So the fact that they've been examining the evidence for the past 5 months, I think, supports your position that, in fact, there was a relationship prior to just last week. However, having said that, the defense was not in a posture to know whether or not testimony by Dr. Walker would be relevant until the court ruled on the domestic violence issues, at which point the court, having allowed testimony of some incidents and having excluded testimony as to others, then clearly set the issue before the jury. So I accept Mr. Cochran's representation that he did not formally make a determination whether or not to call Dr. Walker until after the court's ruling on domestic violence. But that also causes me to believe that if there's been 5 months of preparation, that there ought to be some notes around.
Exactly, Your Honor. Not only that,
But as I indicated to you, we'll take up the issue of experts after you've had the opportunity to look at the list that was given to you in chambers this morning by counsel.
as I recall Mr. Cochran's representations to the court when last we confronted this issue, my understanding was, and I'm sure the transcript will allay any questions we have about this, will resolve those questions. I believe the representation made was that she had not been contacted until earlier that
Counsel,
week.
we'll go back and look at this again. We've argued it enough, I think. The record's clear what's there. I'll have my staff go back through the transcript and see what's there. But I think my observation as to what occurred here is probably accurate.
The court was not left with the impression by Mr. Cochran that he had just recently contacted her?
No, I'm saying I accept Mr. Cochran's explanation that a formal decision to call her as a witness was not made until after the court ruled on the domestic violence issue. I accept that as being a reasonable explanation here. All right, but the issue whether or not there ought to be some reports back there, I don't know. But it's an issue that we'll address later, as I indicated to you. Thank you.
Okay, but while you're addressing that, would you also address the fact that Dr. Walker could not get into the jail without your orders? she never saw Mr. Simpson until you did the orders.
Mr. Cochran, I'm aware of all those things as well.
And the orders were like in December and afterwards, and so you know when she saw him. She saw him during when he was not in court.
Seems to me you're ahead, Mr. Cochran, on this
I am,
one.
I just wanted, so I want you to look at that. Thank you, Your Honor.
Okay. All right, in chambers, the record should reflect that counsel did suggest to me that I include in my admonition to the jury, my instruction to the jury, some language to the effect that the failure of the defense attorneys to comply with the law of discovery is not evidence of the defendant's guilt and should not be considered as such. I think that is a good suggestion, and I will include that in the instruction to the jury because that is, in fact, the state of the law. All right, Deputy McNair, let's have the jurors, please. I made a decision. Yes, I did. I indicated I would not do that.
Your Honor, the credibility language is going to remain?
Yes. Excuse me, Mr. Cochran, Mr. Douglas, why don't you be seated until I finish re-instructing the jury. All right, counsel, be seated, please. Thank you. All right, good morning, ladies and gentlemen. Everybody seems to be smiling today. Good. All right, ladies and gentlemen of the jury, I need to advise you of certain things. First of all, one of the attorneys has fallen ill, Mr. Hodgman, and he is not with us today. However, the parties have elected to proceed in his absence. Also, I need to instruct you and to explain to you some of the reasons for the delay that we have had over the past 2 days. Ladies and gentlemen of the jury, the laws governing criminal procedure in California require that each side disclose and give to the other side the names of the persons they intend to present as witnesses and any written record or recording of the statements made by these witnesses. The law also requires the disclosure of any real or tangible evidence. These disclosures must be made before trial if the witnesses or evidence are then known. These laws exist to promote the ascertainment of truth in trials, to save court time, and to avoid the necessity for frequent interruptions and postponements. During the course of the opening statements, defense counsel mentioned witnesses who had not previously been disclosed to the prosecution or whose written statements were not given to the prosecution before trial as required by law. This was a violation of the law and one of the causes of the 2-day delay, including the absence of Mr. Hodgman. Keeping in mind that statements by the lawyers are not evidence, you are directed to disregard the comments of defense counsel during his opening statement as they pertain to the following potential witnesses: Mary Ann Gerchis, Michelle Abduram, Mark Partridge, Howard Weitzman, Skip Taft, Christian Reichard. If and when these witnesses are presented to you during this trial, you may consider the effect of this delay in disclosure, if any, upon the credibility of the witnesses involved and give to it the weight to which you feel it is entitled. Please note, however, and this is important, please note that the failure of the defendant's attorneys to comply with the law is not evidence of the defendant's guilt and should not be considered as such by you. All right, ladies and gentlemen, we will now conclude the defense opening statement. Mr. Cochran, do you wish to conclude your remarks?
Yes, I do. Thank you very kindly, Judge.
All right.
Vito, colleagues from the defense, colleagues from the prosecution. Good morning again, ladies and gentlemen. This morning, again, I'll be assisted by Mr. Carl Douglas with regard to some graphics that we have, and by Mr. Howard Harris here also with regard to the graphics. As you recall from our discussion last week, in discussing the evidence, we've talked about the coroner's office and talked about what we expect the evidence to show regarding their shortfallings. We've sought to reply to the things that have been brought up by the two prosecutors in their opening statements. And I believe that at the end of the day, we'd reached the point where I told you we were about to discuss the Los Angeles Police Department and their handling of this matter. I think the evidence will show that the Los Angeles Police Department was the main investigating agency in this particular case. The two main detectives are Detective Philip Van Adder and Detective Tom Lang. They're from the Robbery Homicide Division, and they were assigned this case in the early morning hours of June 13th, 1994. In the course of our discussion today, we will be talking about the evidence which was seized or collected at the scene of Bundy and also at Rockingham. Here we have the first graphic there. Under this scenario, we expect to be talking about the integrity of the evidence. That is, whether or not this evidence is capable of your belief, whether or not it's evidence that is correct and appropriate. How was it collected? And so, for the graphic there, all the evidence picked up at the Nicole Brown Simpson condo at the top, the evidence picked up at the Simpson home on Rockingham, the evidence from the Bronco, any blood, all went first through the LAPD there. And then ultimately from LAPD it was sent out to the various labs, be it the FBI, Cellmark, or the Department of Justice. This graphic seeks to put this in perspective. You can see the LAPD then remains a focal point in their collection of all the evidence that you're going to be required to look at. We expect the evidence will show that this evidence that was collected at these various locations that you've just seen was contaminated, compromised, and ultimately corrupted. In the course of the evidence, we expect to show that. Next. Now, briefly last week, I spoke to you about a detective named Mark Furman. Mr. Furman and his partner, Mr. Phillips, worked West Los Angeles homicide. And they are the two detectives who first were assigned to this case before robbery homicide got involved. Robbery homicide is downtown, I think the evidence will show. These two detectives worked in West Los Angeles where these crimes had occurred. And they were the first ones to arrive at the scene. Although you didn't hear about Mr. Furman in the course of the opening statement of the prosecution, we think he'll be a key witness in this case. Let me tell you why I think he'll be a key witness. I believe the evidence will show that he and his partner, Detective Phillips, arrived at that scene sometime after 2 o'clock in the morning. The evidence will show these bodies were found somewhere around 12:15 on June 13th, 1994. That after arriving at the scene, Mr. Furman did a number of things. You saw him in one of the pictures last week where he was pointing down at allegedly the glove and the cap that was under some shrubbery, if you recall. That was a picture of Mr. Furman at that point. You notice that he had his shoes were not covered, that he'd walked in that location at that point without shoes being covered, that he made a number of discoveries at that particular point, that there was a photographer at some time at that scene at the Bundy location, that this photographer was then summoned along with Phillips, his partner, and Van Adder and Lang to go over to the Rockingham address. We expect the evidence will be that presumably they were going over there to give notice to Mr. Simpson about the death of his ex-wife. and presumably that the children were in police custody at that point. Apparently the parents were not notified of either Mrs. Nicole Brown Simpson or the Goldmans at this point, but they went over to O.J. Simpson's residence. You recall also I told you last week that Detective Furman had previously had contact with the Simpsons. He had responded to the so-called 1985 incident. He didn't write a report at that time, but in 1989, he wrote a written report. In that report, he talks about the incident of the 85 incident being indelibly impressed upon his mind. So he had had contact, had been to the Rockingham location. Now, the evidence, I think, will show that he will allege that the reason why he was still leading Detective Van Atter and Lang over to the Rockingham address is because he knew where it was. But I think the evidence will also show from Detective Van Atter that he, too, had also worked in West Los Angeles, and he knew the way over there. But at any rate, I think you'll find that the evidence will show that all four of these detectives, this is prior, of course, to the coroner ever being notified, leave the Bundy crime scene, and they go over to Rockingham. Once at Rockingham, Detective Furman, of course, now by this time, the case is now in the hands of the capable individuals from downtown robbery homicide. He continues to play an integral part in this case. I think the evidence will show that he, in looking at the Bronco, now it's still, by all accounts, I think, still dark outside, but he's looking at the Bronco. It's now maybe getting close to 5 o'clock in the morning, maybe the light's about up. He discovers what he believes is a speck of blood on the door. This is Detective Furman. He discovers some more blood allegedly down toward the bottom of the door. That at some point, when these officers can't rouse anybody at the location, Detective Furman is the one who climbs over the wall to go into the premises. That once in the premises, he's the one who interrogates Mr. Cato Kalin. That he's the one who also, after talking to Mr. Kalin, goes back and finds this glove, the alleged right glove, at Rockingham. We have now for you some video relating to Detective Mark Furman, and I'd like for you to listen to what he has to say with regard to the glove. Now, in fairness to Detective Furman, the question he's been asked is about the glove, and they talk about the glove. But in his responses, you'll see, he at some point talks about seeing them at the foot of Mr. Goldman. Mr. Harris, sir?
How far would you say you were from where the bodies were located?
I was directly above the female victim, which was probably 3 feet. The male victim would have been 10 feet, 12 feet.
All right. And from that vantage point, you first observed the glove that you told us about?
Not first, no.
When did you first observe it?
We had flashlights. We were looking at the female victim. We looked at the male victim. I noticed the glove when I walked around to the... After I exited the residence the first time, I walked around to the side, or the north side, north perimeter of the 875 Bundy. There's a iron fence, and through that iron fence you can get very close to the male victim. And looking there, I could see them down at his feet.
You recall, and you heard the testimony that I could see them down at his feet. And the question we'll be seeking to establish in this trial is when he said he saw them down at the feet, was he talking about 2 gloves at that point? Now, also, this detective plays a critical role as he remains at the Rockingham location. You recall last week I mentioned that we expect to call a witness by the name of Rosa Lopez at some place in the case. Rosa Lopez lives next door to Mr. Simpson. She is a lady who's employed by the family there. She is their housekeeper. And there will, we believe, be testimony that Detective Furman had a conversation with Rosa Lopez on the early morning hours after about 7:30, 8 o'clock in the morning on June 13th, 1994. And at that time, Rosa Lopez shared with him her observations that she had been outside the night before and that the Bronco vehicle parked there at the curb at Rockingham was parked there at approximately 8:15, 8:30. It was parked at a kind of a unique angle. She had reason to remember that as she went outside to walk her dog. She will also testify that she came back outside to walk that same dog at about 10:20 p.m. She saw the Bronco parked in that same location that had not been moved. That the next morning, when Detective Furman had spoken with her, the Bronco was still parked at that same angle, as though it has not been moved all night. She will share with you what, if anything, she said to the detective that morning. You will find out whether or not he reduced any of this conversation to a report, whether or not that report was ever forwarded to anybody, whether he told any of the detectives about it. We expect that she also indicated to Detective Furman that Mr. Simpson left his residence somewhere around 9 o'clock, and there'll be testimony that he and Mr. Cato Kalin went to get the McDonald's hamburger. She was aware and heard his voice when he left, that she heard what she believed to be prowlers during this period of time and became quite frightened. We expect she'll also testify that she heard Mr. Simpson's voice at around 11 o'clock or a little after that. And when she heard his voice at 11 o'clock, it appeared as though he was leaving. And she did not hear his voice anymore that particular night. That after Mr. Simpson's voice was no longer heard, after he presumably had left the Rockingham residence, that she heard men's voices beginning at about 12 o'clock, lasting until about 3 o'clock in the morning. She was not able really to fall asleep until perhaps 4 o'clock that morning, and was awakened because I think the gardener came that morning, and she also had this conversation with Detective Furman, who came and showed his badge and then came inside of her house. So we think that, in truth and fact, Detective Mark Furman will play a very, very critical role in this case regarding his testimony. Now, let's go back, if we're going to talk about the LAPD, and let's look at the statements regarding the coroner. You'll recall last week I indicated to you that the coroner's office for some reason wasn't called initially. They arrived at the scene almost 10 hours after these bodies had been discovered. Let's look for a moment, using the Elmo with Mr. Harris at the sequence of what took place, and then for the record, I'll read certain things into the record from the transcript, Your Honor. The underlined portions I will read for the record. This purports to be, and we will establish at the time of trial, this is a conversation that took place on June 13th, 1994, at about 6:49 in the morning, just before 7 o'clock. And it's a telephonic communication between the deputy coroner, Paul Willis, and Detective Phillips of the LAPD, Phillips being Furman's partner. Detective Phillips, I got a double homicide that we want to let you know about. It's going to be, the press is going to be crawling on us like ants when they find out what's going on. Detective Phillips, this is the first call, and we got a lot of work to do yet. But we need to get you guys rolling out here so we can get these bodies, which are visible from the street, out here as soon as possible. If I can digress for just a moment, you recall that he's saying this is the first call from Phillips to the coroner's office at 6:49 for bodies that were discovered by the police at 12:15 a.m. He also says something else that I think the evidence will show is very interesting. When he says that we're going to get you rolling out here for these bodies which are visible from the street. You'll recall that when I spoke to you last week about Ellen Aronson and Dan Mandel walking past this location at 10:25, not hearing anything, not seeing anything on the sidewalk directly in front of 875. And you have seen the other photographs, what you could see from that sidewalk, and it's clear from his statement, you could see these bodies, and of course there was all the blood with the scene. Continuing on, we kind of not following procedure, but we're kind of asking a favor, and you know, kind of work a little bit on this one. So we have the detective saying at this point they're not following their own procedures, and they're asking the coroner's office to do them a favor and cooperate with them. Thank you, sir. We'll go to the next page, page 240 for the record. It's Detective Phillips again, still talking to the deputy coroner, Mr. Willis. Detective Phillips. Well, you can see them, yeah, from the street here. They're a little off the sidewalk here in front of the house. But the problem is, when this thing breaks, we're going to have news from everywhere here. It's going to be a high-profile type deal. It's the ex-wife of a very prominent sports cast star or sports celebrity. Then he's asked a little bit above, he says, okay, I'm going to have to trust you on this. It's O.J. Simpson's ex-wife. That's Phillips telling the coroner again. And he goes on to say, the coroner says, oh boy, okay, and Phillips says, and he's in Chicago, and Willis says, he does not know anything about this, and Phillips says, he knows now, and that's what's going to break this thing wide open. Next page, page 241, Mr. Harrison. Now, Mr. Willis hears this, and I think the evidence will show he's the coroner. He wants to get rolling. And on this page, in page 241, here's what Willis says. Okay, you want us rolling out now. And then Detective Phillips says, hold on a second. Tom, and I think the evidence will show when he says Tom, he's talking about Detective Tom Lang. So you're not confused, there's two Tom Langs in this case. It's the Tom Lang who sees Mr. Cole Brown Simpson out on the sidewalk, and he sees the Mexican gentleman behind her at 10 o'clock, and there's Detective Tom Lang, who is Detective Van Adder's partner. So he says, hold on a second, Tom, you want the coroner now? No, hold on a second. How long? Okay, you're just getting the first call. And then Phillips goes on to say, we'll give you a call back when we want them moved, presumably meeting the bodies, I suppose. Detective Phillips, it's probably going to be about an hour to an hour and a half. So here we have them calling more than 6 hours the very first time, at 6:49. Then when the coroner wants to roll, or says he wants to roll now, they then say maybe an hour to an hour and a half later. Move to the next page, please. All right. Phillips says, what I'm going to do is I'm going to give this to the supervisor because I'm leaving now. Phillips says, all right. Willis says, and tell them that you're going to be calling back about an hour and a half. Phillips says, okay, and again, we don't want that out. That essentially ends the first conversation. To put it in context, let's see if and when they call back. And we will present evidence to show that at about 8:08 in the morning, on June 13th, 1994, there was, in fact, a second conversation between Detective Phillips and a Mr. Richard Heath, then of the coroner's office. Detective Phillips says, we already gave you guys the first call several hours ago on Bundy. Heath, yeah. Phillips, okay, can you give me an ETA, an estimated time of arrival, if you started rolling now? Some conversation with Phillips, with Heath rather, and Heath goes on to say, yeah, my name's Heath, H-E-A-T-H, and I could give you approximate arrival time of driving time from the main office in about maybe another 15 or 20 minutes added to that. And Phillips says, okay, so you're talking a good 45 minutes then? Detective Phillips, to an hour. Next page, sir. Detective Phillips says, you're not going to roll them for an hour? And Mr. Heath responds, no, we'll be there within 45 minutes to an hour. Now, we think that this evidence is a very important evidence because it starts right at the beginning of this investigation by the Los Angeles Police Department. First, they've already failed to notify. Then when they do notify, they've got so much work to do yet. We know that the coroner's office doesn't come out there until they don't get the final call until 8:08. And so we know that perhaps, according to this man, Mr. Heath, it's at least 1 hour or so after that before they even get out to the scene. You've heard me mention Detective Van Adder, who is the detective in charge of this scene, a very experienced detective from robbery homicide. And as with all of the witnesses in this case, their credibility will be questioned, and we'll be looking very closely at their credibility and what they did that night and how they conducted themselves. We must do that also with Detective Van Adder. Detective Van Adder, on this particular morning at about 10:45, sought a search warrant. As the evidence will show, Mr. Simpson was not in Los Angeles, he's in Chicago. The detectives had gone over the wall first, but thereafter they sought a search warrant. That's not relevant, but what is relevant is the credibility of the detective and what he said to the judge in seeking to get this search warrant. Mr. Harris? And what is the number? We should be giving numbers.
That is D40.
All right. You'll see in this number.
D41.
This is D41. It's a search warrant and affidavit, and you'll see it signed by Philip L. Van Adder on June 13th, 1994, at 10:45 in the morning now. And this is after they've gone over the wall, et cetera, and this is an application to a judge to try and go into the house and search. A sworn affidavit. All right?
42.
All right. And this one, Mr. Harris?
43A.
All right, you pull that up.
And D43B.
Now, here's what the detective in a sworn affidavit says to the judge to get this warrant. It was determined Simpson had left on an unexpected flight to Chicago during the early morning hours of June 13th, 1994. Now, we will introduce evidence to show that that was a direct misrepresentation and untruth, that the police knew from Cato Kalin, the conversation with Arnell Simpson, that Mr. Simpson had been on a long planned trip to Chicago.
D44.
And
D45.
he indicates that himself, that by interviews of Simpson's daughter, and that would be Arnell, and a friend, Brian Kalin, he writes that in. That's what's in the writing to the judge to verify the fact that O.J. Simpson is like gone on this unexpected trip, like run away to Chicago. And he uses that as a reason in talking to the judge.
D46A.
Next thing I'd like to show you is that is the statement from Brian Gerard Cato Kalin. What's that number, sir?
D46B.
Now, thank you. This statement from Brian Gerard Kalin, you notice this statement was taken by the police June 13th, 1994 at 6 o'clock in the morning. Remember I told you that Detective Furman went into his room and talked to this man in the early morning hours. And Simpson, the statement is, Simpson told him he was going to Chicago for Hertz Corporation. So they knew why he was going to Chicago. They knew it was not an unexpected trip. So this was a lie when they were talking to the judge at that point.
D49. D50.
The next issue of credibility deals with the detectives indicated to the judge who they were seeking the search warrant. They observed what appeared to be human blood, later confirmed by scientific investigation personnel, be human blood on the driver's handle of the vehicle. Well, the evidence will show that they may have confirmed it at some point much, much later, if ever, but they had not confirmed it at 10:45. It was not human blood. They could not confirm human blood. But that was another misstatement to the judge at that particular point. Now, in addition to that, and I'll read these for you, the other inaccuracies of some importance that we think the evidence will show are as follows. The detectives in seeking this particular warrant never disclosed to the judge the manner in which entry was made. That is, they'd already climbed over the wall. They never bothered telling the judge that. And then finally, the final inaccuracy that I think you will find of some great relevance, the fact that Mr. Simpson had in fact been contacted by Detective Phillips and had volunteered to come home, taking away from the warrant any implication that he had somehow fled the scene. That was never done. Now again, this is the evidence from their files, and based upon what their lead investigator, said to a judge. And at some point in our opening statement today, I want to characterize for you how Mr. Simpson conducted himself in the early morning hours of June 13th with the way that the detectives conducted themselves. This brings us then to a discussion of the Bundy crime scene. You recall briefly the other day I talked to you about, we think the evidence will show ultimately this was a place of the gathering of the evidence. And that we think the evidence will show that it is very important at the crime scene to secure this area. That people should not be walking through the evidence, should not be tracking up the evidence, should not be touching things without gloves, should be in some way protected. This evidence is all very, very sensitive. We would expect that hopefully by the time of trial, you will actually have some footage from local televisions of how the detectives and how many people were out there and whether or not they were, in fact, wearing anything over their shoes. You've already seen in the prosecution's opening statement Detective Furman's shoes and how they existed at the time. We think the evidence will show that this scene was tracked and traipsed up, and the gathering of evidence was a complete disaster. And we feel that the evidence will be shown to be contaminated, compromised, and corrupted, as we've indicated earlier. Now, Your Honor, before we show this next graphic, I want to say a word to counsel, and you may want to use your script.
I've already. I am a direct photographer not to attempt to take photography of the screen in the courtroom.
I've spoken so the family of Mr. Goldman will be aware with regard to this picture. This is the only picture that in any way could cause any concern, Your Honor, but we'd like to move on at this point. Now, this purports to be a photograph of Mr. Goldman's body while still at the scene of the Bundy location. And you will notice several things about this particular photograph. I believe the evidence will show, first of all, that the lady whose shoes are there, these shoes are uncovered. She's standing on some kind of a white sheet or something of that nature. You can see blood on this photograph. She has nothing over her shoes. She's standing there. You see the body. And you'll see something else interesting. You'll see some gloves. Now, these gloves have blood on them. And these gloves have now been dropped on Mr. Goldman's body. Now, these gloves are, the evidence will show, are typical of the kind of gloves that are used at the scene to pick up evidence or to collect various and sundry things. And yet you see these gloves now found on Mr. Goldman's body in this fashion. And we think this is typical of the way things were conducted at that particular location at that time.
Thank you.
Thank you, Mr. Hill. We expect, as we indicated last week, to show that based at this particular crime scene at Bundy, there'll be a number of things that we expect the evidence to show. That one of which is this crime scene and the patterns of the crime scene are consistent with a major struggle. Mr. Ron Goldman's blood, as I told you, should be all over the perpetrator, especially in the upper and middle parts of the perpetrator's body. You will recall that Detective Furman's description this morning, where he described this rather small area where Mr. Goldman's body was found. You recall he talked about a fence, and you've seen, I think, some pictures. You'll see a tree in the area. It's a very small area. Like he had to go outside to look outside the fence to see where the body was. A very small area. And I think that you'll find if there was this major confrontation, and you recall last week Mr. Goldman's hand, that I indicated to you, I expect there'll be testimony that that hand came in blunt force trauma with one of his perpetrators or one of the perpetrators there. And there would be some marks and some injuries, it would seem. Plus there are trees, there's this fence, and there was a violent struggle. So that if you recall the pictures of Mr. O.J. Simpson last week, you can understand that will be important evidence as to the lack of any marks, bruises, or anything of that nature. In the area, we expected the scene to also show that in the area where these murders took place, there are a number of footprints in a very small area, which means that most likely the perpetrator had to be there for a period of time and that there was this pattern of fighting. think the evidence will be in this case that Mr. Gomez's blood is on different areas of the location, which means that he too was moving around. So there was this kind of a confrontation or this fight that went on over a period of time as one is fighting for one's life. And as you know, it was a violent struggle in which he ultimately was stabbed some 31 times. Now, the prosecutor, 30 times. The prosecutor indicated to you all this happened very fast. And I think that you'll see from the evidence that's not exactly correct, given the situation when one is fighting valiantly for their life. There was some testimony last week about certain blood drops, I think, by the prosecutors that were at or near the many footprints. And I think that you will find that it'll be very unusual and that it'll be a remarkable occurrence that there are only 4 drops of blood that they talk about and so many footprints. Further, we'll look very closely during the course of this trial at the glove, at both gloves. We'll look at the glove found at Rockingham, the right glove. We'll look at the glove found at Bundy. And we'll be looking to see whether or not there are any cuts on those gloves consistent with any cuts or anything on Mr. O.J. Simpson's hands. We expect that there, as I mentioned to you last week, there will be fingerprints on the railings that are fresh at Bundy. And we think that the evidence will show those fingerprints are not O.J. Simpson's fingerprints. That there are hairs on the cap and the glove at Bundy that are not O.J. Simpson. Thank you, Mr. Harris and Mr. Douglas. Now, you'll see in the exhibit up on the board, the large board, the video exhibit, you see a lady against the Bronco. That's the Bronco that you hear a lot about, and that's a photograph taken on June 13th, 1994. You'll see the tow truck behind the Bronco. And you see this lady up, apparently peering in the window of the Bronco. And we expect to show that this Bronco, which you heard with this important evidence therein, was not secure, that people such as this lady graphically were allowed to walk up, touch it, and when that Bronco left that location, there'll be evidence that there were at least 2 coffee stains on the hood of the particular Bronco, that it wasn't secured, that it wasn't preserved, that it wasn't made so that you could count on that evidence.
That is D63.
All right.
D64.
All right, now thank you, Mr. Harris. The Bronco was, of course, impounded. All right, Mr. Harris?
D68A. D68B.
All right, and there were some special instructions to take the vehicle to Print Shack, PAB, across the street of Parker Center. And then they note for us that there are 2 coffee stains on the hood, disregard not related. You will have to make the determination of whether that should be disregarded. However, because if this vehicle was properly handled, it's a question of whether or not those coffee stains would even be there. Mr. Harris?
D69. D70.
All right.
D71.
After the Bronco had been to the print shed, it was then removed and taken to the impound at a place called Vertels, V-I-E-R-T-E-L-S, the towing yard here in Los Angeles. And you'll see it's impound, and you'll see the 94 Ford Bronco again, and again the license number. Mr. Harris?
D72 and D73.
Let's see. When they got this Bronco at Vertels, let's see if they used this same form. The robbery homicide, RHD there you see. And you see that the check where the prints or evidence or give special care is no longer checked. There's nothing there. Nothing in that location.
D74 and D75.
This will tell you what instructions were given regarding that Bronco as early as June 14th, 1994. I think the evidence will show. The instructions were hold until released to rep from Hertz Corporation. I think there'll be evidence this vehicle was actually owned by the Hertz Corporation. You'll notice that no special precautions were taken. This vehicle was being held for release to the representative from the Hertz Corporation at that point. Of course, then now we're back to this question then of the integrity of the evidence, and you have the Bronco there going through LAPD, than anything out of the Bronco. Now I'd like to walk over, with the court's permission, to move closer without blocking anyone, with the so-called Bronco timeline. Excuse me, please. May I proceed, Your Honor? Thank you very kindly. This is the so-called Bronco timeline, and let's see if we can put this in perspective for you. There'll be testimony that the LAPD announces that the Rockingham site was quote-unquote secured, and there'll be a major question regarding that. That's in June. We know that there was the initial search of the Bronco for blood and trace evidence on June 14th. Then, within a day thereafter, on June 15th, 1994, the vehicle was towed to Vertel's, and that's the towing yard I just spoke to you about, and that's the place where there was the only indication was hold for release to the Hertz Corporation. And so you can see in June what took place. Now, we know and we expect there will be testimony that as early as June 15th, the day that vehicle, the Bronco, was towed to Vertel's, there were documents taken out of the driver's side pouch. We expect there will be testimony from a man by the name of John Meraz, M-E-R-A-Z. Mr. Meraz will indicate that they all knew down there this was O.J. Simpson's vehicle, that he got inside that vehicle. And getting inside, he took some receipts or invoices. And I think the evidence will be that some of these receipts or invoices were made out or in the name of Nicole Brown Simpson. So I think you'll find in the course of the evidence, Nicole Brown Simpson also drove that vehicle. There'll be further evidence that she was in the vehicle, perhaps had gone to the cleaners or some place to pick up some item. But Mr. Meraz will tell you that he took these items out of the driver's side pouch on or about June 15th, 1994. He will say that he put those items back in to the Bronco, but the items were then subsequently stolen or taken in another burglary of this particular car that's supposedly secure on Vertel's property. The upshot of it is that today, 7 months plus later, we don't have any of those receipts. They've been stolen, they've been taken, they're gone from this supposed secure vehicle in custody of the police or in Vertel's. And so this Bronco timeline seeks to spell that out for you. You'll note in going back that we have a smaller picture of the woman touching the Bronco. That's still while it's at the scene. We know what's happened on the 14th, then the 15th, and we move on. Mr. Meraz takes the documents initially on the 15th, and I think he says he puts them back almost immediately, within a short period of time. They're kind of like souvenirs, I suppose, if you believe what he tells you. But Vertel's does not report the removal of the documents to the police and the police commission until July 11th, 1994, almost a month later. The official word came out that these documents have been taken and they're missing. And of course, they then start an investigation to try to find out where these documents are. This Brown timeline talks about this whole period of time when we think the evidence will show the Bronco was improperly stored without the appropriate holds, and then when it was improperly stored, that some bad and unfortunate things happened with evidence having been lost. Now, you'll see, between this period of June 15th, that's the date that the Rots got inside when it was brought to Vertel's, and August 26th, did not observe special care rule to preserve the integrity of biological and trace evidence. We think there will be testimony that this vehicle, it's possible this vehicle for any number of people to get in and out of that vehicle, and there was not the hole on it that it had in the print check. Then, lo and behold, on August 26th, between the period of August 26, 1994, and September 1st, 1994, there was, done by the prosecution, an extensive search of the Bronco for biological and trace evidence. They went back looking for evidence used in this trial. Now you can see this is for a vehicle that had been towed there on June 15th. So what is that? 2 months plus, almost 2.5 months. Go back. Now they're looking for extensive search for biological and trace evidence. This is a vehicle that we know has been basically improperly stored. There's been at least one burglary or trespass, and maybe 2 if Mr. Maratz is believed. Yet then they then go back and seek to get evidence out of there. And this goes into what I've tried to describe for you, of the graphic there, of the integrity of the evidence, what happens to that evidence, where it goes before it gets to you, and who has had an opportunity to contaminate it or compromise it or in any way corrupt it. That leads us to the point of this integrity of evidence being contaminated, compromised, and corrupted. And we think that the saga of the Bronco illustrates this concept of the evidence being contaminated, compromised, and corrupted. Thank you. Well, now, with your permission, turn our attention now to this whole concept of a discussion of DNA evidence in the Los Angeles Police Department. I suppose that there's a saying that if you have garbage in, you get garbage out. And we have several charts that we think will be illustrative of this whole concept of DNA evidence and what it actually means. Mr. Douglas is placing a chart on the board. And Mr. Harris, do you have a laser? The black box. You did the black box already. Okay. And we put the black box up because, again, this deals also with the integrity of the evidence. Now, with regard to this particular exhibit, before I get to that, Ms. Clark, I want to make a few statements, and I'll let you know when we get to that. All right. Nowhere, I think, will you find in this case is the problem of the evidence being contaminated, compromised, and corrupted more important than the area of DNA testing. This is the evidence will show is a very new and powerful technology. In the past 5 years, police departments and crime labs have tried to transfer this DNA test that has been used for research and medical diagnosis and apply it to crime scene samples. We expect, though, you will hear in the course of the evidence, this transfer of technology has not been simple or easy. And so I want to share with you, in the course of my opening statement now, some differences between DNA testing for medical purposes and forensic DNA testing on crime scene samples. Remembering in the graphic, that all evidence passes through first the LAPD's hands. If it's compromised when it starts, it's compromised when it comes out. If the evidence was contaminated at the scene or mishandled by the Los Angeles Police Department, it doesn't matter what DNA tests are done afterwards, how many times they're done, or which laboratories did them. The results will not be reliable, we expect the evidence to show. Now, to understand the problem of contamination, one must understand, first of all, how small these samples are. And Mr. Douglas has gotten ahead of me just a little bit. Go back to small amounts of DNA. And for illustrative purposes, to illustrate this for you, this is a chart that's titled Small Amounts of DNA from Specks of Blood. Now, what we have is a regular-sized penny here to the far left. And I want you to be able to compromise or strike that. I want you to be able to compare the regular-sized penny with 20 nanograms of DNA. And that amounts to, those of you who see very well, I'm pointing to it, almost like a pinprick. It's 20 nanograms. Much of the evidence in this case, you'll be asked to make decisions regarding, is 1/10 of that amount. 1/10 of the 20 nanograms are 2 nanograms, an amount so small that you can't even see it. That's what we're trying to demonstrate in this chart again. The penny is the 20 nanograms, the 2 nanograms, an amount that you could not even see with the naked eye. So that exhibit I was just referring to, Your Honor, was
207, Your Honor.
now, Mr. Douglas.
This is exhibit 210, Your Honor.
We think the evidence will show, and including the last chart that was just taken down, that these small, minuscule amounts of DNA are very easy to spread around. They can get on your clothes, in your hair, on tweezers, scissors, other tools, be moved from one place to the other without anyone seeing or knowing what is happening. And this, of course, is how you get contamination. Now, during the course of my remarks today and then last week, and before that, the remarks of the prosecutors, we've all stood at this particular podium. If I sneezed, or if any saliva came out, or if I scratched my hair and any dandruff was there, or if I touched this and had any blood on my finger or a splinter there, if Miss Clark did likewise, if Mr. Darden did likewise, then our DNA would be on this area. And if I took a handkerchief out and wiped this, such as they do in labs, that would pick up the various DNA that's here. You can't see it. That's how small it is under these circumstances. So that gives you an idea. If we were to wipe it across here, a handkerchief, it could now be taken to the lab and allegedly tested. In fact, some medical labs, as I said, do in fact do this, and it's done in the lab in a scene to determine whether or not there's any contamination. That's how they test it, to see if there's contamination. If you're trying to test to see if someone is going to be able to be compatible for a particular organ transplant, they check to see, because you can't see this. Now, as I gave the example, if I had been the only one here, you might expect to find only my DNA. But if Mr. Darden and Ms. Clark were here, you might expect to find their DNA. If Mr. Van Adder here sneezed, you might find his DNA. So there's all kinds of ways in which we have this possible contamination. And one of the problems with the test is that it cannot tell one person's DNA from another. This is what we call, and I think the evidence will be, a mixed sample. There's a great controversy, we think the evidence will show, about whether small mixed samples can be tested reliably, even if everything else is done properly and there is no contamination. So if you had contamination to it, then you can see what the problems are. Now, to give you a perspective, now, we're ready. This board that I'm now going to refer to is the so-called DNA testing technology transfer board. What we want to demonstrate here, as you recall, I said that over the course of the last 5 years, what we're trying to do here is to transfer from what we use in medical research and to exclude suspects primarily to the field, to forensics, to crime scenes, to try and make it work in that setting. This is, as I indicated to you last week, cyberspace or 21st century technology. And I think you will find the evidence will be that the collection procedures are 19th century or covered wagon collection procedures. And that's why it's such a problem. And so if you looked at this medical research area, generally you could expect that in the medical field that there are clean samples, more than likely in a clean medical lab. The blood is carefully taken under antiseptic conditions in hospitals. And in a forensic setting, DNA testing is done by definition generally. Dirty samples are taken from crime scenes, from sidewalks, from carpets. And they're exposed to all sort of contamination. That there are many different sources. These are, as you know already, these are minute specks of blood. There may be saliva. There may be skin, cells, dandruff, as I indicated to you. Even a spray of a sneeze can contaminate the forensic sample. So what I want to do in this example, we have these charts here, is this. In comparing the medical research, we're going to compare the medical research with the forensic and see which one is more likely to be reliable under the circumstances. Well, I think that the evidence will show that as opposed to the clean samples and the dirty samples, in this instance, the clean sample in the medical lab will be far more reliable, something you rely upon. The next area we'll be talking about is generally in a medical lab, you have a general sample size. The doctor can have whatever sample size he usually wants or needs. In forensics, the samples come generally in very, very limited, minute amounts. When working with such small amounts, often the test can only be done once. And of course, we think the evidence will show that it's harder to produce reliable results under those circumstances. In fact, you will hear, we think in this case, that most of the important DNA tests performed by the prosecution were done with amounts of DNA that were actually below the preferred amounts for reliable testing. So if you talk about the medical research labs having a general sample size, and in the forensics area having minuscule sample size, again, you can see there is a higher risk of contamination in the minuscule sample size. And that brings us down to the unmixed samples from known sources. As you know, and Ms. Clark alluded to this in her statement, in a medical setting, you have people that you know. If you have a lady who's going to have amniocentesis, you know who that is. You have someone who's going to give, one person's going to give somebody else a kidney, you know who they are. So you have known sources that you're dealing with. And that makes a big difference, as I think you'll see during the course of the testimony. In medical testing, we take these unmixed samples from known persons. In forensics, we use and collect samples that could be mixtures in varying amounts from a number of unknown people, because you don't know who's been out there, who's walked, who's sneezed, who's bled, who's scratched their head. You don't know over a period of time. We expect that you'll hear, again in this area, that the new forms of DNA testing used by the prosecution in this case are just not reliable enough to use when analyzing mixtures from unknown sources. And the key thing here being mixed samples from unknown sources. So again, once again on forensics, there's a higher risk of contamination. Then in the lab, in the medical research area, there is generally minimal handling. This is fairly clear and straightforward. There's less handling than in the scene when you have someone going out trying to collect something. Contrary, as I said, to what the prosecutor told you last week, the evidence will be it's not as simple as wiping up a spill in your kitchen. This technology is so sensitive. It's not that simple at all. You and I just shouldn't go out and do this. We can do it. We wanted to use the same techniques they're using with the LAPD, but you get results that are all unreliable. So between minimal handling and multiple handling, you can see again, there's a higher risk of contamination with the multiple handling. Error rates, better known. And that's because, I think you'll hear testimony, that in the medical labs, they subject their results and things to tests. I mentioned the wipe test. In labs, they do that because they're concerned about contamination in the labs when you go to the doctor. You want to have the doctor make sure his lab is contamination-free as near as possible. It brings about confidence, and that's what we've done a whole industry based upon. Transferring this technology to the forensics area, the error rates are not nearly as well known, as I think you can see. So again, there's a higher risk of contamination and error in this area also. I think you'll find that in the course of the testimony that the labs have a higher standard for doing DNA testing in medical laboratories. They're much stricter on themselves than the standards that forensics and the police departments and laboratories are using. And so you can see how important it is. In one case, when you're talking about these high standards, you're concerned about whether or not your organs will be compatible, if you want to have an organ transfer or whatever. And the other, concerned about somebody's freedom, their virtual life. And so we're going to see whether or not, under this scenario, whether or not there aren't higher clinical lab standards when you're concerned about somebody at the hospital than you are when somebody's on trial for their very life. Given that, lower lab standards and the lack of testing, again in this area, in forensics, there's a higher risk of contamination and error. I mentioned this earlier, but in the labs there is this rigorous proficiency testing. And of course, I think you'll find the testimony will be that in forensics, very rarely do they do any blind testing, no outside agencies. They give themselves easy tests and almost never take blind external proficiency tests. And that has a real bearing on the overall proficiency here. And so, again, I think you'll find there's a higher risk of contamination and error in the forensics area, again. And finally, with regard to statistical controversy in this area. In medical testing, usually you're just trying to see if someone has inherited a copy of a diseased gene from their parent or whatever, has the correct genetic types for transplantation of an organ, or has been infected with a harmful bacteria or virus. That's what you're looking for. And there's no elaborate statistical estimates are needed to get reliable test results for that. In forensics, we think you'll hear testimony that there's a bitter and complicated statistical controversy regarding this entire area, DNA, and specifically PCR, about a DNA match and what a match means. And while we're about it, I think the evidence will show when you hear the prosecutor talking about it's a match, it's a match, it's a match. What she really means to say is that it's consistent with. These are not fingerprints, consistent with someone else's genotype or with their blood type. So with regard to this whole area of statistical controversy, again, the forensics area, the higher risk of contamination error in this area here. So if you look at this chart, you look at blood on both sides of that, you can see clearly, and I expect the evidence to be, that because of the dirty samples, the minuscule sample size, the mixed samples from unknown sources, the multiple handling, the error rates not well known, the low lab standards, the easy proficiency testing, and the major statistical controversy. In all those areas, the seeking to transfer this technology to forensics is fraught with all kinds of problems, and there is a much higher risk of contamination and error. Now, we expect that during this hearing you will hear some astronomical numbers presented regarding their DNA test results. And these numbers are part of what I was telling you, the statistical controversy, whether or not these are accepted in the science. And these numbers also only address gene frequencies. These are not fingerprints. And the numbers that you will hear, if you hear them in this case, have nothing to do with the issue of contamination that we've been talking about. They do not have anything to do with the issue of laboratory errors. They don't have anything to do with the issue of tampering, whether the sample was tampered with. And they have nothing to do with other important DNA issues which you'll hear about in the course of this case. Specifically under the DNA testing aspect, we think that you'll hear testimony in this case about polymerase chain reaction, the so-called PCR testing. And I think you'll find out in here that the very best medical and research labs that do PCR have contamination problems. And as I mentioned to you last week, I think that you'll hear that this is an area that presents a real problem. We expect during the course of our evidence in this case to show that from their own studies, the LAPD's laboratory is a cesspool of contamination. Looking at their own records and the tests they've run, we will demonstrate for you what those records show. We expect then in this entire area, the evidence will show that the careless, slipshod, negligent collection, handling, and processing of samples by basically poorly trained personnel from LAPD has contaminated, compromised, and corrupted the DNA evidence in this case. And, Your Honor, that might be a good spot. Should we go further?
All right. Thank you, counsel. All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember my admonition to you. Do not discuss this case amongst yourselves, form any opinions about the case. Don't allow anybody to talk to you about the case, and you are not to perform any deliberations on the case until the matter has been submitted to you after the completion of the case. And we will resume again at 1:30. All right, we'll stand in recess. Thank you, counsel.
She's on her way down. Have to get an elevator or something.
young trial lawyer in Pasadena. I recall trying a case in Judge Ladig's courtroom, being late in a jury trial, and Judge Ladig had the jury out sitting in the box as I walked in late from lunch. And he never said anything to me, but I got the message.
It happened to me, Your Honor. I apologize, we had a late meeting, which delayed lunch considerably, and I didn't expect it to take as long as it did.
Well, keep that experience in mind. All right, counsel, let me bring up one matter before we invite the jurors to rejoin us for the continuation of Mr. Cochran's opening statements. Counsel, when you use a videotape or an audio tape during the course of the opening statements, or any time during the course of the trial, then there's a transcript that's available. I forgot to ask you for the normal stipulation that the court reporter need not attempt to take down what is on the video or audio tape at that time. And Mr. Cochran, you did use that videotape during the course of your opening statement. Is that stipulation agreeable to you?
Yes, I will be so stipulated that
Yes, he's so stipulated.
All right.
not to take that.
Thank you, counsel. All right, Deputy Magnaron, let's have the jury, please. All right, counsel, please be seated. All right, good afternoon, ladies and gentlemen. All right, Mr. Cochran, do you wish to continue your opening remarks?
Yes, I do, Your Honor. Thank you very kindly. Leo and counsel, gang. Good afternoon, ladies and gentlemen. I can make a promise to you this time that I will finish this opening statement this afternoon, barring any unforeseen calamities. We'll be finished this afternoon with the opening statement. Thank you for your patience, and ask you again to keep an open mind. Just before we concluded lunch, we were talking about the importance of DNA, and we still have some more DNA to talk about. I have two charts now I want to discuss with you briefly. They're labeled, for the record, PCR amplification charts, and we're seeking to explain how this concept works, the polymerase chain reaction, or PCR, this technology I've been talking to you about as a facet of DNA technology. PCR tests take these very, very small samples that we've been talking about, and now you've seen some of which you cannot even see, and they are amplified up, kind of a molecular Xeroxing, if you will. And that's what we're trying to demonstrate here. We expect the evidence to show and that scientists are not yet able to actually examine the small amount of DNA contained in minute specks of blood. They must first amplify the DNA so there's enough of it to examine. Amplification, or amplifying DNA, as I said, is like molecular Xeroxing. They start with a small amount of DNA, and they go through these various cycles. Each cycle doubles the amount of DNA, and they do this 32 times, the evidence will be, before they have enough DNA to examine. Now, this first chart shows what happens when you have a single piece of DNA that is then amplified or doubled 32 times. And then it goes from this one fragment that you may not have been able to even see to over 4 billion fragments, as is indicated on the particular chart. That is the molecular Xeroxing made as hopefully, as clear as we can make it in line with what we expect the testimony to be. Mr. Douglas, we move. What's the number of that chart, Mr. Douglas? Now, referring and directing your attention to number 209, which is the amplification of 4 fragments. Now, this chart seeks to illustrate for you what happens when there may be a mixture of DNA in the sample. We're just talking about mixtures, and heard me this morning talk about the wipe test with a handkerchief on this particular podium. This chart shows 4 different fragments of DNA at the start. And after this mixture, just like we did in the previous chart, is amplified up, there will now be over, the bottom should be 16 billion or 17 billion fragments. Extra fragments of DNA, the evidence will show, could get into the sample in any number of ways. And that's one of the vices of this particular system and its reliability. From someone coughing on the evidence, from flecks of blood which may come from one sample and be passed on to another sample, from specks of blood that stick to a pair of tweezers, if the technician is using those, or scissors, from someone shedding dead skin cells onto the evidence, from dandruff, from any number of things. So the problem comes when one when one has more than one sample and the amplification gets into the billions. We still have this same problem as you look at that. These charts, we expect to have testimony from the experts to address these charts. And we hopefully use these today to make this process a little clearer to you of how the PCR is amplified up, try and get some results. And even when you get the results, as I indicated this morning, a match doesn't mean like a fingerprint. It means consistent with generally. And there can be when the contamination gets in there, then you can't tell one person's DNA from the other. And we can move on to the next chart then. Now, in this case, to try and conclude our discussion of DNA so everybody can wake up again and be alive again, this, you've heard a lot about DNA, and you hear a lot about DNA evidence. The prosecution will undoubtedly present some of these technicians who come in from the crime lab who perform the various tests. And you'll recall that on this particular high-profile case, they designated as the officer in charge a Miss Mazzola, who was a trainee. This was only her 3rd crime scene. She was supervised by a Mr. Fung, who was a supervisor that day. And we expect their technicians will come in, tell you what they did, the various tests they conducted, and the conclusions which they have drawn from the tests. We expect to present testimony, however, somewhat contrary, including some of the people I've told you about earlier. And we expect that the people we call will tell you, based upon their observation and their knowledge of the field, which of these test results are reliable and which ones aren't, given what the technicians will tell you that they did. Now, in summary, with regard to the DNA, we will look at each item, hopefully have testimony regarding each item, hopefully have some testimony regarding which items are reliable or not reliable, and then give you evidence by which you can make a final decision. You'll recall, I believe, that Ms. Clark in her opening statement said that blood consistent with Nicole Brown and Ron Goldman was found on the glove that this Detective Furman we talked about claims to have found behind Mr. Simpson's home. That glove will be, undoubtedly, the evidence will show, one of the most hotly disputed items in this case. Where the glove was, how it got there, where it came from, be very important issues. In addition to that, there will be a major dispute in certain other areas. I think you'll hear a lot of testimony about the so-called blood found in the Bronco. You remember the Bronco timeline. I think you'll hear a lot of testimony about whether or not the prosecution's contention that blood consistent with, not their blood, but consistent with Goldman and Nicole found inside Nicole Brown Simpson, inside the Bronco, whether or not this finding is trustworthy. We expect the evidence will show and that the police technicians would use unreliable procedures in collecting this. They made fundamental errors in conducting these tests, and then they misinterpreted their own findings, as I've indicated to you earlier. That The stains that they think are consistent with Goldman and Nicole Brown Simpson contain tiny amounts of DNA, so little it can barely be detected. And this DNA could only be found using this super sensitive procedure we've talked about, where even a sneeze could contaminate it. So even if the test results were right, we think the evidence will show, the DNA could be from a tiny amount of contaminating DNA from the crime scene, from another person. Finally, in that connection, we think the evidence will show that the DNA results that supposedly put Nicole Brown Simpson and Ron Goldman in the Bronco are not like a fingerprint, and a match doesn't mean that. They detect characteristics in the DNA that millions of people have, not characteristics that are unique to one particular person. Now, let's talk about something other than DNA for a moment. When Mr. Simpson came back from Chicago, we think the evidence will be that he came home immediately. He came back voluntarily after hearing about his ex-wife's death. You have heard some indication about his demeanor on his way back, that he came home, that he was asked by the police to come downtown, that he went downtown, that, without giving you what the statement was, that he cooperated fully, and that he gave the police a statement, perhaps some 33 minutes, which statement is tape recorded, that the two detectives who interviewed him at the time were Detectives Lang and Van Adder. He answered all their questions. Conclusion of that interview, they asked for a blood sample. Mr. Simpson was only too pleased or cooperative to go and give a blood sample at that time. And if I might step over a little closer, this next chart, and Mr. Douglas, what is this chart?
Number 205.
This chart hopefully will graphically illustrate what took place. Referring to number 205, we have Parker Center. This is the Los Angeles Police Department headquarters down at 150 North Los Angeles. This is the building in which Mr. Simpson gave this statement to the two lead detectives from robbery homicide. They questioned him and he answered their questions. Thereafter, and that's the building depicted, there's the little yellow circle depicted there. Thereafter, they asked Mr. Simpson to give some blood. The technician then drew some blood from his arm. We think, according to the testimony, it was approximately 8 milliliters of blood. The testimony was between 7.9 and 8.1, which I think is 8 milliliters of blood. Now, we think the evidence will show under normal police procedures, they've been following their own procedures, when the detectives had this blood in a vial, certainly Mr. Simpson's blood at that time, they would have taken it over about a 3-minute or very short drive and book it at a place called Piper Tech. You hear evidence about where they book this kind of evidence, where the refrigerators are and that sort of thing. They book it to preserve it. You hear the importance of preserving that blood. We think the evidence in this case will show that the detectives didn't take the blood from Simpson at about 2:30 on June 13th, 1994. They didn't go this very short distance to Piper Tech and book it. For some reason, they came all the way, I guess this is some 20 miles or so, from downtown LA with the blood on their person in this vial, came all the way out here, this area called Brentwood, the home of O.J. Simpson, 360 North Rockingham Avenue. We think the evidence will show Detective Van Adder, who had this blood on his person, instead of booking it in Piper Tech where it should have been, carried this blood around from 2:30 till perhaps 5:20 in the afternoon on June 13th, 1994. Went back to O.J. Simpson's home. And there, we expect there will be some testimony. That blood vial he'd been carrying around apparently in his pocket, he then turned over to Mr. Fung, who was the supervisor of this officer in charge, the trainee at the scene. And then you'll hear some interesting testimony about what happens to that blood. The blood is supposed to be number 17, but it gets booked as number 18 at some point. Number 18 you're going to find is a pair of sneakers. That same afternoon at Rockingham, we think you'll hear testimony that Detective Van Adder's partner, Detective Lang, been with the LAPD some 25, 27 years, talks to Mr. Simpson after Mr. Simpson comes back home. And they ask him, what shoes were you wearing last night? Words to that effect. And they pick up a pair of Reebok tennis shoes. And I think you'll find that's consistent with what Cato Kalin had said he was wearing, I think, when he goes to McDonald's to get the hamburger. They then take these tennis shoes. Tennis shoes are ultimately booked as number 18. But for a while, at least, the blood is also number 18. Detective Lang, I think, will testify that he takes these tennis shoes, he takes them home for the night. He doesn't go back downtown and book them or whatever. Takes them home and brings them back the next day, which would be the 14th. So there's this mislabeling, there's confusion as to what happens with this blood and who gets it. We know that the next morning, Fung has the blood downtown, and Colin Yamauchi, one of the technicians, takes 1 milliliter of blood out of this particular vial. So this blood, this is the strange saga of this blood and why it was carried out here. We expect the evidence will show exactly the events I've just testified to you, or just told you about in testimony. Mr. Douglas?
Next, Your Honor, is Exhibit 211.
Now, with regard to Exhibit 211, this exhibit seeks to demonstrate for you, as best we can, using the prosecution's records. All we can use is the records. These are their records. If this is wrong, maybe because the records are wrong. But the defendant's sample offered voluntarily. We've told you that. That's in Mr. Simpson's blood. I've already shared with you that you have 8 milliliters taken on June 13th. We know that the detective walks around with it for these 3 hours or so before the technician ever gets it. According to the records as we understand, so you start with the 8 milliliters. We know that on June 14th, we think there'll be testimony that Colin Yamauchi took from Fung 1 milliliter of Mr. Simpson's blood. We'll have to subtract that at some point. We know that 7 days later, Mr. Flaherty took 1.5 milliliters in a tube. It's a smaller tube, as indicated here. Ultimately, return 8 milliliters from this tube. So we know there was 0.7 milliliters used out of the smaller tube that had been taken on the 21st. Then on June 25th, Colin Yamauchi again put some blood on some threads for some purpose, and he used only 0.05 milliliters at that point, according to our understanding of their evidence. Then on June 27th, Mr. Matheson, again, another one of the technicians, took 0.75 milliliters of Mr. Simpson's blood, all from the same tube. And finally, the defense at some point were given 1 milliliter of the blood. And we know that there's some blood left in the small tube, and we know that in a recent measurement in January, I think on or about January 4th of this year, there was 1.8 milliliters left in the tube, plus the 8 milliliters returned from the smaller tube. And if you subtract these particular figures, and I've done that, subtract the 1.0, the 0.7, the 0.05, the 0.75, the 1.0, you will have 3.50 milliliters of blood taken. To that, you have to add the 1.8 left, and the 0.8 that was used there are 2.60. So if you add the 2.60 to the 3.50, you will get 6.10 milliliters of blood. And so this chart, perhaps maybe it'll be explained to us during the trial, shows that if you started with 8.0 milliliters and you use 6.10 milliliters, there would be then 1.9 milliliters missing. above the amount that's left, 1.90 missing. And one of the things we'll be looking at in this case is what happened to that missing blood, and where is it? Now, perhaps there are some records we haven't seen that will explain that. Those are the records as we understand it, that there would be 1.90 milliliters of missing blood in that connection. A bit more about this crime scene and what happened. We think you will see and hear from this trainee, Mazzola, and what she did at that scene, how she sought to collect these samples, Detective Fung's role at both Bundy and at both Rockingham. We think that you'll be able to then make a determination about what took place out there on that date. Now, one of the other key bits of evidence we expect in this case will be these socks that Ms. Clark talked to you about in her opening statement. Remember, she talked about the socks? And I think that with regard to the socks, I believe we have a timeline and we also have a graphic with regard to the socks also. May we have the graphic and the number of the graphic? Okay, all right.
The graphic is D84.
D84? Thank you. You'll recall there was some testimony about this. I think there'll be testimony during the course of this case that this is the master bedroom in Mr. O.J. Simpson's home in Rockingham. There'll be testimony this place is usually meticulous and spotless. You'll note that the carpet is very, very light. I think there'll be testimony the carpet is either white or very light throughout, going up the stairways and in the hallways and various other places. And you'll recall that in this picture you'll notice that whatever the strap is on the bed is hanging down on the bed. I think there's another picture where that strap has been moved. And over in the center, and you'll see in this picture, the second picture, Mr. Harris, what is this? In this picture, you don't see the strap hanging down, so apparently it's been moved. You will see a view of these socks. These socks apparently bald, kind of part of them rolled up, and on this carpet or rug that's at the foot of Mr. Simpson's bed and just in front of the fireplace. The only item you find there. Here's a close-up view of these socks, which were located there, and this now is June 13th, the afternoon hours, at the Rockingham residence. These socks are located. Now, the timeline, I think, is helpful to us as we consider and look at these socks. Again, these socks were recovered on June 13th. Just talked about that. And they're examined on June 13th. There's no mention of blood on these socks on June 13th. We know that Michelle Kessler, basically the supervisor of the lab over there at LAPD, shows these socks, they can't really examine them, to two of our experts, Drs. Michael Baden and Dr. Barbara Wolf. They see the socks on June 24th. That's within 11 days of the socks having been taken back to the lab. It's June 24th. Around this same time, I think also in June, Ms. Michelle Kessler, I think, makes some observations of these socks and at some point sees some fiber or something on the socks. So there's an opportunity, I believe the evidence will show, to look at these socks and been able to observe them on more than one occasion. Then we think that on June 29th, 1994, the evidence will show that Kessler, Matheson, and Yamauchi do in fact inspect the socks. There's a third date in the saga of the socks. It's not until August 4th, 1994, that anybody in the LAPD lab sees a blood stain on these socks for the first time. Now, these are the same socks that you see up here. They're picked up on June 13th. They're seen on the 13th, seen on the 24th, seen on the 29th. But yet it's August 4th before a blood stain is seen on these socks for the first time. And that's not all. We think the evidence will show that on or about September 22nd, 1994, there was, without testing any blamed anyone. It false leaked to the press that Nicole Brown Simpson's DNA had been found on one of these socks. The problem with that false leak was that no DNA test had yet been performed. So they had predicted the results before the socks had ever been tested for DNA. They were still, in fact, at the LAPD lab, but they don't have the capacity to do this. Then the socks, after that leak, on the 22nd, I believe, and that leak was by a local Channel 4 reporter, who then reconfirmed that leak the next day about Nicole Brown Simpson's DNA on these socks. The socks then were not even sent out for DNA testing until September 26th, some 4 days later. Then, of course, lo and behold, on November 17, 1994, the lab reports they find DNA on the socks. Nicole Brown Simpson's DNA on the socks, just as they had predicted in this false leak back September 22nd. And of course, these are the same socks where nobody saw any blood at all until August 4th. And that's not all with regard to these socks. You will hear that throughout there are very, very small amounts of these nanograms, which you saw on the chart, on the evidence in this case. The nanograms found on these socks is more than 1,400 nanograms, which is as much as all the other blood tested in this entire case, just on these socks. So, we think this will be, the evidence will be, this will be a hotly contested item as to whether or not these socks were consciously, intentionally tampered with in an effort, in a rush to judgment, to get evidence on Mr. Simpson, where you have the results predicted before the socks are ever sent out to the lab. And the amount of this DNA being equal to the amount of all the rest of the blood found in this particular case. I think the evidence will show that in addition to this, you can see this area is very, very, very light around here. There's no blood found on this carpet or on that rug that's at the foot of his bed. There's no blood found on the light carpet on the stairs and the hallway floor on the way up. Because the court has indicated, I believe, that we'll have a jury view in this case, you'll be able to see for yourself, hopefully, at some time in the near future, this particular area, you can see for yourself exactly how it looks and what took place. I should point out that the LAPD did, in fact, do some serology on these socks at some time, but they did not have the capacity to do the DNA that was predicted. So we think this will be something that you will find of some great amount of interest, and it will be a major item litigated during the course of this particular hearing. I mentioned to you earlier, as we leave the socks and what took place, that I wanted to briefly compare with you the conduct of O.J. Simpson with the conduct of the officers, the LAPD officers involved in this case for this general area of June 13th. Let's take, first of all, Mr. Simpson. We expect the evidence to show that Mr. Simpson's in Chicago on a prearranged, long-standing trip for Hertz to play golf. That he gets a call from Detective Phillips in the early morning hours. That his whole demeanor and everything changed, of course. That he comes back voluntarily. When he gets back, he comes home. That he meets with the detectives. They ask him to come downtown. He goes downtown and he meets with the detectives without any counsel. That he talks with them. That he gives them blood. Does everything they ask of him. That he then comes back home that afternoon, June 13th, in the afternoon. Now, meanwhile, the detectives, we'll start with Detective Phillips, delayed, it's almost 10 hours before they get the coroner out there. And we've already talked about the ramifications of that and tried to establish this man's innocence. They then go from the Bundy crime scene to Rockingham. All four of them, as you know, then climb over the wall and they make these misrepresentations to the judge. So in their very first contact with the criminal justice system at 10:45 on June 13th, they don't tell the truth, the evidence will show. Because first of all, they know he's on a trip that was planned, and they say an unexpected trip. We've shown you those three items earlier. They don't tell the judge how they get over the wall or whatever. So these are the things they put in a declaration which you've previously seen already that day. They continue looking around, they amass and find evidence. We've talked already about how people at the scene, certainly at Bundy, are traipsing through the evidence and that sort of thing. They, later that day, after making contact with Mr. Simpson, are at his home. They go back downtown with him. They question him. They take his blood. Instead of taking his blood and booking it like they should have for their own procedures, they take that blood and come some 20 miles or so west, back to Rockingham, carry it around, seize his tennis shoes, don't book those until the next day, mislabel. The blood is to be 17, they label it 18. The tennis shoes or the sneakers are 18. And these are the experienced detectives in this case. When you look at this case, as the case progresses, we want you to characterize how they conducted themselves and how O.J. Simpson conducted himself in making a judgment in this case about whether or not the prosecution will ever prove this case beyond a reasonable doubt. There will be a number of key witnesses in the case. Without getting into any of them, all witnesses are important. I think all sides would agree that no side has a priority on the truth. All witnesses should be accorded, as the court has instructed you in looking at how you determine the truthfulness of a witness. You should do that. There are other miscellaneous points that I'd like to make at this point, with regard, one of which is with the 911 tape. The tape I have in mind now is the one from October 25th, 1993. I believe you heard testimony that one of the officers who came out at that particular time, and this is the time when many of you said during voir dire you'd heard this particular tape, when there's no physical injury or whatever, there's a door damage, which is already damaged, which is damaged some more. Mr. Simpson agrees to fix that door. You'll hear what's on that tape with regard to what Mr. Simpson has to say and what Mrs. Simpson has to say about her intent and her thought. But I think what you'll find, the evidence will show that this argument, the entire argument on October 25th, 1993, was over picture frames of former lovers, or lovers while they were away and separated from each other, not having been removed or taken out of the house as they were striving to get back together, as you know, during the latter part of 1993. In another area, in listening to the prosecution's opening statement, there was certainly a suggestion there may be some connection between the noises, these thumps on the wall, if you will, that were heard by Mr. Cato Kalin somewhere around 10:47 in the evening, and someone presumably climbing over the fence. His testimony, I think there's a fence back there near Cato's room, and accidentally dropping the glove where Detective Furman claims that he finds that glove, of course, later on in the morning. Keep in mind that there will be, we expect, testimony from Rosa Lopez about the fact that there are people and voices over in the Simpson compound, 12 o'clock on till about 3 o'clock, that she hears. It's not O.J. Simpson's voice out there. She hears people talking, and she can't go to sleep, she says. We think the evidence will show that this walkway, which is very, very narrow, is very, very near where she lives, kind of in her housekeeper quarters in the house right next door, we expect the evidence to be. That the area where Detective Furman claims that he found this particular glove is an area that has a number of cobwebs and things back there, which one might infer that people hadn't been walking back there, hadn't been back there for a while. I think the evidence will also show that on that side of Mr. Simpson's home, Mr. Simpson had wanted to come home and hide himself from anybody outside, a limousine driver. There are at least 2 entrances to his house on that side. There's one door, the evidence will show, that goes into a laundry room, and of course there's a door into the garage, all on this side of the house. I make these statements because I think this is what the evidence will show in response to what the prosecution has indicated. I think you'll also find that there will be testimony, there is a great amount of very thick shrubbery top of that fence that separates the property where Ms. Lopez lives, where Mr. Simpson lives, on that date. And I think you'll hear testimony as to whether or not any of those twigs, leaves, or any of those items were ever disturbed or appeared to be disturbed, as though anybody had climbed over that fence. Now, we want to turn our attention to something I alluded to the last time. We call it the timeline. One of the things that we expect to show during the course of this trial is not only did Mr. Simpson not commit these brutal murders, but he did not, would not, could not, the time frame he committed these particular killings, under the witnesses that both sides know about and we understand. What we have is a timeline with a chart and a timeline with the graphics, which we'd like to call to your attention now. So what's the number of that?
That is D87.
D87. And D87, so that you're clear, this is the Simpson compound. This is the home on Rockingham that you've heard a lot about. This street over here is the... Can I get that back? Thank you, Mr. Harris, sir. This street over here is the Ashford Street, where ultimately Allen Park will come. The street over here is the Rockingham gate, where the Bronco will be parked. There's a gate right here, and the Bronco is parked right there. Remember, we indicated there'll be testimony about when the Bronco comes out, how it's a sharp turn right to that location. And over here, there'll be testimony that Cato Kalin's vehicle is parked. And in some of the subsequent photographs, I believe we'll see that his vehicle is parked here on Ashford also. Thank you, Mr. Harris. And this is the Bundy residence of Nicole Brown Simpson, and I believe that 875 Bundy is right there. This is the walkway that Detective Phillips talked about, right up in that way. A lot of shrubbery, and there's a gate there. The testimony was, you recall, or his statement was, you can see the bodies from the street, and the gate was open. I think you saw some pictures when the prosecutors were doing their opening statement. This is Bundy, and Bundy in this area is a street that traverses north and south. North being this way, south being that way, west being here at the top, as I understand it. And this is the area here where these bodies were found. This is Nicole Brown Simpson's residence. It's the residence which she had purchased. You recall, with the funds that she'd gotten from the money that Mr. Simpson had given before he married, and there's some additional funds that he'd given her. She had moved there voluntarily.